Hello, good morning, everyone who's watching this from India. Good afternoon, good evening to all others watching from different parts of the world. My name is Ashish Bhardwaj. I'm from the Jindal School of Banking and Finance at OP Jindal Global University. Welcome to the first session of day 3 of this law summit. And this session is on the economy of law in economics revolution. We are going to be talking to 4 distinguished law professors who are part of this panel who are going to reflect on this topic. I'll very quickly introduce them. Professor Robert Ardia, he's Dean and Anthony Busby Endowed Dean's Chair, School of Law, Texas A&M University in the United States. Professor Robert Cunningham, Dean and Head Curtin Law School in Australia. Professor Kevin Johnson, Dean of School of Law, University of California, Davis in the US, and Professor Shilpi Bhattacharya, my colleague, law professor at Jindal Global Law School. If we were just talking about law in economics before we started, if my 4 panelists would have been 4 economists, then we would have probably had 5 different views on this subject, on this topic. And if one of them went to Chicago, then we probably would have had 6 to 7 different opinions. That's how a joke on economics goes, but let's see if we can prove it wrong towards the end of this session. For the audience watching us on YouTube and elsewhere, we are going to be talking for about 60 minutes. I'll very briefly introduce the theme, the topic, and then we'll have a moderated discussion in a Q&A format where I've requested all panelists to restrict their responses to about 3 to 4 minutes per question. This will be followed by a brief Q&A session with you, the live audience. I'll be receiving the questions and comments you'll be making on different platforms and portals. And for the panelists, if you have a counterpoint to make to one of your fellow panelists, then please feel free to interrupt me and we'll give some time. All right, so maybe around 120, 110 years ago, Oliver Holmes very rightly said that for the rational study of the law, the black letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. More recently, in India, Justice A.K. Sikri from the Supreme Court of India said that law has implications across disciplines, not just law, and it really impacts jobs, economic growth, government revenues, issues of taxation. And sometimes he goes on to say that macroeconomic fundamentals are predominant, which is why Indian courts, according to Justice Sikri, are becoming increasingly receptive to economic analysis of law. Now, it wasn't like this for a very long time. The last half a century indeed witnessed an emergence of this field, this very interdisciplinary field called law in economics, which can be considered as one of the most important intellectual developments by many legal scholars and economists around the world. Not only does this discipline direct obvious economic areas such as antitrust or competition law, intellectual property rights, regulation, industrial organization, but it has implications on all other areas of law, most other areas of law. Again, it wasn't like this. About 50, 60 years ago, this discipline, or rather movement, was largely coterminous with the application of economics to antitrust, to what a firm or an industry wishes to do or does. But over time, the impress of economics has become stronger on the calculation of damages in torts, on contracts and securities, even issues of family law, monetary relief in divorce cases, and there's so much more. There has been a growing interest among the economists as well as lawyers and legal scholars in using economic theories and empirical methods to enhance our understanding of the legal systems. The discipline of law in economics has had a huge influence on how several countries have dealt with important issues ranging from environment, property, land, mergers, banking, and so on. But it has also shaped, very importantly, public policy responses to social issues like child labor, public safety, crime control, and many others. How law in economics gained prominence in becoming such a vital guiding principle in the rule of law is described by many as a revolution. Now, whether laws shape preferences and in which direction is important for those conducting cost-benefit analysis of judicial decisions. and for those who want to know whether the decisions accord with the democratic will of the public, of the people, especially if judicial decisions shape that democratic will. Now, this is where an eminent economist, an Indian economist, Kaushik Basu, who's at Cornell now, he points out the shortcomings of the discipline of contemporary law in economics, the way the discipline has shaped and has become visible now. This is more so in certain developing countries, including India, where there's a constant refrain in how the law is fine on paper, but the implementation faces some challenges. Another major criticism is around the rather convincing criticism around the notion of rationality, which is really the bedrock of this entire economic foundations of law and economics. Thus, more recent and advanced developments in the field of law and economics are now trying to answer complicated questions like why do people follow some laws but not the others? Why do some societies seem law abiding and others do not? It is also closely linked with a very interesting book that came out a few years ago titled Why Nations Fail by an economist, Darren Acemoglu, which also tries to understand some of these challenging questions from a slightly different lens. Another one is why is corruption more widespread in developing countries or in certain developed countries and not others? Governance is another issue. So it is a very vibrant area, and I'm very happy that I'm joined by four people who can really do justice to this topic. Let me dive into the first question, a fundamental foundational question that I have in mind for each of my panelists. And the question is, what is really the contribution of economics in developing legal systems? So your personal view on this question. Let me start with Shilpi, who can bring perhaps some perspectives from the Indian legal system, and then we'll move to Australia and finally to the US before it's too late in Texas. Over to you, Shilpi. What is the contribution of economics in developing the legal system?
Thank you so much, Ashish. I mean, I think that is such an important question that I don't know if I can do justice to it in 4 minutes, but I think economics, both positive and normatively, has played a very important role in helping us to understand sort of how the legal system works, both in terms of the design of legal rules, as well as you mentioned, in terms of sort of how well legal rules are working, as well as sort of the entire institutional structure of the law. So if you think of economics as a discipline, so it is in itself such a vast discipline. So if you think of sort of empirical economic studies of sort of how of court systems like the Indian Supreme Court, there have been studies of the functioning of the Indian Supreme Court, pendency of cases. So in that sense, empirical economics has proved to be one of the more effective disciplines to help us sort of understand where we're going right or wrong in terms of how the legal system is working. And then in the Indian context, at least from an academic perspective, we've seen less of sort of academic contributions in terms of understanding the implications of sort of the application of economic theory to legal rules. So here, I think we have a lot to learn from sort of the academic contributions of scholars in other countries. So, for instance, in more developed areas like competition law in India, we are seeing that there is sort of more of an economic analysis happening, but it's still in other fields of the law like tort law, contract law, where it's more developed in other countries, we don't see that kind of an economic analysis playing out. And of course, we also see that some of the cases of the Supreme Court, some of the older common law cases, for example, contract law cases, we see the courts mentioning concepts like risk allocation. So there's definitely sort of an application of some of these interesting economic principles, but it hasn't become very mainstream, I would say, in within the Indian legal fraternity, and also within sort of more specialized regulatory tribunals, as well as more specialized regulators like the Competition Commission of India. while they do have economic expertise, we still see that they're not as I don't want to use the word comfortable, but they're not as they're not using economic analysis as much as we see in sort of in more advanced or more developed countries. But I think in terms of the contribution that economics has made and can make to the law, I think first of all, because economics is considered quote unquote to be a science, so I think it does bring a degree of objectivity to the way that we understand the law that I think is so different from the way that we would otherwise analyze the law if you were looking at it through the prism of other disciplines. So I think the degree of the objectivity that economics as one disciplinary prism for understanding the law provides is really significant. But also, I think what makes economics significant is just in how how it can provide this unique frame to understanding legal problems and legal context. So, for instance, if we're looking at the design of legal rules and we think of sort of the error cost frameworks, which is like one sort of tool that we might use if we're using sort of a law and economics approach, then sort of, what is the cost of getting this legal rule wrong, or what is the cost of taking a wrong decision, and what is the benefit of taking a wrong decision. So that error cost framework is a very interesting sort of way of analyzing judgments, analyzing rules, and that's just one example of how we could sort of how economics provides a very unique sort of perspective for us to understand and even sort of analyze the law. And of course, for people who are not familiar with economics, and this is why it kind of becomes harder to integrate it into mainstream sort of legal analysis, because it seems very sort of alien to have these kind of objectively measurable sort of answers to legal questions. But like I mentioned earlier, I think that is also the attraction of economics, that there is sort of a very intuitive, sort of clear, sort of predictive framework that economics provides in terms of how we could think about sort of how we could predict what legal actors would do, and how we could sort of think about outcomes of legal rules. For example, that a particular remedy for breaching a contract would may or may not sort of provide an adequate solution in terms of what is the problem that we're trying to solve. So is, say, specific performance better, or are damages better in a particular context? And economics provides a very clear solution to that problem. Yes, I'm sorry, I'm going on.
No, that was, thank you so much. We are on a great start with this. Thanks for your answer. Let me move to Robert now. With the same question, Robert, what, in your view, has been the contribution of economics in developing legal systems?
Thanks for the question, Ashish, and thanks to the Jindal Global Law School for hosting this wonderful event. I guess at the heart of the question is another question, which is, what is economics? And there's many ways in which we could come at that question, and my answer is probably a little bit too simplistic, but the way in which I often conceptualize economics is that it's about who gets what. And if we think about economics through that prism of who gets what, then it obviously has a pretty significant impact upon the rule of law in a practical sense. So, Ashish, it goes back to the dichotomy that you drew out in your introductory comments about the theory of law on the one hand and the practice of law on the other. I don't think Australia is alone in its common law system, in the sense that many cases that make it to court are backed by significant wealth. So that is, the wealth itself ends up having a very large impact upon how the common law develops over time. And we could unpack that particular issue through a number of different lenses. We could talk about the role of corporate power and the accountability that issues that relate to that. I know that it's possible that we'll talk about welfare economics along the way, but another area of interest, I think, in this domain is what's sometimes referred to as public choice theory, which really talks, in my view, about the role of concentrated interests in shaping regulatory frameworks. And I mean, particularly in Australia, but again in many other countries, we see that the regulatory frameworks that have been established by the legal system in Australia are very much shaped by big mining houses and those that have an interest in essentially exploiting natural resources for private gain. But when we think about it in those terms, there's always this tension between private and public. And I guess from a normative point of view, what I think needs to happen is we need to start thinking about the way in which we have constitutionalized power in the past. So we could think about Montesquieu and the way in which Montesquieu, in the spirit of laws, talked about the need to separate power. But we all know why that is, because power needs checks and balances. But have we adopted that type of thinking into the economic frame? Have we thought not so much about separating political power, as we do with the executive, the legislative, and the judicial, but how to separate economic power? And in some ways, that's what competition law is about. That's what even intellectual property, to some extent, seeking to balance out private and public interests, is ultimately about mediating between private and public. But I don't think we've really thought about it through a constitutional lens. And so in some of the work that I've been attracted to, we could speak perhaps of the separation of economic power doctrine and think about the various aspects of law that go to separating power in the economic domain. Why would we want to do that? Well, the simple answer is the rule of law, and particularly focusing on the practical dimensions of the law. If we don't separate economic power, we know what happens. The economic power becomes concentrated. And when it becomes concentrated, it then has significant impacts upon regulatory frameworks, which then impacts upon the way in which the law is created and the way in which the law is developed. So I might speak to some of those themes later if I have time, but thanks for the introductory opportunity.
Thank you, Robert. I really like that you took all of us back to another fundamental question of what is really economics before understanding more about law and economics. And you said it's who gets what. So I think it's also important to add one layer to it. In understanding who gets what, we need to understand how much and when. So the issues of equity, efficiency, all of this will kick in. But thank you so much for those introductory thoughts. Let me move to Kevin now with the same question. Kevin.
Sorry about that. Thanks very much. And I very much appreciate this opportunity to talk with you all a little bit about law and economics. I come at the issue from a particular perspective, I guess. It's funny, in some ways, I studied economics as an undergraduate, and then I went to law school, and I thought the study of law was much like the study of economics. Same kind of classes in some ways, same kind of exams in some ways, although I did better in law school than in economics. And it strikes me that Robert's exactly right. Economics is about who gets what, and law is about who gets what. And so they work well together. And I think it's unquestionably the case that law and economics has really transformed the way that most judges, scholars, and lawyers think about the law in the United States, and it's had an impact on legal rules. And I think it's helped improve the focus of legal rules and legal decision-making. And in the end, I'd conclude that economics unquestionably can aid in the analysis of legal issues and rules. At the same time, I think it's a big mistake to think that economics is black and white, cut and dried, and completely objective, and a easy way to reform the law. We all know that legal rules aren't clear-cut. And the same is true for economic analysis. As Ashish said in the introduction, you get 5 economists in a room, you may get 6 opinions about what the rules should be. I think that economic analysis has many variables. They have to be estimated. Outcomes do not always come out the way economists say they'd come out. Numerical values have to be assigned to certain injuries if you apply it to law, and those can be debated. In the United States, there's a famous case involving the Ford Pinto, in which there was a cost-benefit analysis engaged in by the Ford Motor Company. They decided not to repair a defect in a car because it would cost more to repair it than it would to pay off judgments in wrongful death actions. Raises all kinds of questions, including, well, is economic analysis appropriate when you're dealing with people dying? How do we value the loss of life? And what about pain and suffering, which is very different to objectify? So I think it's a mistake to think that economics can dictate answers and can help us finalize legal rules and the outcomes of cases. Like law, there's room for discretion, there's room for judgment. When law and economics tools of analysis are employed, you'll have economic indeterminacy, and that necessarily means legal indeterminacy. So in the end, I don't think that law and economics is a silver bullet for clear legal rules. In addition, law and economics has a decidedly political point of view. Many adherents, particularly in the United States, but not all of them, are conservative. Law and economics has been questioned as overly conservative and too conservative an influence on the law. So in the end, I think that law and economics is a useful tool, but it is exactly that. And it's like other tools that are available to judges, lawyers, and scholars in looking at the law. You can learn from many different disciplines about how to fashion legal rules. You can look at the social sciences, like the US Supreme Court did in Brown versus Board of Education, in holding that segregation led to poor educational outcomes for African-American students. But I think history, sociology can also offer some insights into legal rules. And in a very different political sort of position, some would say that critical race theory, which analyzes the law by focusing on the law's treatment of minorities in society, is a useful tool for looking at the law. It's added important insights and context to legal analysis. So I think that while economics can be a useful tool, lessons and tools from other disciplines can also help as well.
Thank you very much, Kevin. Economics is a tool within a portfolio of tools available to the legal system as such. Thank you for sharing those thoughts. I'm going to take the same question to Bobby, our fourth panelist. What are your thoughts on this, Bobby?
Well, thank you for Ashish having me here, and thank you to Jindal for this wonderful gathering. This panel, but really this entire gathering, like so much that Jindal does, really is world class and truly global in every sense of the word. And so, thank you for the opportunity to be here. I will try not to reiterate things that we heard from my fellow panelists. They have covered lots of the relevant territory. Let me say a little bit about the basic question you started with was the contribution of economics to developing the legal system. I'm going to say a little bit about that, and then I'll come back to what lots of the discussion is focused on, which is the law and economics as a methodology for analyzing law. In terms of the broader kind of what is the role of economics as to the legal system. So a few sort of broad thoughts. The really two things I'll highlight. The first is that we do have seen over time, and I can say this without any prejudice to the baseline systems of custom, but that as economic growth and wealth increases in jurisdictions, there generally is this movement away from relational contracting, from custom as a mechanism for relationship building to institutions and structures, right? So again, rather than relying on tribal relationships, on custom, on tradition, and on this kind of relational dynamic, there's the opportunity to put in place institutions, and there is a drive, a push to put in place institutions that allows for further economic growth, further economic activity, and the like. That's an important phenomenon, or it can be an important phenomenon. It's not an unmitigated good. It can be destructive in many ways as well. But broadly, it can be understood as an important component of the interrelationship between economics and economic growth and what the legal system looks like and the role and the scope that the legal system plays. I'm going to give then my second point, kind of to connect it to a concrete setting for that I think highlights that interrelationship that can emerge. I spent a good chunk of the early 1990s living in what was initially the Soviet Union and then became independent Russia. And I was very involved in legal reform issues at the time as the Soviet Union was collapsing and independent Russia and the other republics, now countries, were emerging. Among the folks who were working very actively and prominently on economic reform at the time was a guy by the name of Jeffrey Sachs. Jeff Sachs really in many ways spearheaded the kind of shock therapy, or was the theorist behind the shock therapy model of privatization that was put in place in Russia and a number of the other post-Soviet countries and republics. And again, it was a small community of Americans and really expats in general in Moscow at the time. And so I came to know Professor Sachs at that time. And at occasion, it was a small group, maybe it was 30 or 40 people. And Jeff was giving some remarks on what needed to happen in terms of economic reform and economic vitalization in then independent Russia. And after he finished and it came time for Q&A, I was at the time just an undergraduate student, but one who was focused on law and legal reform. And I knew him well, and I thought I would give him a softball question. So I stood up and I said, what is the role of law in what you're describing? And his response was, we'll get to that later. And I said, you mean my question? He goes, no, law. And I said, what do you mean? And he went on to explain, and he said, right now the task is to unleash the forces of economic growth and capitalism and so on and so forth, and the law would follow naturally from that. Needless to say, unless you have been completely oblivious to the ensuing history of Russia, Jeff was wrong. Now, the end of the story that I'll mention is that some years later, he gave a lecture at Yale Law School, from which I graduated, that was all about the importance of law in economic growth and development. And they sent a copy of this lecture to all Yale Law graduates. And so I got my copy and I scribbled a note in the front and I said, Jeff, I'm glad to see you finally figured out the answer to my question. And I sent it to him and he hasn't talked to me since then. But it highlights the ways in which there was, and I think there is in some corners of economics still, this notion that law is a simple outgrowth of a certain state of the economy, as opposed to a critical ingredient and almost dispositive factor in determining the path of economic growth and our lives. The obvious ones we talk about are property rights and contractual rights. So the notion is you can privatize, but unless there are clear lines of who owns what, property law and contractual laws that allow you to engage in contracting, it is hard to navigate that economic liberalization effectively. But others follow very readily. What about the lack of a judicial process, which requires rules of civil procedure? What about a bankruptcy code that allows entities that have gone bankrupt to not be subject to imprisonment or to execution or the like, but instead are subject to some mechanism of bankruptcy and reform? All right, so those are some thoughts on the relation between economics and the legal system generally. Very quickly, because again, I think we've covered lots of this. Law as economics as a tool vis-a-vis law. The first thing I would say is I totally agree with Kevin that it is a problem that not uncommonly in the law and economics community in the US, and I think increasingly overseas as well, economics is thought of as the tool. I used to be, and I use law and economics in my work, and I was used to defend it to a colleague of mine who was very critical of law and economics by saying, look, it's just one tool like others. Nobody is claiming that it's the only tool. And we had a presenter came, I won't say the name, but a presenter, very prominent law and economics scholar, but also a very mild, unassuming guy who I thought would be reasonable. And he presented a paper called The Nobel Prize in Law. So anyway, we went to his talk to hear his presentation, and his entire presentation consisted of saying that we don't need a Nobel Prize in law because we already have it. It's the Nobel Prize in economics. In essence, arguing that the only real way to analyze law was through the economic lens. that is to my mind, a very foolish device. That said, I would also push back a little bit. I think that economic analysis used properly as a tool, along with the other tools that Kevin also mentioned, can have a kind of a discipline, or can encourage a disciplining effect, right? It can force us to ask questions that we might not naturally otherwise ask. Now, to be fair, critical race theory, as Kevin mentioned, and law and sociology and law and psychology and law and politics can do that also. But I do think that the economic framework is one that sometimes can push us more than some of those others, because it's relatively new or unfamiliar or the like. But we have to guard against this hegemonic notion that economics is really the only way, or even the primary way, to understand law, because that then produces the range of political fallacies and biases that Kevin also described.
Thank you, Bobby. Thanks very much. Well, I was hoping that one of the panelists would also talk about what the law has to teach economists, or to the discipline of economics, but I guess we'll tease that out as we move on with the discussion. I want to bring us to the next question, highlighting the role of judiciary. We know that how laws are interpreted and enforced ultimately depends on what behavior is in the rational interest of legislators, judges, lawmakers, people in general. And there is an inherent problem with this, as we all know. Now, the question is around the role of judiciary in promoting the intersection of welfare, economics, and law. It came up in the introductory remarks that some of you made. Should the concept of welfarism be the sole evaluation criteria for legal rules and institutions? And how can it benefit the society? Can I start with you, Shilpi?
Sorry, yes, absolutely. Thank you so much, Ashish, for that wonderful question. And also, just very briefly to the previous question that you asked, I think the reason why most of us didn't mention how law influences economics is because in so much of sort of the law and economics movement is about what law can learn from economics. And this is sort of one of the criticisms of the movement, that it's all about sort of economics kind of dominating our analysis of the law, rather than sort of, or even economists dominating sort of, because I did a PhD in law and economics, and there was a lot of friction between the 7 lawyers and the 7 economists who were in the program. And it was always the economists telling us that we didn't know what we were talking about. So that's basically what law and economics is about. Economists telling us how we should interpret the law. But just quickly on to the question that you asked. So when we think of sort of the concept of welfare, what we think is, of course, that sort of getting what we want. So getting most of what we want. So we know what we want, and then sort of we act in a way that we get what we want, whether those are, and that's the maximization of utility. And in a lot of sort of the normative frameworks of a lot of sort of laws are designed to sort of create systems through which you can maximize your utility. But that, of course, presumes that we know what we want. And this is where also there is sort of some literature that, we don't always know what we want. And also, how do you actually come up with knowing what and aggregating everyone's utility, right? So how do you sort of create laws that, then you basically become, because everyone has different preferences. So if you're trying to sort of create a world where you're making everyone happy, you're basically doing it at a very, very basic level. So you're oversimplifying it to such a degree that sort of, is there any sort of benefit to using that tool when it becomes so oversimplified to that extent? And then the questions of sort of the diversity of population, of inequalities, of sort of where different people are coming from, and then do those rules really serve different people? Then that's a question that sort of comes up. So when we think of sort of the role of judiciary in this regard, I think one thought that I want to put out there is that so the judiciary is supposed to promote justice, right? So and justice is, in a sense, an outcome that we all think should be the right outcome, and that in itself gives us some utility, right? So when justice is done, that in itself might be a welfare enhancing outcome. And who's to say that that's not a better outcome than some sort of mathematical sort of determination that we've made based on sort of aggregating the preferences of different people. So so in terms of sort of what judges do, and sort of this is also bringing in concepts like fairness, like equality into economics. So if you want to bring those, who's to say that those are not important principles that people want to live and want to have in their lives, and that doesn't give them happiness? If judges are sort of bringing those kind of principles, then why not? So that's sort of just what I want to say, that sort of maybe we need to go beyond welfareism in the truly economic sense and think of sort of other concepts as well.
Thank you, Shilpi. Robert, would you agree? Do we need to go beyond welfareism as an evaluation criteria for legal rules and institutions?
I mean, short answer is yes. But how do we do that, I guess, is the follow-on question. Again, there's a number of different ways of coming at welfare economics, but I tend to look at it through a cost-benefit lens. I mean, that's part of what welfare economics is. It's certainly not the whole story. But it, to some extent, goes back to Kevin's point about the Ford Pinto example and the cost of a life, for instance, and weighing that up against the various benefits. That also flows into corporate accountability questions, which I touched upon earlier. I guess one of the things that I would state from the outset is that the judicial system and the political economic system generally is not always particularly good at measuring costs. It seems to be better at measuring benefits, and this is particularly the economic system, I would say, is better at measuring benefits rather than costs. And that's often because of the private-public dichotomy. That is, the benefits usually are privatised and the costs are usually socialised. And so you end up with that sort of public choice theory dynamic where you have a fractionalised interest when it comes to dealing with the costs associated with economic activity. But I think the law does have a really important role to play in accounting for costs, and whether or not that's done through an economic lens or not is perhaps not the point. This might seem like a bit of an abstract example, but the foundation of the Australian legal system over 2 centuries was really built upon a false fiction of terra nullius, which was to say that no one lived on this continent prior to 1788. And then we sought to build a legal economic system with the political economic dimensions that flow based on that falsehood. But yet, after a couple of centuries, the High Court of Australia turned its mind directly to that question and actually confronted it and said, well, actually, that's not true. And in doing so, it was really, from a very macro point of view, able to acknowledge the costs associated with the colonial foundations of this particular country. And again, while that might seem like an abstract example, I think there are many other micro examples scattered throughout our political and social and economic system where costs and benefits are askew. I'm particularly interested in intellectual property, and perhaps we'll get to some of those issues later, but just following on briefly, that the intersection between law and economics is obviously the heart of what we're talking about, but a part of that equation also, I think, particularly for the future, is the intersection between law and technology. Because more often than not now, it's technology that is determining what we can and can't do rather than the law itself. And I mean, people like Lawrence Lessig in the US have made that point very clearly through the sort of code analysis to say that, you know, computer scientists are perhaps the new lawyers in a sense, in that they are able to determine who does what. So I would like to, I think, flesh out some of those law and technology dimensions and how those law and technology dimensions relate to this law and economics discussion. Thanks, Ashish.
Thank you, Robert. I'll take the same question to Kevin now. Kevin, your views on the role of judiciary in promoting welfareism or welfare economics?
Well, I think courts have done their best to try to integrate economics into their analysis. But we have to remember that judges, at least in the United States, for the most part, aren't economists and are going to only be able to really apply sort of the signposts of economic analysis as opposed to the nitty-gritty of economic analysis. I think the benefits of economic analysis to judges has been in thinking about things like costs and benefits, like externalities, the impacts are probably the greatest in antitrust law, but still, as Bobby mentioned, economics creates some things that we should focus on, and judges do focus on more now than they did in the past. In their analysis of legal issues. At the same time, I think that economics was in the deep background of many legal regimes well before the development of law economics and played some role historically in the development of legal doctrine and analysis. I'll give you an example from the United States. The rules that govern the federal litigation process, the federal rules of civil procedure, which were put in place in 1938, they focus again and again and again on economy and efficiency in civil litigation. They create rules that foster and promote these values, maybe too loosely related to economics, but still loosely related to economics. They require things like joinder of claims in one lawsuit as opposed to many lawsuits, joinder of parties in one lawsuit as opposed to many lawsuits, huge class actions to resolve as many disputes out of one wrong as possible. I think these are the kinds of economic concerns that you expect judges to handle rather easily, even though it's elementary, I give you that. But I think trying to get judges to really focus deeply on economic analysis in welfare economics it is going to be difficult. Even law professors with PhDs in economics have to grapple with these things. I think it's an awful lot to expect judges to be able to, as amateurs. And that's not, I don't mean that to be an insulting term, but that's what they are when it comes to economics.
Thank you, Kevin. Bobby, your thoughts? Is it simply a problem of relying on signpost economics, or is the problem deeper, where perhaps rational interests are being pursued by judges who might simply be irrational? What's your take?
I suspect it's a little bit of both. So let me actually begin with since we're talking about judiciary in particular and sort of law and economics, the kind of historical point of reference, and really contemporary too, that I thought might be interesting for folks is so much of the influence in law and economics has actually not come exclusively via academics, but has come via, in fact, the judiciary and public officials more generally, but particularly the judiciary. And that's a product of a very systematic program that was undertaken starting a little bit in the 1970s, but even more so picked up in the 1980s, funded by a group of organizations, the Olin Foundation and others, to develop these judicial training programs in law and economics. And they were very pleasant, always in very pleasant locations, that judges would be brought to be trained in law and economics. And again, one can construct the nefarious version of that. And I don't think one would be wrong to do that. But even without the nefarious version of it, this became I'm going to say an ideological approach to the use of economic analysis by the judiciary. Why ideological? Because it came from a particular frame of neoclassical economics that was being pressed and advanced. That neoclassical model in terms of its assumptions of that the baseline is efficient, notions of the common law was the efficient model because it's a product of market-like forces, as opposed to statutory and regulatory action is in essence, by definition, inefficient because it involves market interventions, which are not subject to the same kinds of pressures. It pressed for devolution of authority from federal to state to local level, because that would invite sort of competition among jurisdictions, jurisdictional competition, regulatory competition of various sorts. So it was a particular frame of reference that was ideologically pressed forward. So it is the case, again, as Kevin touched on earlier, that today law and economics, as it plays itself out in the judiciary, has tended to be grounded in that particular model of economic analysis. Now, the good news is that the legal literature has moved a long way from that. So it's probably the case that if we did a search for law and economics analysis, a huge chunk of articles in the last year or two in the United States on law and economics will be grounded in behavioral economics, alternative game theoretic models than what have been used traditionally. Some of my own work has been on a shift in analysis from prisoner's dilemma games to coordination games and what that means for the scope and appropriate role of government institutions and regulation. So I think that in the scholarly literature, there has been more and more recognition and embrace of that. How much that is transferred or translated into the judicial branch? I think some, but not nearly as much as one might hope. It's also the case that, an article was written by a former colleague of mine now some 10, 15 years ago, in which she said, when everyone does law and economics, no one is doing law and economics. Now, what did she mean by that? She was saying that she actually did a search for the references to efficiency in law review articles. And she found that it had spread so widely that in essence, if you use that as the measure of what law and economic analysis is, focusing on or attending to efficiency, that would of course capture 60%, 70% of the legal literature. And so she raised the question, if everyone is doing that, then can we say that anyone is doing that? Or has it become so diffuse and meaningless that it doesn't have any force anymore? The last point I would say on this is that part of this is also a disciplinary phenomenon. It's that it is hard to translate cutting edge economics into legal scholarship, let alone cutting edge economic analysis into legal scholarship and from there to judicial analysis. Now, there's nothing unique about economics. Now, I could do the same thing with cutting edge psychology or political science or sociology. So what tends to happen is by the time you get to the bench, let alone academia, but by the time you get to the bench, there is this incredible lag. So judges apply law and economics, but they apply the law and economics that economists were doing not even 20 years ago, 30 years ago and 35 years ago. So it's awesome that we have this pipeline, this kind of interdisciplinary pipeline, but the danger is the pipeline is slow and it twists and turns and it gets narrower and narrower. So even the judge who says, I'm doing smart law and economics is doing the smart law and economics of the mid-1990s. And economists wouldn't even recognize what they're doing anymore.
Well, thank you very much, Bobby. We have questions coming in from the audience, and I'm going to actually pick one that aligns very well with what you said, Bobby. And it's an open question to all the panelists. I'm going to ask Bobby first and then move on to the other panelists. So given that there are certain challenges with how economics can be, as a discipline, taken to law students in law schools, the question is, how do we bring in this intricate study of economic analysis into legal education to law students? Does it require a change in the structure? Does it require a change in pedagogy? Does it require anything that is currently very difficult for law schools to adopt? And I'll add another layer. Is all of this more difficult to do post-pandemic?
Good. Well, I want to hear what others say, because that's a great question. So I'm wondering what others have to say. So I'll just very quickly say on the first part, lawyers are a conservative bunch. I mean, not in the political sense, but in the caution sense. And if you think about even for India and the United States and other common law jurisdictions, even more so, right? We have an entire legal system that is premised on the law is the law because someone 100 or 200 years ago said it was the law. We've evolved a little bit, but very incrementally and gradually. So that translates into the law school curriculum as well. In particular, it shows up as, sure, law schools teach law and economics, and law schools teach law and psychology, and law schools teach law and social science, but they tend to teach it in isolated pockets, right? It is a separate course, or there is a particular professor who has a PhD in X, and so they weave it into their course. From my vantage, what I tell people is that I spend a lot of time as a dean out there among employers. I haven't found the employer who is looking for students who know less. They are generally looking for them to know more, and they actually don't mean more law. What they generally say is we can teach them the law, right? What they want them to have is a sophisticated understanding of the broader context in which whatever area of practice they're working in operates, whether that is psychology or economics or finance or political science or whatever else it might be. So I think, again, as law schools, if we can find ways to, in a more serious way, integrate the law and into things, into as early a stage as our first, you're not going to throw contracts away and replace it with a law and psychology class or a law and economics class, but to weave those things in, it will begin to lay the foundation so that the students themselves go off and take bankruptcy, right? They're asking a different set of questions than they would ask otherwise. That's the one. Post-pandemic, obviously, the biggest, from my vantage, impact of post-pandemic is physically during the pandemic, we all hunkered down, right? We hid in our bedroom with all the curtains closed and the doors closed. I worry a little bit that there are two paths that diverge in a wood post-pandemic. The other is a flourishing of innovation and creativity and new ideas. People are excited about, we are back, we have opportunities to try new things, experiment with new things. And the other is that people have been becoming accustomed to the precautionary principle, and they're resistant to trying anything new. And if we see that, frankly, I think that legal education globally will suffer because to keep up with the world, we've got to be able to.
Thank you. Thanks, Bobby. Shilpi, what do you think? You've done a PhD in law and economics. You teach in a law school. You routinely teach economics students. I know that. How can we get this right in our universities?
I think, no one has mentioned Posner yet, so I think I'll mention Posner. Posner said that sort of what's important is to convey the intuitions. So I think in terms of how we it is important for law students to understand the intuitions of economics so that they can just apply the basic and have a basic understanding of what economic behavior looks like. So I think in terms of how we communicate, and this also goes back to what Bobby was saying, right? So they don't have to know everything, but just in terms of understanding the intuitions, I think if we can communicate that to them, and that too, as Bobby said, across different across different classes rather than just through specialized courses, I think that would be a better way and a more effective way. So just in terms of just the basic understanding of what economics provides, I think is because if you go too much into the technicalities, I think we lose our students. So I think we should keep it simple, but it's important to convey to them at least open their minds to these different disciplines so that they know what the possibilities are, and they can go and and then you can have more advanced courses as electives where they can but at least the basics, all students should be communicated at least the basics. That's my thought.
Thank you, Shilpi. Robert, what do you think? Is the problem so grave that we need to change the structure and the pedagogy in law schools?
Laws are social science, right? In the same way that economics is a social science. So I think what's happened over time is we've tended to bunker down into our disciplinary camps and, in a way, separate things that in previous times were not separated. If you go back and actually read The Wealth of Nations by Adam Smith, it's not necessarily an economic doctrine that he's presenting. He was a moral philosopher or an ethicist, and there's a whole range of ideas in there that are applicable to the study of law. But yet, we don't necessarily integrate original text from The Wealth of Nations into legal studies. There are a whole range of different ideas that can come from law and economics, whether it be through Adam Smith's original work in The Wealth of Nations, whether it be looking at Demset's ideas about the cost and benefit of actually establishing markets in relation to particular activities, whether we're looking at Ronald Coase and the nature of the firm, and distinguishing between market activity, state activity, the firm activity, and perhaps social production as well. We haven't talked about social production, but Johan Benkler talks really nicely about that, I think, in The Wealth of Networks, and the role of the fact that economics doesn't answer everything, right? Because if you look at the development of things like music, language, science, none of those things were developed because people were getting paid to get out of bed in the morning. I mean, language is a very classic example of that, right? It just happens because society produces stuff. Some of that stuff is recognized in the economic system. Other things just happen naturally because humans are, social beings, and we can talk about behavioral economics and everything else. So from my point of view, I think it's really about breaking down these false boundaries between disciplines and recognizing that at the heart, law is a social science, with all that comes with that. The grey areas embedded within historical analysis, within economic frames, and the like. So that's what I would say.
Thank you, Robert. Kevin, your response to this question.
No, I think that it's a hard one, because when you talk about changing the curriculum, that's always a challenge, and something that if I want to sort of take all my faculty's time for a year, I raise the topic of curriculum reform, give a committee the task of coming up with curriculum reform. They don't have to talk to any faculty members for the whole year because they're all wound up with curriculum reform. Seriously, I think if we want to, and I think it is important for students to learn tools of economic analysis and law and economics. I think we have to think more carefully about how we hire and how people integrate issues of economic analysis into their classes. I mean, I had this tremendous class in law school from a professor who later became a Court of Appeals judge, Douglas Ginsburg, on economic analysis that I benefited from greatly. But a lot of students who probably need that kind of class won't be taking that class. So you need to come up with a way of integrating it across the curriculum. And I would say that for other disciplines as well. If you're really interested in inculcating that body of knowledge, you have to figure out how to integrate it across the curriculum. And that involves hiring, not necessarily changing people's syllabus or what they're teaching. And I think that's why having a disciplinarily diverse faculty is a good thing and can really benefit students in important respects, get economic issues and analysis out there. I do have a similar experience as Bobby with employers, except the employers I've been dealing with are always telling me that they need students who know more about accounting. There should be, more lawyers, accounting for lawyers classes, things like that. We need more hard business knowledge among law students, as opposed to that softy kind of knowledge they get in some of their classes, according to the employers.
Thank you, Kevin. So this is all the time that we have for this particular session. We have 2 minutes left, so I'm going to exercise my moderator privileges to say something to all the law students and economic students who are listening to this. We briefly touched on this. Does law have anything to teach to economists? I am one of them, but I think law has a lot to teach to economists and to the discipline. In fact, economics generally applies its general theory largely to abstract concepts of the property exchange, firms, technology, capital, even labor. But as David Friedman has said, quite a lot of what lawyers and law professors do involves dealing with the same concepts in their real world incarnation, which is very, very different. Some of you talked about critical race theory, but sociological, political, cultural dimensions of not just CRT, but religion, caste, cultural differences. There's so much complexity that is not taken up in the true form. But I'll end with the story. It's a very interesting one. Some of you might know this. Around the 1960s, when this movement was picking up in the United States, Aaron Director, who's the founder of the Journal of Law and Economics, he had hosted a dinner at his home for Ronald Coase to discuss his theories on property rights, which they considered in error at least, and at worst, hearsay. They wanted to understand the arguments that he had presented in his 1960s famous paper. And the crowd was really top-notch people. It included Milton Friedman, George Stigler, Arnold Harburger, John McGee, really the enlightened minds of the time. The discussion began with 20 of 21 people opposing Coase and his arguments, and it quickly, and the whole thing was then called and described as Coase theorem, which we now know very popularly. And it led to a Nobel Prize for Coase, of course. By the end of the evening, by the time dinner was over, it was dessert time, all 21 of the attendees endorsed the paper and Coase's arguments. Coase had successfully converted all of them. In fact, according to John McGee, and I quote, the debaters stumbled out into the evening air in a state of shock, mumbling to each other that they had witnessed intellectual history. Now, since then, the famous 1960 paper by Coase, titled Problem of Social Cost, is still probably the most cited law review article of all time. So, law students, there is something...
Can I add, though, Ashish, just a quick tack on to highlight sort of the complexity of those, of course, is that Ronald Coase, to the end of his life, including I recall in a conversation I had with him, said, "It distresses me that my name is associated with a theorem that I never advanced." So unfortunately, those 21 people in the room took what he said and they made the Coase theorem, which wasn't actually what he had argued. Yeah. Exactly. So to Kevin's point about the way in which, again, kind of these things get distorted in the politics of it, Coase was never of the argument that, you don't need law. To the contrary, he was suggesting that law has this important consideration, but unfortunately in other hands, it became something different. But anyway, I love that story.
Absolutely. No, thank you for that comment. But that's all the time we have. Thank you so much, Shilpi, Bobby, Robert, Kevin, for your time and your wonderful insights that you've shared. I'm sure all the participants have benefited. Thank you very much. With this, we come to an end of this session. Thank you.
Hello, good morning, and welcome to this exciting new session as part of this wonderful conference. In this session, we are going to talk about educating legal education, the globalization of legal education. Legal education has passed through different phases, such as internationalization and transnationalization. When we talk of internationalization of legal education, it has ensured that we moved beyond the purely local conception of law towards developing specialized areas of practice and research, such as conflict of laws and public international law. Transnational law has ensured that we study different jurisdictions. But in the last few years, the legal education has passing through the phase of globalization, a process that has brought countries and peoples closer due to massive developments in technology, reduction in the costs of transport and communication, and the disintegration of barriers to the flow of goods, services, and investment. This deepening integration has presented both a new set of opportunities and challenges that legal education has to confront. Opportunities refer to greater learning prospects, such as adopting globally accepted best practices that can be contextualized and emulated in teaching, research, and academic administration, bigger and better employment opportunities for young law graduates. Likewise, challenges that globalization has brought in newer areas such as international trade, international finance, and international capital that require regulation. Also, when we talk of globalization, we should be mindful of the challenges it poses in terms of climate change, heightened income inequality across the globe, which in turn has triggered a backlash against globalization seen in the form of waves of increasing nationalism and populism in certain pockets of the world. To discuss many of these issues and some of these issues in this panel, we have an exciting set of speakers with us. Let me very briefly introduce the speakers to you before I go on to these speakers. We have with us Professor Dr. Natalia G. Preskina, the Vice Dean of FEFU School of Law, Far Eastern Federal University, Russia. We also have with us Professor Dr. Byron Garth, the Interim Dean and Distinguished Professor of Law Emeritus, University of California, Irvine, United States of America. I also have Professor Dr. Jan Holloway with us, Dean, Faculty of Law, University of Calgary, Canada. And last but not the least, we have Professor Dr. Kelly Vitesti, the President of Law School Admission Council, United States of America. On behalf of Jindal Global Law School and OP Jindal Global University, I welcome all of you to this exciting panel discussion. And let me start by kicking the discussion by asking the first question to Professor Preskina about the challenges that she thinks legal education is facing in the wake of globalization, including the phenomenon of backlash against globalization in certain pockets of the world. Professor Preskina, if you could share your views with us on this. Thank you.
Dear distinguished participants, it is my great honor and privilege to take part in this Global Law School Summit 2021. First of all, I would like to extend my great appreciation to the Vice Chancellor, Professor Dr. Raj Kumar, for his kind invitation, and to all involved in organization of this outstanding event. Paristan Federal University has been in partnership with OP Jindal Global University and Jindal Global Law School since December 2016, when we concluded our cooperation agreement, and since then our relations proved to be strong and long-term, and we hope to develop further working ties with your respected university and the law school. I believe this summit is in some sense symbolic, as next week on December 6th, our President of Russia will be visiting India and meeting with your Prime Minister, Mr. Narendra Modi, to discuss the most privileged strategic partnership of our countries. By the way, Mr. Modi has visited our university campus in Vladivostok back in 2019, during his participation in our Eastern Economic Forum. And this year he was participating online due to COVID restrictions. Moreover, this event is symbolic for us as today we celebrate the National Lawyers' Day in Russia. And I'm also very pleased to be today on board with distinguished panelists, colleagues from the United States, Canada, and India. I have very fond memories about kind and hospitable people and have beautiful countries which I visited and where I studied before. I studied in Middlebury College, Vermont, and McGeorge School of Law in Sacramento, California. Our university has a federal status, which is like the top status among all universities, and our School of Law is on top law schools in the Asian, in the Pacific part of Russia. As far as this question, as far as global challenges are concerned, we should consider probably guides and results of surveys made by professional global organizations and legal stakeholders. And last year, there was a research and there was a report made entitled Developing a Blueprint for Global Legal Education, which was undertaken by the International Bar Association and the Law Schools Global League with coordination of IE Law School from Spain. And the results were discussed at the International Bar Association conference last November. So this, the key challenges that are global and common, this research was conducted around the world in Africa, Asia, Australia, Canada, the European Union, Hong Kong, Latin America, and the United Kingdom. This research analyzed a lot of articles and scrutinized more than 400 law schools' websites. There were a lot of interviews made with top officials of law schools and deans. And the key challenges, for the sake of time, I will not tell in details about them that we discussed at the International Bar Association. So the key challenges for legal education identified included globalization, technology, regulation, diversity in all forms, and affordability and access to legal education among students. So all the above challenges are worth to take into account in order to deal with them and identify and carry out respective precautionary measures. Thank you.
Thank you, Professor Priscina, for sharing your views on this question. Let me now turn to Professor Garth. And Professor Garth, my question to you is that are the law schools, and especially the law schools that we have in the Global South, do you think that they are equipped to deal with these challenges that Professor Priscina mentioned, that globalization today presents to the legal education in general?
Well, I'm going to take a slightly different tack to this question, in the sense that I don't think it's just about whether individual law schools are equipped for the challenge, but whether the kind of political economy of law schools in any particular jurisdiction are up to the challenge. Because I think one of the problems that has engendered backlash is that partly of deregulation of law schools. We have in India more than 1,000 law schools, in China 1,000 law schools, in Brazil, Mexico. We have these huge numbers of law schools, and only a very small handful where you have to have strong English skills to enroll, where you have tuitions often that are much larger than the tuitions at the schools for the many. And you have very selective admissions. That means that almost the only people who can get in are those who come from fairly privileged backgrounds. And in many places, they have no access to the jobs that are created by elite globalization, such as in corporate law firms, which have spread around the world and are also part of the reason why we have all this reform in legal education. So and that engenders resistance. There's a whole movement in South Africa to kind of reject this whole global enterprise because especially the traditionally Black law schools feel completely excluded from the rewards that come with it. So the challenge is to make not just law schools more accessible, but to make the benefits of globalization and global jobs, human rights, and law firms available to those who don't have access to the very small group of schools, which now feeds into the global jobs.
Yeah, thank you, Professor Garth. I completely agree with you on the question of accessibility to legal education. Now I turn to Professor Holloway and a linked question to what we have been discussing in the last 10 minutes. Given the restrictions on access to legal education and the challenges that globalization presents, what do you think are the innovations and reforms that need to be carried out in the curriculum and the pedagogy of legal education?
Well, thank you, Prabhash. You're right. My answer does build quite nicely on what Natalia and Brian had to say. In North America, we traditionally said that the mission of a law school was to teach students to think like lawyers. That was the expression we used, to think like lawyers. And I think that holds true still, except that I would modify it and say that our mission today has to be to teach our students to think like global lawyers. When I started out, and I'm not that old, but when I started out, the term jurisdiction was a comfort term for lawyers because it signaled when something stopped being my problem and became another lawyer's problem in another part of this country or another part of the world. Now, of course, jurisdiction is built into almost every legal issue. I mean, even the most modest clients nowadays will increasingly have interests that transcend the borders of any one country. Now, I don't believe that it's the job of most law schools to teach foreign law. I mean, many of us do. We teach American law, we teach English law and French law and so on. But our core mission is to teach our students to become Canadian lawyers. But what we need to do, though, is inculcate a sense of what I often refer to as global mindedness in our students. So to look at legal problems, not just through a domestic lens, but through a global lens. And in some areas of the law, that is perfectly intuitive. Things, as you mentioned, Prabhash, things like environmental law. We just saw a big international summit dealing with climate change. And if anything ultimately is going to change, it will have to change through law. Human rights law, of course, is by definition a global thing. But even things like business law, corporate law, the phenomenon of the Delaware Corporation. I mean, that long ago outgrew the bounds of the small state of Delaware, USA. Any corporate lawyer, no matter where she or he may be practicing, has to at least be aware of what a Delaware corporation is and the significance of it, and what impact that may have upon the domestic operations of a company in a foreign trade law. So I think it's that globalization is already pervasive, and therefore, as those whose role it is, whose mission it is, whose sacred mission it is, to prepare the next generation of legal professionals, we owe it to them. We'd be shortchanging them if we didn't consciously, assiduously work to instill a sense of global mindedness. In terms of pedagogical reforms, I'll say two things. The first, and I actually mean this, is that we all need to become more like Jindal. And I'm not saying that just because I'm speaking here at a conference hosted by the Jindal Global University. What you have been doing since your foundation has really been holding up a torch for the rest of us to follow. You've done that through the kinds of professors, kinds of faculty you've appointed. You've done it through the extraordinarily vast array of international linkages that you've developed. You've done it through the pathways, the pipelines, to use a Canadian metaphor, for students that you've developed to introduce them to careers in, of course, in India, but in Great Britain and the United States and here in Canada as well. So that's the first thing. We all need to be more like Jindal. The second thing I think we need to do, and this is really this is really lighting a torch in terms of the conventional way that we approach legal education in North America. But that is that we have to break down the dichotomy between theory and skills. The whole model of legal education in North America, and also in much of the rest of the common law world, is based upon this idea that law school is meant to be a theoretical introduction to legal study, and that in their early years of practice, or as an article clerk, the system we still have in Canada, they will acquire practical skills. But the fact is, we now know a lot more about how adults learn and how they retain than they knew in the latter part of the 19th century when the conventional model of legal education was developed. And what brain science tells us is that adults learn and retain best when they, as I put it metaphorically sometimes, roll up their sleeves and get their hands dirty with ideas. In other words, when they actively engage with the subjects that they're dealing with. In other words, that the dichotomy that we draw between theory and skills is a false dichotomy. If you want to teach lawyers how to properly do things, you have to teach them why it is that they do things in that way. And in the common law world anyway, that reflects an accumulation of precedents dating back almost a millennium. Conversely, if you want to teach someone theory, why it is we do them, you have to teach them how to do them. So that's the second thing I would say. So be more like Jindal and break down the dichotomy between theory and skills. Those are my two prescriptions.
Thank you very much, Professor Holloway. That's very, very encouraging for us. We are still a young law school. And I completely agree with you that introducing the global lens to study subjects is something which is very, very important. And at Jindal, we definitely try to do that. And since we are talking about the reforms in curriculum and pedagogy, let me now turn to Professor Testi and ask her that what strategies she thinks law schools can follow in this regard. For example, can a double degree program through international collaboration, can something like this be a way forward for introducing curriculum and pedagogy reforms?
Question, and it's really nice to be with you all today. And I want to start by also recognizing Dr. Kumar and OP Jindal University. The Law School Admission Council is proud to be a partner with you in your law school admission and in so many other ways. And so it's a delight for me to be here with you today. So I want to preface my remarks by saying that I'm going to speak both as LSAC's president, someone who works now all the time at the start of a legal education, encouraging students to attend law school and making sure that admission processes are fair and transparent and ethical. But I also want to share some reflections from the 8 years I spent as the dean at the University of Washington School of Law, that, as many of you know, has one of the most distinguished and oldest Asian law centers in the world, and very much known for its global outreach. So let me start by saying that I think when we begin to talk about reforms that may happen, we could start by realizing that the entire pre-law to practice pipeline is one that we have to attend to. If we work really at only one segment of that, we won't have the impact that we hope to have for legal education. And so one of the things that I would like to begin by suggesting is that at LSAC, we're very proud of the LSAT, which is the best test of critical thinking for law school admission that there is in the world. And I congratulate Jindal for using the LSAT India for its admission. I think starting with admission is critical because it shows students that the pathway is a fair one. It's one that rewards potential and not just privilege. Because until law serves all of the world, it won't reach the potential that it has to make the world a more just and humane place. In terms of curriculum and pedagogy, I'd like to also there share that there are many different kinds of programs that can work. The joint program was one that you mentioned, and I absolutely think those are outstanding. But in my experience, one of the things that works most effectively is making sure that people are meeting each other. And as Jindal does, and as so many universities do, that there's a constant transfer and a connection between students and faculty and administrators to share common concerns, to share best practices, to learn from one another. And so I think any way you can accomplish that mixing, if you will, that's where you'll see great change happen. We certainly saw that in the work we did early on in China, Japan, and Korea at the University of Washington. And lastly, the other point that I would make today is that I think we all need to be mindful that when we start to talk about global opportunities, those can't mean just opportunities that go to elite and that are at the highest level of big law firm practice. When we think about globalization, I like to suggest that we think about educating every lawyer to be a leader for the global common good, to have the skills in law, the supplemental skills that need to go with thinking about legal doctrine and theory, skills like financial literacy, skills like leadership ability, and of course, ethics and integrity, and that care for the common concern. If the pandemic we've all been through has shown us anything, it's shown us that our world is deeply connected, and that without that concern and care for what happens on a global basis, law cannot be bounded any more than something like a pandemic can be. So I encourage us to think about it in that broad sense and look forward to more discussion with all of you today.
Thank you very much, Professor Testi. I completely agree with you that one of the very important reforms that have to be made is to ensure that legal education does not remain elitist and it kind of reaches everyone. Every student who is bright and who wants to study law should be able to study law. I think that's a very, very important point that you make. Let me now turn to Professor Priscina once again. And, since we are talking about these reforms in curriculum and pedagogy, Professor Priscina, in India or in Global South, our experience has been that there is often shortage of skilled human resources in the law schools, to train students in these newer areas of law that have become dominant in the area of globalization. So, for example, we have a lot of expertise in traditional areas of law, such as constitutional law, criminal law, administrative law. But we really struggle to get quality faculty and human resources in these new areas, such as international finance, international investment, etc. How do you think this challenge can be addressed? And, what has been your experience in Russia on this regard?
Thank you very much for this interesting and hard question at the same time. And we have similar problem in Russia. So the short answer is that we have similar situation in Russia, and we call this staff shortage hunger for experienced staff. So some law schools are just hungry for skilled human resources, and some just starving, which makes them vulnerable in the world of competitive law schools and high quality of legal education. And being from non-English speaking country, Russia is a non-English speaking country, I would also name here not only human resources skilled in new emerging branches or institutes of law, but also faculty members with high or good command of English language, which are necessary for teaching in international programs, in international courses. For instance, our School of Law, which is like top one in Pacific part of Russia, we have hardly 20% faculty members with good command of English. And this is definitely one of our significant disadvantages. And in other law schools, Russian law schools of our region, the situation is even worse. So how we deal with this problem? We send our faculty members for professional training programs. We use programs of visiting professors, both from the most qualified national and institutions. We also use partnership programs on faculty changes and other measures which law schools may afford, taking into account our regulatory, of course, material, logistical, personnel, and other reserves. Thank you.
Yeah, thank you very much. This is indeed a problem, and I think all the developing countries are kind of facing this problem. Let me turn to you, Professor Garth, and from your long experience in academia and in academic administration, what are your views on this in terms of the shortage or the non-availability of skilled human resource in law schools, especially in these new subjects that have become important in the area or in the time of globalization?
Okay, I think I will introduce a little provocative note into our discussion, which is to note that globalization is not just a something that was inevitable and happened because just of technology and some of the things that you mentioned, but it relates very much to the rise of U.S. power after the Cold War, U.S. modes of regulation and governance, the spread of U.S.-style law firms and investment banks, and very much much of the U.S. approach to governance has been, in a way, exported, but also imported around the world. So there's a kind of core and periphery, in a way. So these new subjects, all of the ones you mentioned, like corporate governance, investment arbitration, international commercial arbitration, financial matters, are things that if you want to learn the cutting edge, you almost have to go to New York or London. And that puts a special burden on countries other than those that are close to this kind of core. How do they both master, and you can master it by having Zoom calls and have somebody teach it to you, but these rules also, come with a tilt toward those who made the rules. So what you want to do, and I've seen people at Jindal doing this, I've seen it in Brazil, is you learn the rules knowing that the WTO or international commercial arbitration is not necessarily a completely level playing field, but you learn how to play and you try to move the rules so that they accommodate other interests that maybe weren't there. For example, anti-dumping in the WTO was created by and for the US, but other countries, Brazil, China, India, learned how to play. And so it's not just that you need the mastery of these new areas that are now so important in the globalization that we have now, as opposed to globalization when it was the British Empire or somebody else, and have to learn to play this game and be able to excel and further the interests in those rules, along with mastering the rules.
Yeah, I agree with you completely, and I can say this from my personal experience. I work in the area of trade and investment arbitration, and when I started teaching trade law in India about a decade back, there were hardly very few law schools in India where trade law was taught. But today, a decade later, almost every law school, or well, at least the important law schools, all of them offer a course on trade law. And this is because India has been a very active player in the WTO. And you mentioned about anti-dumping. India happens to be the highest user of anti-dumping duties. So yes, I guess the important point that you make is that through your human resource, you can also play a role in trying to shape, the rules of globalization. Professor Holloway, if I may again come back to you, and sort of, a very important thing that we see in this area of globalization is that lawyers or even academics, they have to continuously keep themselves updated because there's so much that's happening all around. And therefore, in this regard, there's this new concept of continuing legal education, which has become quite important. Now, what are your views on this? Do you think that this can be an important tool to retrain and reskill lawyers in the area, in these new areas of law, especially in this area of globalization?
Prabhash, I think this is actually the most important question of all, and in a way, it's more important than talking about evolving the curricula in law schools, because we kind of do that anyway. we all know that the legal profession, I don't know about Russia, but it's probably as true there as it is in Canada or the USA or India or Great Britain or Australia or New Zealand, is conservative by nature. Some might say resistant to change. We also know that there's a famous scholar, a business scholar named Peter Drucker, who once wrote famously that culture eats strategy for lunch. In other words, we can talk and plan for change, but unless the culture changes, then change really won't take place at all. And so if we really want to make the most of the opportunities that globalization presents to make the lives of humanity better, to protect the environment, to further safeguard human rights, to prevent war and so on, we need change in our professional culture. And the way to do that, of course, is to get lawyers to want to learn. And so this has been one of the greatest challenges in North America. I mean, most jurisdictions in North America now have forms of compulsory continuing professional legal education. But it's also true, I think, that in most jurisdictions in North America, many lawyers don't take it seriously. It becomes, as we say, a bit of a box-ticking exercise. So the question then is, how can we motivate lawyers? Because, of course, they're going to shape the mind, no matter what we do in law schools, they're going to shape the minds of the young lawyers who join their offices. How can we motivate them to want to get aboard the globalization train, because that train is leaving the station whether we like it or not. And I think it's possible to do so, but we need, in order for this to be successful, in order for cultural change really to take place, we need the bar councils and we need the courts to come to the party. We need the bar councils to really put teeth in these continuing legal education, continuing professional development requirements. And we need courts to say, I'm not going to hear you, counsel, because you haven't fulfilled your continuing education requirements. I'm going to disbar you. That's the kind of thing that we need. So I think it's possible, Pravash, but I think it needs a lot more teeth than, at least in this country or the United States, we've given it so far.
Yeah, thank you very much, Professor Holloway. At Jindal Global Law School, we are trying to develop a program on continuing legal education. And I completely agree with you that it should not just be a box-ticking exercise, and some kind of carrot and stick policy, would be useful to ensure that it actually achieves the purpose for which it has been set. Professor Testi, if I may come back to you again, and one of the concerns that we often hear these days is that because of globalization and because of growing interest in certain areas of law which are considered to be more lucrative or maybe might generate more jobs for law graduates, we see a tendency among students that they kind of try to neglect or maybe not give much attention to traditional subjects or theoretical areas of study. And therefore, these areas are being pushed to the margin. Would you agree with this from your experience? And if yes, then what do you think can be done?
Thank you very much for the question. And there's really two different angles on this, and let me outline both of them. The first one is that students, when they're going to make the investment of legal education, of course, are looking for a way to realize a living and profit from that investment. And so as they're thinking about where to go and what to study and then how to progress through legal education, they're of course mindful of their career and making that investment worth it. And so that's something that I think pushes toward certain fields where the payoff for being a lawyer is much more lucrative, as you've noted. What's difficult about that and what cuts in the other direction is that in many ways, that's not necessarily what's in the heart of the student when they begin. And we do extensive studies of law applicants, asking them, why are you interested in law school? What is it that's drawing you there? And over time, the answer to those questions has changed quite dramatically. And it's not in the direction of going more toward making money. It's going away from that, in the sense that one of the common answers used to be, it's a way to make a great living. My father was a lawyer and he told me to go to law school. Those were common responses. Today, the top 3 reasons people go to law school all are different ways of saying that they care about the world and they want to make a difference in it. They want to make positive change and they care about justice and claims for justice. And so I sometimes been known to tease my faculty and say, please don't turn gold into lead. Those students come to law school really wanting to make law align with justice and to be able to see themselves in a role that helps them work for justice. And so I think it's incumbent upon all of us in legal education to understand that part of the complexity of our task is that we take students from all kinds of fields and then they go into all kinds of fields. And what's difficult then is we have only a small amount of time to make sure that we're providing the kind of education that can even that up a little bit as they come into law school, and then open all those very different doors and empower them for a lifetime in law in what are vastly different fields.
Yeah, I agree completely. And if I may offer an analogy from cricket, I don't know how many of you follow cricket. No matter how popular the T20, the shortest version of the game becomes, Test cricket, the 5-day version, will still remain popular. So I guess no matter how important courses on investment or trade or commercial arbitration become, I guess courses like jurisprudence or constitutional law or administrative law will still continue to be popular. Thank you very much, Professor Testi, for sharing your views on this particular topic. Let me now come to a slightly different area, which some of you have already touched earlier. And for this, I'll turn again to Professor Priskrina. In the last few years, we see that while there is globalization, but there is also a backlash against globalization. And we have seen this becoming important post Brexit or post the victory of Donald Trump becoming the US president, and the rise of right-wing forces all over the world. Now, this backlash against globalization and this deepening of nationalism and rising populism that we see all over the world, this is also bound to have an impact on legal education as well. So my question to you, Professor Priskrina, is that what kind of impact do you think it would have on legal education, and how best legal education can respond to these challenges?
Thank you for your question. Speaking about Russia, we are a multinational, multi-religion, multi-language country, and in general, people are quite tolerant and are against various manifestations of nationalism or populism in our country. Moreover, it is strictly prohibited by our legislation on its highest level by the Constitution of the Russian Federation. And in recent years, President of Russia has attacked nationalism several times, in particular to the Ministry of Internal Affairs of Russia. He demanded to strictly suppress the propaganda of nationalism, xenophobia, religious enmity, violence, pointing out nationalism as the first among the priority threats. It seems that diversity in students and faculty members may be seen as one of the efficient responses to minimizing or limiting deepening nationalism, and not only in terms of internationalization, but also diversity in different variables, such as diversity in terms of location, whether it's rural or regional, maybe gender diversity, cultural diversity. And in addition, law school's curriculum may be amended by respective courses. Thank you.
Thank you. Thank you so much, Professor Praskina. I'm curious to know the views of our panelists from US and Canada on this question, because this is a question which I guess affects both the global North and the global South. Any one of you, Professor Garth, or Professor Holloway, Professor Testi, would you like to say anything on this rising nationalism, populism, or the backlash against globalization, because of this feeling that it has only helped the elite and it kind of hasn't helped the working class? And what impact do you think it's going to have on legal education, and how should we respond to it?
Can I start? Well, go ahead, Brian. You go ahead, Brian.
You go ahead. No, I was just going to start with a sociological truism, in a way, that is for law to matter in any particular country, it has to adjust to the changing politics, or law will be marginal and will not be a player in the language of governance. And so inevitably, as there is a reaction to globalization, because this style of globalization with China rising, with nationalist movements everywhere, is going to be challenged. And we can't win that in the law schools. So in part, we're going to have to find ways, inevitably, whether we want to or not, to adjust and in a way tame it, legalize it, make it so that if there's nationalism and even authoritarianism, that it is rule where there are administrative rules, there are things that control it. And we've seen that happen in the past. So from my study of legal education for many years, I would say legal education will not lead the way, unfortunately, to preserve the things that we'd like to preserve.
I want to say I agree with Brian completely. I mean, law is the master of society, is the servant of society, not its master, at least in a society which really embraces the rule of law. But to me, I think that the challenges, the backlash against globalization, put another way, it's a cry for leadership. And the time we're living through now is a very, very trying time for leadership, because what we've seen, what has gone along with the rise of nationalism, is the rise of populism and a suspicion of expertise. It's one thing to be skeptical about elites who are elites simply because of who their parents were or how big their bank account is. But to be skeptical of someone who's, quote, elite because they happen to have spent many years studying in a university and have worked very hard, that I think is dangerous. I don't mean to hold the United States up as the archetype of this, but the fact that someone who was so consciously anti-intellectual as Donald Trump could be elected president, I think speaks volumes about the global challenges of leadership that we're facing. And he's not the only one. He's just the one that's closest, geographically to me. In Canada, we're already facing the consequences of this, and the current President Biden is in his own way just as nationalistic as President Trump was. And so a small country, I mean, Canada's very large geographically, but we're small demographically. We need trade. We need globalization. And we feel right now in Canada that we're fighting a losing tide against nationalism and insularity in the United States, and it's going to make both countries worse off. The unfortunate thing is we seem to be the only ones who feel it right now.
Yeah,
and I think it's a challenge for India too. But anyway, let Kelly speak. I don't want to go on too long.
No, Professor Holloway, you can complete your point.
Well, I think, the India, the Indian economic miracle. India is blessed because they have a large internal market. A massive internal market, and so they're buffered from some of the headwinds that a country like Canada faces and the rise of economic nationalism. But really, India's economic miracle was built on trade. And to carry that miracle to the next level means that India, needs trade as much as Canada does, and trades not just in goods but also trades in services. And that, as you will know better than me, Prabhash, that is a particular challenge facing the legal profession in India. There is a great resistance to opening up trade in legal services to the global world. I, for one, think it's an opportunity for Indian lawyers, not a threat, but I know that the Bar Council of India doesn't quite see it that way.
Yeah, absolutely. Professor Testi, would you like to share your views on this topic?
I wish I didn't agree with both Dean Garth and Dean Holloway, but I do. But I will say this, that there is one more aspect that's a little more hopeful, perhaps, and that is that I think the questions you've posed and also India's own leadership really do situate legal education at a time when it's more important than ever. It's more important than ever because of the suspicion Dean Holloway noted about proceeding based on evidence. It's more important than ever because of the rise of populism and the idea that whoever shouts the loudest wins. It's more important than ever because of the deep differences that we see everywhere. And law and legal education have a leadership opportunity to help people bridge those differences, to understand difference without being disagreeable, to find ways to bring people together, to find pathways to peace. And that's something that I think really is right now an even more urgent opportunity for legal education to step up and to provide the leadership that Dean Holloway noted.
Yeah, thank you. Thank you very much, Professor Testi. We have about 12 to 13 minutes left in this session, and we have some audience questions with us. I'll put this question to Professor Garth because one of the questions is on the issue of accessibility. And the question is as follows. Is there a way to implement a practical approach when we speak of increasing access to law schools in areas which are deprived of the benefits of globalization? Do you think this could be possible through the law schools, which already have a privileged access to the benefits of globalization? So I guess the question is about what are the practical steps that can be taken to ensure that there is a wider access to legal education? Professor Garth?
I think, the national law schools are moving into all kinds of different parts of India. So you have a sort of an outreach in that way. But for me, I would focus a little more attention on what can you do with the schools that are not the famous schools, and can you bring them in? We have a project called After the JD where we study lawyer careers in the United States, and we're writing a kind of a concluding book. And one of the conclusions that's kind of sad is if you don't go to a top law school, your career is one of accelerating decline in a way. That is because things don't build on each other in the same way that they do. Whereas if you happen to be someone who's got a really good education from your parents and you get into one of the top law schools, it's accelerating, right from the start, and it continues. And what I would like in my little idealism here is I would like some recognition in India, the US, and other places that the places where the disadvantaged are trying to make a career in law, which is an upward mobility career, ideally, are often in the schools that are not the hardest ones to get into, but are the schools that provide opportunity for those who don't have the advantages that they need to score well on tests, for example. So I think when you focus on the general access, you also focus on paying more attention, bringing them into the game, finding jobs, recognizing that there are talented people there who didn't get advantages.
Yes, absolutely. And if I may say that the democratization of the legal education could be one of the ways in which we increase
Yes.
access.
Now it's
Professor
completely
Holloway,
fake democratization.
yeah, yeah. Professor Holloway, there's a question on clinical legal education, a point that you emphasized, and the question is basically in two parts. Firstly, the question of emphasizing on the continuing legal education of practitioners or lawyers who are in the areas of in these areas which are important because of globalization. And second is on the question of continuing legal education for the faculty members themselves, people who teach these subjects in the law schools. What do you think would be the strategies in this regard? Do you think it would differ from practitioners to academics?
Well, I mean, it may differ in presentation, but it's similar in the sense that it's all about incentives. As law school deans, we have at least some ability to incentivize people to want to improve themselves and not to stagnate in career terms. I really do believe, though, that in terms of the practicing bar, the practicing profession, the incentives have to be sticks as much as carrots, maybe even sticks more than carrots, and which is why I talked about the bar council and the courts being critical partners in this. In terms of clinical legal education, I actually think that's a wonderful opportunity to do what I said I think is important, and that is to break down the dichotomy between theory and skills. But it's possible to do it in a way that helps one's community. The traditional model of clinical education we have in North America tends to be around legal aid clinics, and most law schools have them, and they're very important. But it's possible to provide, set up clinics to provide free legal services to small business people and entrepreneurs, to help immigrants, to provide some form of free legal assistance to people in family disputes who, in a perverse way, when they most need lawyers, it's when they can least afford it. I think that it's a golden opportunity to really improve legal education while making a real material difference for the better in our communities.
Thank you so much, Professor Holloway. We have a question on the issue of skilled human resources and the lack of it, and I'll turn to you, Professor Priskrina, because you talked about this and the problem and the fact that you have this problem in Russia as well. Now the question is that do you think the lack of skilled human resources could be one of the causes behind legal educations and law schools being elitist?
Could you please repeat the second part, because I didn't hear the second part of
sure. So the question is that is the lack of skilled human resources one of the causes behind legal educations and law schools being elitist?
Yes, I think so. That there is a close connection to that, and maybe there is no universal recipe or magic pill to that. We should aim to have as much skilled professionals as possible, but at the same time we need to take into account to kind of maintain a certain balance. So, for example, while integrating into the world educational space, we should also preserve the dignity of our own legal educational system and of our own law school.
Thank you so much, Professor Priskrina. We are almost at the end of the session, just a few minutes left, and I'll now give an opportunity to all of you to sort of present your concluding remarks or your concluding observations on this theme. And let me start in the reverse order. So let me first go to Professor Testi. Professor Testi, any concluding observations or remarks that you have?
Yes, and thank you. I've enjoyed the conversation and being with all of you, and want to thank you for that and wish you all well. I think the closing couple of remarks that I would have us think through is, first of all, to the last question that Professor Kaprskina answered. One of the answers could be the better use of collaboration through technology. And that's something that I think we haven't had time to talk a lot about, but I think that will present an opportunity that we should all take better advantage of. That doesn't mean there aren't impediments to it. I think so often, for instance, about the fact that in every law school in the United States, we teach 4 sections of the same course every year, and how much efficiency and how much lowered cost there would be if we did that differently. And we could, but there are real impediments to that because of the need for each school to be financially viable on its own. But I do hope that we can find ways to use technology to further collaboration, and that's something that I know is the subject of other panels and I think holds great promise.
Thank you. Professor Holloway, your concluding remarks.
Thank you, Prabhash. I think that one of the things that we could do much better at in law schools is telling the story of why law is important and why legal education is important. I mean, Bryant touched upon a couple aspects of this. But I think of India. I mean, if you look at how important lawyers were to the formation of India, you know, Gandhiji, Pandit Nehru, Sardar Patel, Dr. Ambedkar, they were all lawyers. Yet if you look at the image that lawyers have in the popular media in India, which reflects the image that many ordinary Indians have of lawyers, it's not very positive. And I think that, and perhaps this goes to my leadership point, that we, all of us involved in the legal profession, including those of us involved in legal education, have not paid as much attention as we may have to telling the story of law, to being leaders in telling the story of law.
Thank you, Professor Holloway. Professor Garth, concluding remarks.
Okay, I will try a little sociological point as a kind of concluding thing, which is there are fabulous global law schools like Jindal, Getúlio Vargas in Brazil, and what they've created really is, you know, something that's uniquely global. And one of the challenges of all these globalized law schools is, where do they exist in their own social world of the legal profession? And like in Brazil, the law professors there cannot challenge the rather conservative, in certain ways, dominant lawyers who are part-time professors, part-time lawyers, part-time business people, part-time politicians, part-time public intellectuals who, when they teach their courses, they just have assistants teach it in the same way they have forever. And I think one of the challenges of the national law schools and of Jindal is that the bar is very conservative and still goes to the government law college in Bombay, where there almost is no teaching. So part of the challenge is, how do these global pockets, you know, do they challenge, do they modify, do they, quote, modernize those who are in many ways at the top of the profession, but able to resist reform? And in India, the advocates and the judges control the global law schools, so they can resist change coming from there.
Yeah, absolutely. Professor Priskina, your final comments.
Yes, thank you very much, all colleagues, for great discussion today. I think that to conclude, we face a highly ambitious and important undertaking that requires concerted effort from all those who involved in shaping the future legal architecture of a global society. And we remember that the world is small legal world is even smaller, legal world with technology is even much more smaller, and we are all interconnected. Just yesterday, I had a telecom with Indo-Russian Chamber of Commerce and Industries about their upcoming visit to Vladivostok and about establishing a sea route from Chennai to Vladivostok, which will make a lot of legal questions, and we will have to deal with our legal specialists in that regard. Thank you.
Thank you very much. Thank you very much. It has been an absolutely fantastic discussion. I thoroughly enjoyed it and learned a lot. Globalization definitely presents several opportunities and challenges. And of course, we all have to keep working together in our own ways in different parts of the world to maximize the opportunities and to minimize the threats or to face them boldly. I thank all our four distinguished panelists for their excellent presentations and for answering all the questions. And I thank all the audience for being with us. Please stay connected for the next session, which is going to start right away after this session. And with these words, I close this session and I thank all of you once again. Thank you very much.
Thank you all. Thank you. It's
Thank
great
you all.
being with you
Dhanyavad.
on this
Phir
panel.
Thank you,
milenge.
everyone.
Fir milenge. A very good morning to everyone. My name is Karan Latyan, and I welcome you to the 18th session of the Global Law School Summit. In this session, the discussion would circle around the topic commercialization of law, modern trends in corporate law. As part of the panel, we have with us today 4 distinguished scholars who are going to reflect on this topic and share their perspectives on the various dimensions of corporate law. Our first panelist is Professor Michael Adams. He is the head of School of Law, University of New England, Australia. Our second panelist is Professor Geo Hans. He's the director, E.W. Barker Center for Law and Business, National University of Singapore. Our third panelist is Professor Dr. Brian Horrigan, Executive Dean, Faculty of Law, Monash University, Australia. And our last panelist is Professor Dr. Moroz Svetlana Pavlovna, Dean, Law School, Caspian University, Kazakhstan. Thank you so very much for being with us today. This session is going to run for 60 minutes, out of which our panelists would have a moderated discussion in a Q&A format for approximately 40 minutes. I have requested the panelists to restrict their responses to 3 to 4 minutes. And in the end, we would invite questions from the live audience for the panelists. I will briefly introduce the theme of this session, which would lay the foundation for the discussion to follow. Corporations are a relatively modern social innovation, but their global role in present times rivals that of national or local governments. Since the year 1600, when the English East India Company got chartered to operate as the world's first multinational corporation, corporations have proliferated across geographies and, backed by technological advancement, assumed gigantic sizes. No wonder the combined market capitalization of the world's top 50 companies measured 28% of the global GDP in 2020. Leapfrogging from just 4.7% in 1990. Over time, corporations have graduated from wielding just the fiscal influence, and their footprints can be noticed in all the aspects of the daily lives, including the corridors of political power. Their role also stands broader now, and apart from being seen as catalysts for world trade, technological innovations, and job creation, they have significant social responsibilities today. With the growth of the corporations and the complexity of the operations undertaken by them, the imperative of defending the interests of its shareholders and various stakeholders become the trigger for the emergence of commercial laws. Distinct from the existing civil laws, the new stream of such niche laws constitutes the response to the never-increasing challenges posed by the corporate space. Over the last few decades, aside from corporate law, we have seen the emergence of laws for specific fields like intellectual property, competition law, capital markets, and commercial arbitration, among others, symbolizing the resilience of the commercial law regime. In order to secure the best results from globalization, both soft laws and hard laws need comprehensive renovation, keeping in mind the diversity that the domestic laws exhibit. The corporate ecosystems globally have now potent regulators in place, both for company affairs as well as capital markets. Backed by strong domestic laws and regulations, these regulators are watchdogs to ensure effective corporate governance. Besides, institutional investors are increasingly championing shareholder activism in most countries. The consolidation of the corporate law regimes in various countries has also resulted in many positive developments in recent times. The emergence of trends like mandatory environmental, social, and governance, the ESG norms, and corporate climate disclosures, special purpose acquisition companies, and hedge fund activism continue to affect companies globally. The COVID-19 pandemic, the social justice movement have had far-reaching impacts on business and society around the world. In many ways, we are at an inflection point. corporate law trends vary across regions, but corporations globally are experiencing a reckoning around their role in the society. So without much ado, I'm going to start with my first question, which is that it is said that diversity drives innovation and enhances employee productivity. Why do most company boards still lack diversity? How does the status in developed and developing economies differ in this regard? And while gender diversity has been accorded legal recognition in many countries, is the time ripe for extending such legal status to racial and ethnic diversity in boards as well? I would like to start the discussion with Dr. Pavlona, and I would request you to share your thoughts on this topic, please.
I'm starting?
Yes, Dr. Pavlona.
Okay. Hello, everybody. When I answer all the first questions, I must to say about problem in our country. And I want to say that are no problems with racial or ethnic diversity in the composition of directors in the Republic of Kazakhstan, but certain gender problems still exist, since in general men are predominantly represented on the boards of directors of Kazakhstani companies. Kazakhstan has ratified a number of international conventions, including the Convention of the Elimination of All Forms of Discrimination Against Women, signed in New York on December 1979. But according to results, Kazakhstan of 2017 ranks 52nd among 144 countries in the gender gap index of the World Economic Forum. According to the indicator economic participation and opportunities of women, first place. According to the education attainment, 48th place, health index 36th place, political advancement 93rd place. We have adopted the law of the Republic of Kazakhstan, dated December 8, 29, on state guarantees of equal rights and equal opportunities for men and women. In accordance with this law, the state ensures the observance of equal partner relation between men and women in the legislative, executive, and judicial branches of state power, in local self-government bodies, but there are still problems because in leadership positions, in public authorities and management, as well as in private companies, men are predominantly present, whereas in the middle level such dominance is no longer observed.
Thank you, Dr. Pavlona. I can see that, the problem that Kazakhstan faces is quite similar to the Indian problem. And we also suffer greatly on the gender front when it comes to corporate boards. But moving on, because the problem is not just limited to gender diversity, but also the racial diversity, I would now request Dr. Horrigan to share his views on this question. Dr. Horrigan, over to you, please.
Thank you very much. Across the world, there probably is a lagging effect in both gender diversity and other forms of diversity. But with the rise of environmental, social and governance considerations, what we use as the shorthand of ESG, it's very hard to say that investors and institutional investors are looking at ESG, which will include notions of human rights, diversity and so on, and social and economic well-being, and say that's not a concern for a company and its own governance. So in responding to the rise of ESG, companies will need to confront the lagging effect. From a range of diversity viewpoint, It's not just gender diversity. And here we need to confront the issues about the best interests of a company, because there are matters to consider about the best interests of a company in terms of what perspectives do you need on a board and within the organisation to ensure that you've got access to the right perspectives that will open up opportunities. And the idea that a very narrow cross-section of the community sitting on a board or being employed by a company will give you the best possible results in the best interest of the company is an idea that needs to be tested, because the more interests that are represented that are genuinely meaningful in terms of helping to identify the interests of the company, then the more likely it is that you can seize opportunities, understand what different segments of the community require, and so on. And indeed, in terms of intercultural competence, being able to take a multinational corporation and operate in multiple sites of operation. So the issue of the categories of diversity must broaden, and we can have a discussion about what they are beyond gender and how they work, but we need to relate it also to, this is not just about having interests represented. There are public policy reasons why any country might want to have diversity of various kinds represented in companies and in their leadership, but it's also about making what's necessary to achieve the best interests. In terms of how you get there, there's a rise across the world of attempts to try to straddle the mandatory-voluntary dichotomy by introducing diversity requirements into comply or explain corporate governance requirements. Australia and other countries are moving in that direction. That is one way, not the only way, to get around this. We either leave it to a company or companies in a sector, or we mandate it. So that's one way to do it, where it becomes identified with corporate governance on a comply or explain. Either do it, or if you're not going to do it, explain why in your circumstances. That increases explanatory and public accountability. So that would be my take on the question of diversity.
That's absolutely important to understand that, if companies truly need to be a multinational, then it's not just being present with their corporate offices in those jurisdictions, but also to be connected to the ground. That's absolutely important for companies to realize that's true. But moving on to the Singapore, the jurisdiction of Singapore, Professor Hans, what would be your take on this question?
Thanks very much, Karan. I think I'll say something about diversity and productivity, because I think people think diversity means that you ignore meritocracy, and you're simply throwing a dart at the targeted group of people that you want. So if you use women, for example, in a society with 100 women, I mean, if you're not choosing very strictly using strict criteria, you could well end up with the 50th ranked woman. But I think it is properly managed diversity that creates meritocracy, as without it, you'll be scratching around for the 100th ranked man when the first and top ranked woman hasn't even been put on the board. So the status quo with only a certain kind of person in terms of gender, race, religion on the board is clearly anti-meritocratic, as you'll be getting weaker and weaker candidates, even if you try your best not to. So I guess that's the viewpoint that we have in Singapore, which, with Lee Kuan Yew has always looked at meritocracy quite strictly. I think it is a meritocratic argument to have diversity. Thanks.
Thank you, Professor Hans. And I'm fully aware that we have already heard a perspective from Australia, but that does not stop me from approaching Professor Adams with respect to his take on this question.
Well, thank you, Karen. Yes, a lot of the comments have been made. I mean, I think that probably the most important thing for me is the distinction between the gender question, which is clearly important. If you look at Norway and Sweden, where they have their 40% mandated, and the diversity question, that this is broader, those educational experiences, the racial background, ethnicity, age, all those factors. I think the research is actually quite overwhelming in terms of that diversity. Of course, they have to be high quality individuals, and that there is an onus, certainly on the larger corporations, to make sure that the executive training or the professional training, and certainly we know in the legal profession, the accounting profession, it is pretty well 50-50 at certainly the university level, but right through to partners in firms. But when we look at boards, it seems to be still a long way away from that. My issue is that we have tried targets in the UK, the 30% club and that type of concept, and they really are changing what I would refer to as a glacial speed. We are at a point where some form of affirmative action, some sort of encouragement, but I also completely agree with the quality question, but it's actually making the opportunities, the experiences, and also, I guess, the showcasing of exemplars, people who are outstanding, to give those opportunities. If you look in the public sector within Australia, so the government-owned corporations, they have actually provided much more diversity than still our listed boards. And the stock exchange governance principles now requires disclosure, which is, as Brian said, will help the debate along in that area. So I think we have a lot of work to do, but we are slowly moving in the right direction.
Thank you, Professor Adams. So this is true that the debate, that is centered around whether we need to prioritize diversity over quality or quality over diversity. I think it's going to go on. But in my opinion, I think both of these objectives need to be simultaneously. The endeavor should be to achieve them together. And it's true because in India, I remember sometime back a law was passed that in a public listed company, there needs to be one female director appointed to the board of the company. So, but how far we have come with respect to that, we don't have any credible research to demonstrate, but definitely that was a welcome step in that direction. Well, moving on to the second question. So the second question that I would like to ask my panelists is on the recent, the pandemic and the situation that has got created because of it. So calamities test the resilience of corporations. As corporations adapted to life in the virtual environment, many began exploring how to permanently leverage the associated efficiencies post-pandemic. Though forced by circumstances, what has been the impact of the virtual annual general meetings and board meetings on the efficiency of the companies? Have virtual annual general meetings improved shareholders' participation? Should the law evolve in order to allow for virtual meetings to be convened in the post-pandemic world as well? And to begin the discussion on this question, I would request Professor Adams to take the lead.
Oh, thank you, Karen. I think this is a really interesting question to ask because there's no doubt that we have seen such an acceleration of technology over the last 2 years, predominantly due to COVID. We are here using Zoom. You're probably aware in 2019, Zoom had about 30 million users. It was one of many products. It now has 300 million users. You'll probably remember during 2020 how literally every day there'll be an update as they would redesign everything from the leave button to the way they record to security. Now, there are other competitors, but actually it is interesting how Zoom has sort of, in a way, de facto become the default with a little bit of MS Teams and, as I said, Google Hangouts and those other products. When it came to the corporations, and I'll speak from an Australian perspective, but I think it has been replicated, the governments sort of use a bit of a knee-jerk reaction. We knew you couldn't meet in person. COVID just made the pandemic too difficult. Travel was restricted. So they had to allow, in short term, the use of virtual meetings. The other area of practice, of course, is executing of documents. There was no ability to do a wet ink signature across multi-contracts, so they had to come up with other forms. And in Australia, we used our delegated legislation from our federal legislation to allow that to happen, and the various states mirrored those laws. Well, I must admit, as an academic involved in this area for 30 years, I actually jumped into the debate and said, why don't we make this permanent? Yes, we're taking a step forward, but this is the time to actually amend our legislation to come into the 21st century. And that now has actually finally happened. We've taken many of those emergency regulations to cover a situation and make it as a normal business. Your second part of your question is not just around the technology and the short term. It's like where is the post-COVID norm, if there's such a thing? Well, I think what it has shown is that we want to use our time efficiently and effectively. When I run a meeting, one of the great things, and I see we're not using it here, but is the live transcript. So in other words, we could have closed captions for all our words, which immediately creates a word file. Well, if you're taking minutes, that's fantastic, as well as obviously recording the record. I also think it tones some of the behaviour. Whereas in a live meeting, a shareholder might stand up and shout and scream and behave actually quite inappropriately. The recording in a permanent form sort of tones that down to some extent. It also enables the chat type function to record good questions which management can then go away and investigate where appropriately. So I actually think it opens up a wider audience. It is appropriate, and I would imagine, and again, maybe we all work in universities, the hybrid model where you will have some face-to-face people in an appropriate venue, but then having other stakeholders, other shareholders able to use this sort of form will actually make it more interactive, and I think we will see greater engagement as we go forward. It is not a perfect solution, but it's actually a big step forward. They're my initial thoughts.
Absolutely, Professor Adams, and I agree with this point of view. But I remember the law as it is in India. In the board meetings, there are certain matters that cannot be just discussed over audio-visual linkages, and for that, physical meetings are required to be convened. Though these norms were relaxed for the COVID pandemic, but I don't know going forward whether these relaxations will become more permanent. But moving on to Singapore, Singapore is not just a corporate hub, but it's also a preferred jurisdiction for arbitration. So more than annual general meetings, the live proceedings in arbitration cases must have also transferred online. So what would be your take, Professor Hans, on this issue?
Thanks, Karan. I'm not an expert in arbitration at all, but I was involved in some litigation involving a business trust where we appeared as experts before the Delaware courts earlier this year. I think, for these things, it works perfectly fine. Whenever you have a small setting and you're talking about a couple of people speaking, and even with litigators around. The problem is when it comes to voting on a large scale, and this is where I think India is actually way ahead of Singapore, because you've had postal voting and now actual online voting for a long time. We, on the other hand, have, as with Australia, we've passed emergency legislation allowing this. But what we are seeing is that technology is being used for the meetings themselves. But in terms of the AGMs of the large listed companies, they're still not using it for the votes themselves. So it's the same problem that we have with Zoom teaching. That works fine, but we're not so sure with online exams, for example, because you're worried about the cheating and the cooperation and so on. One thing I would say, though, is that I think the Companies Act should always be drafted in a way that is technologically neutral, because we are going through the process of relooking at our act again. And there's always a danger that you prescribe things too strictly and then you can't, the practitioners can't innovate, right? So we should actually allow the company's corporate constitution or articles to develop technology-wise instead of waiting for the statute to always be changed. And where the statute itself is concerned, the UK Companies Act is quite remarkable, because I think Michael talked about the Australian Act as well. It's quite remarkable that you can change the Act itself, some parts of it, with subsidiary legislation without actually having to go through Parliament. So I think for things like technology, that's something that we should really think about instead of having to change the Act all the time. Thanks.
Thank you, Professor Hans. Dr. Poblana, I would request you to share your perspective from Kazakhstan on this issue.
Thank you. We believe that virtual annual general meetings of shareholders are an essential requirement of our time. Currently, they are effective and a successful way to manage the company's activities. But there is one problem: if absentee meetings of shareholders are retained, that the virtual meetings are unlikely to receive proper distribution. Thank you.
Thank you, Dr. Poblana. So technology, definitely, it's a requirement in law that, the law should evolve around technology and make most use of it. But the next question is kind of going to change the direction of this whole discussion, because from the pros of technology, we're moving to the demerits of technology, which is climate change. And my next question is dealing with that. So corporate responsibility for managing climate change as a long-term financial risk has gained traction all over the world, be it the Biden administration's rejoining the Paris Agreement or on its very first day in office on behalf or half of the UK's largest businesses taking carbon net zero pledge at the recently concluded climate change conference. The pressure is real. The goals announced by a corporation, even if profitable in the long run, may be costly in the shorter term, and corporations face pressure to defect from their pledges. How do we ensure that companies keep up to such promises? And I would request Dr. Horrigan to break the ice with respect to this question.
Thank you, Karan. There's in asking the end question that you asked us, which is, well, how do we ensure? What are the drivers? There's at least two. One is the investment pressure. So climate change is clearly bang smack in the middle of environmental, social and governance concerns. And the more we have tools and analysts and institutional investors and individual investors and labour-oriented investors and others who are interested in climate change as an aspect of ESG, then we get the business and economic and investment pressure. The second lever is obviously law. There have been some recent innovations in Australia on a couple of levels. One is to go back to our corporate governance standards, which are all companies that are listed companies must comply or explain why they're not complying. Climate change is clearly an aspect of managing and disclosing risk. Secondly, there have been some innovative published legal opinions that others might want to look at. That's in terms of a body called the Centre for Policy Development, commissioned some legal opinions by a couple of leading lawyers, and they've produced 3 opinions now, which basically say managing climate change risk and making climate change disclosures is a matter of corporate law. If companies and boards don't get the management of risk right, and if they don't get the disclosure aspects right, including disclosing or making misrepresentations about what they're going to do after COP26 in terms of setting targets about net zero emissions and so on. If you get that wrong as a board, legally, you may have a problem in terms of directors' duties. If your jurisdiction has a business judgment rule, you might be disentitled from relying upon it, and you might face other liability for what's commonly now called greenwashing about climate change and other disclosures. In my view, the reasoning in those opinions, and they're publicly available on the internet from the Centre for Policy Development's website, in my opinion, the reasoning in those opinions, notwithstanding the different ways in which directors' duties and business judgments are formulated in other jurisdictions, that reasoning is not confined to Australia. So I would put forward the pressure from the investment and financial side and the way in which this is now very clearly part of corporate law and managing and disclosing climate change related risks.
Thank you, Dr. Horrigan. So I would quickly invite Professor Hans also to share his perspective on how environmental norms and climate change is a real consideration for corporations across the world, especially in Singapore.
Thanks again, Karan. As you know, clearly Australia is leading the world in a lot of things with respect to directors' duties and climate change and so on. And some of what they're doing has actually come into Singapore. And one of my colleagues, Ernest Lim, who's written a CUP book on sustainability and corporate mechanisms, is working with certain Australian and UK NGOs where they're looking at being more nuanced with directors' duties and trying to make some of these ideals more enforceable. So he's examining what it means to really act in the best interest of the company. And his arguments would be that that takes into account the environment as well. However, some of us believe that it is not, you can't just rely on the best interest of the company alone, because it is difficult to remove ideas of shareholder primacy from that. And so some help must come from other directors' duties, one of which is the proper purpose rule, and that requires companies to act fairly and constitutionally. And that could form the backbone or help in forming the backbone of this whole corporate purpose concept that we see now, which I think without some form of sustainable directors' duties will not work. Now, what do I mean by sustainable directors' duties? That means that directors' duties must be clear and varied in themselves. Derivative actions should be used to sue for corporate wrongs rather than using open-ended oppression litigation. And so it's necessary for us to actually have cases that come to court where we work out the details of these things. And that way will help build rules rather than use of some kind of uncertain discretion, which I think many third world countries are still at when you look at things like oppression and unfair prejudicial conduct. So I think it is about going back to looking at directors' duties in more detail. Thanks.
Well, it's actually quite correct to say that, you know, when such responsibilities are to be placed on the corporations, the directors' duties need to be chalked out quite clearly. And this is one problem that plagued the Indian jurisdiction until 2013, because the Indian corporate law did not have any particular statutory provision listing out these duties, and we always relied on the common law interpretation of the directors' duties. But even with the new law, which lists certain duties, we always feel that, you know, directors have a little more obligation than what is stated in the statute book. So, Professor Adams, what would be your opinion on this issue?
Yeah, thank you. I'm going to probably follow on from my Dean colleague, Brian Horrigan, in the sense of the greenwash angle. In fact, I've just recently written an article which was published and it's getting quite a lot of readership because of the Volkswagen scandal. I'm sure many of the people watching will be well aware that Volkswagen, when it was being measured for pollution emissions out of its vehicles, basically had software running that when the governments around the world were doing testing, it would give one result, but in real world usage, basically about twice the amount of pollution was occurring. Well, the High Court of Australia, which of course is our final court of appeal, has actually just rejected an opportunity to go in front of the court to accept $125 million, that is Australian dollars, fine, which is the largest ever imposed in this area. And basically I wrote that I believe this sent a very strong message to corporations in the way they must use both climate change information and obviously in that broader environmental type things. Now that doesn't solve all the issues, but I think it really does send out a message. Our regulator, the Australian Competition and Consumer Commission, the ACCC, in winning this case really have shown their powers and their willingness. Now, the fine, if you look in dollars, is much less than was paid in the US or in the EU, but of course that's around the scale and vehicles, etc. But I think it really is a bit of a turning point to say some of these issues, corporations have taken liberties in taking things which are damaging to the environment and turning them as if it's really good. And of course, the flip side of this is how can we encourage innovation? What can we do? And in fact, I have a PhD student looking at intellectual property and a way of encouraging sharing IP on environmental benefits to help climate change to achieve. So I think there's rather than just a carbon trading market, which is obviously one mechanism, but there are other ways to solve this problem. So I think in the next few years, we will see some very interesting dynamic changes across our jurisdiction.
Definitely, and I feel that, you know, till the time considerations like climate change and environmental protection remain limited to the financial scheme of things, the dichotomy of whether to invest money into such innovations on a regular basis or pay a fine, like, you know, once it becomes due. I mean, this has always remained, but I feel that, you know, keeping these considerations more in the moral realm, like, you know, holding the corporations morally responsible for such innovations, I think would have a far-reaching like, you know, implication. But moving on, and then the next question is quite linked to this question, and in fact, it's an extension of this question. India introduced recently a mandatory CSR regime for companies in the 2013. Many other jurisdictions have also implemented similar norms on a comply and or explain basis. Should other countries also emulate this move in their respective jurisdictions? Or can such a move usher in the desired responsible capitalism regime? So I would start with Dr. Pavlona with respect to this question as to, you know, how a CSR regime is looked at in Kazakhstan specifically.
The performance of obligation, but corporation, especially foreign ones, can be guaranteed only by including appropriate conditions in contracts. If the contract stipulates means of security for performance of environmental and other similar obligations, then despite the disadvantage for companies, the companies will have to perform them in order to avoid responsibility for their non-performance. Thank you.
Thank you, Dr. Pavana. So this has always been a little confusing for me, because I have always been a supporter of CSR, being more of basically a voluntary regime than a mandatory one. And I always believe in the school of thought that, when these when these activities happen on their own and the corporations really want to do it, they generate like a bigger and a better result. But we also understand that corporations mostly are profit-driven, they're associations, and sometimes CSR takes a backseat. So implementing it through the legal mandate becomes the only option available to the governments. But what would be your take on this, Dr. Horrigan, with respect to CSR and its mandatory nature?
The mandatory nature of it, or the voluntary nature, or any compromise between that, again, needs to be considered against these notions of responsible capitalism, stakeholder capitalism, compassionate capitalism. They're all attempts to try to soften the nature of capitalism, to soften the harsher impacts that are seen from short-termism when it comes to companies pursuing a short-term focus upon shareholder interests, perhaps at the expense of other interests. We need to recognise that these strategies are, first of all, path dependent, in the sense that there can be historical and social and economic conditions that need to be taken into account, country by country, that make it more or less palatable and necessary to do this in India versus Australia versus elsewhere. So we always must recognise that there is no one-size-fits-all global solution here. It must properly respect local political, business, culture, social culture, and other conditions. But I will say this, again, we're in the realm of investor-developed trends and tools and law. In terms of investors, corporate social responsibility, like environmental, social, and governance considerations, is now becoming mainstream in the ways we've discussed today in corporate governance and as part of a company's DNA. So whether you take the Indian solution or another solution, the idea is not to have it as an add-on, but to have it dealt with by a company's corporate governance arrangements and its approach, its purpose, and it's in the DNA, from the board throughout the rest of the company, opportunities, risks, and so on. From the legal point of view, and from the regulatory point of view, again, there are ways in which other forms and standards of regulation can help. So again, in many countries, to say that, for example, it's part of the corporate governance arrangements. If you want to be listed on the securities exchange, you have to do this. And if you're not going to do this, explain why it doesn't apply to you. But again, for example, in the Australian context of the corporate governance requirements for listed companies, matters of diversity, climate change, disclosure and management of social and environmental risk, corporate social responsibility and ESG are implicated in those matters. So whether we talk about investor concerns and how investors will look at a company's social license and its legal license and its economic license to operate, or whether we're looking at the legal framework within which company purposes and directors' duties and other regulatory standards kick in, like corporate governance requirements, I would argue that from all of those angles, corporate social responsibility is mainstreamed and is an absolutely vital way of ensuring that companies are being strategic and legally compliant and socially responsible in their approach to these matters.
True, very true, Dr. Horrigan. Thank you so much. So it's actually quite fascinating to see how corporate law has evolved and the objectives of companies have expanded from just catering to shareholders to now also catering to stakeholders, and the definition of stakeholders is ever increasing. But Professor Hans, I would like to take your opinion on this. How do you feel that this social audit of companies is imperative to achieve better CSR objectives?
Yeah, well, most of us are academics here, so I guess we are on a certain spectrum anyway, in terms of how we believe in ideals and how important they are. But the problem with something like CSR is I don't know how you can make it more enforceable. And I was just talking to a businessman yesterday who said that he has tried to do good by his employees in the last 2 years. He's kept them on. And what's happened now is that his competitors, who basically sacked most of the employees a year and a half ago when COVID hit, is now offering 20% more because they didn't have the costs for the last 1.5 years in keeping the employees there. So the problem with CSR is that we're assuming that investors, the other stakeholders, employees, are all in a sense, unfortunately, they're acting rationally by looking for a job that pays them more now. And they're not going to remember the last 1.5 years where they were paid for doing very little work. So I would say that the law has its limits. I think the problem is more with the economic systems that we have in the world, because there is no competition now for a form of capitalism in a sense. And that becomes more extreme as vested interests take hold without any countervailing voices. So capitalism is great when there is a realistic challenge to capitalism, as there was in the 50s to 80s. But as Robert Schiller says today, it has become merciless capitalism and has led to the inequalities we see today. And we're trying to address all of these things with CSR. But I think the point about governments is that they should always aim to take the middle and play off extreme ideologies against each other, both on the left and the right. I don't know if that helps in answering the question. No, thanks.
No, but this further highlights the point that whether CSR should be more. I think as Dr. Horrigan said, that it needs to be integrated into the DNA of the company. And how do you integrate that? By checking a box on a form that you have fulfilled the CSR responsibilities, or by actually believing in it. So the debate would be everlasting on this point until a solution is reached. But this brings me to the last question for the session, and this is the last moderated question. And the question is that shareholders' empowerment and investor engagement are the hallmarks of corporate governance. What are the impediments faced by majority shareholders in countries where concentrated shareholding structures are found? Are the laws in such countries robust enough to extend protection to minority shareholders? And I would request Professor Adams to take the lead with this one.
Thank you, Karan, for that. If I may, I actually have one insight I wanted to say. When I think of CSR and ESG, and then I will swing back to this question, I tend to think of the CSR aspect, and this piece on what Professor Horrigan was saying, is very much from the corporation's perspective. In other words, being a good corporate citizen in the context of their leadership, the board's decisions. ESG is very much from the investor end of the telescope, looking in to say, do I want to invest in the long term in things which will not do harm to the planet or those other factors? So it's a nice conceptual way of seeing the two sides of a coin, based on a similarity but quite different. The other interesting factor, of course, is to take into account globally that if you think about it, for the last 50 years, probably longer, the major global companies have been oil companies, fuel companies, stuff that we know that has done damage but has also enabled economic development. At this point in history, our two largest global companies are Apple and Microsoft, and in the last 10 years, Apple was already a big company at $1 trillion. It is now worth $2 trillion, but in fact, Microsoft is now worth over $4 trillion. So that reliance on software doesn't have the same impact as others. Anyway, that was some considerations. Now let's swing back to the other factor, which is the question around that shareholder concentration. One of the big issues in particularly common law jurisdictions, I think, and where we have things like statutory derivative actions, is often in the textbooks, in the proceedings, it all looks fairly straightforward. In reality, we know it's often the procedures and the cost orders that are actually the downfall. In other words, the minority group bringing an action against the resources of the company and a majority directors often are required to obviously to give an underwriting in respect of the cost of litigation. So in fact, one side often has insurance, the other side has to fund it themselves, and that can be a huge deterrent. Obviously, in some jurisdictions, you do have litigation funders who are willing to take a reasonably big slice to underwrite that legal actions. In other jurisdictions, that's not allowed. So I don't think the law quite has addressed in any of our jurisdictions that particular fundamental problem. But the other side of that, of course, is shareholder activism, which does not use those traditional legal processes and are much more likely to use social media and other campaigns, including obviously hurting customers and clients by making people feel uncomfortable around certain areas. And we have certainly seen that in Australia in a whole range of areas. So there are some tensions in this particular topic, and I don't think we have yet resolved them for the 21st century.
Right. So thank you so much, Professor Adams, for that. And I feel, your comment that, these questions have not been resolved is quite true, especially from the Indian perspective, because recently we saw the biggest corporate battle that India has ever seen between Ratan Tata on one hand and Cyrus Mistry on the other. And that was a classic minority and majority shareholder tussle that laid the foundation for better oppression and mismanagement laws. But moving on to Kazakhstan, Dr. Pavlona, what do you feel about this minority shareholder issue, and how is Kazakhstan developing its law to better deal with these issues?
Since the law of the Republic of Kazakhstan dated February 1927 on amendments and additions to certain legislative acts of the Republic of Kazakhstan on the protection on rights of minority investors, minority shareholders have received proper legal protection. First of all, major and minority shareholders were clearly separated. The major shareholders included a shareholder or several shareholders acting on the basis of an agreement concluded between them, who own 10 or more % of the voting shares of the joint stock company. Minority shareholders is a shareholder who owns less than 10% of the voting shares of joint stock companies. Despite the fact that minority shareholders have less powers than majority shareholders, they have enough opportunities to protect their rights and legitimate interests. Thank you.
Thank you. Thank you, Dr. Pavlona. And then this brings me to a very important point. So especially in India, we see that, for minority shareholders to proceed against the misadministration of the majority shareholders, you need to breach a bare minimum of 10% shareholding to be able to even stand before the court and agitate your concerns. So how do you feel, Professor Hans? Are similar measures in place in Singapore as well, or does the Singaporean law have a different take on this issue?
Thanks, Karan. So just answering your question, no, we don't have any minimum shareholding requirement to bring a derivative action. And our statutory derivative action was actually probably the second in the world, following on from Canada, right? But there are countries like China, which also have these requirements that you need to have a minimum number of shares and you have to hold it for a certain amount of time before you can bring an action. So these are problems that you have to consider going forward. But following on from this story, it might just be that there are concerns with giving shareholders sometimes too much protection. And I just want to put this out there for us to think about, that in some countries, it might just be that they already have more protection today than creditors, right? So you've talked about there are oppression rules in private companies, which are largely against the family founders. Of course, the problem in listed companies is that you don't have oppression cases that usually can be brought. And we normally say that minorities should simply sell if they are unhappy. But they also have class action litigation, and that's growing in more and more countries, right? We're seeing more conditional fee arrangements. We're seeing more third-party litigation funders. So, I think shareholders and even minority shareholders are finding ways of bringing actions. And these are not derivative actions, right? These are shareholder actions where they bring in their own, for themselves in their own classes. And the thing with these class actions is that they may actually favor certain shareholders like hedge funds who sue at the expense of passive investors who do not sue. So therefore, I'd like us to really consider if in fact it's the minority or small creditors who actually need more protection today given the vast amounts of share buybacks and dividend payments that we're seeing around the world, we're still waiting for the UK Supreme Court's decision in BTI and Sequana to see whether creditors will be protected from these huge dividend payments that effectively ended up defrauding creditors, right? So Laporta, for example, says that US, Australia are very high in shareholder protection, but very low in creditor rights. And more countries, including Singapore, are moving that way because of the new restructuring rules that we have, which we are actually sort of eroding creditor rights somewhat. So with COVID, with financial difficulties, we have to ask ourselves, if we destabilize priority structures somewhat, will companies really have problems borrowing going forward? Thanks.
Thank you, Prasad. Dr. Horgan, your remarks on this issue, please. Thank you.
I could just add a slightly different take in terms of another thing to discuss that's relevant. When we talk about class actions and litigation funding and with shareholders, a couple of things that we have to confront as new realities. One is the movement towards dispute resolution in arbitration, including international arbitration, and the way in which those rules, even at the global level, are being changed to allow third parties and stakeholders to agitate interests in those kinds of dispute resolution processes. So that's relevant for countries, it's relevant for investors. The other thing would be that as we move into this realm of there being more protracted disputes that need resolution, of course, from a company point of view, we're talking about there could be shareholder disputes, there could be shareholder-stakeholder disputes, and the change of ownership and the categories of institutions and individuals holding shares and the different interests between different kinds of shareholders and the conflicts of interest there are again part of the complexity when we approach this issue now of, in light of the change of ownership, in light of dispute resolution being not just in courts, how do we deal with that? That it's not just about minority shareholder protection, and as my colleagues have indicated, that itself is sensitive to the state of the law and the particular path dependency trajectory of the corporate law in each of the jurisdictions. But there are these broader concerns that are part of the ecosystem that corporate law theory, corporate law regulation, and corporate law practice needs to now adjust to.
Thank you so much, Dr. Horgan. The first question that I have here with me is for Dr. Horgan. So I would not take your leave right now. So you are requested to answer an audience question, wherein the audience is asking that has it become difficult for corporations to cater to their contributions towards environment and climate change consideration, the financial or economic consequences they may have faced due to the pandemic?
So there will be a lot of worthwhile evidence-based analysis to look at different jurisdictions and look at those kinds of questions. The issue is companies and their boards are looking at this from a short-term and a long-term perspective. So there is an obvious need, and I think even in the way in which India has looked at where can your mandatory CSR spend be located, and can you count under the Indian law what you had to spend during the pandemic versus what you might have spent in other directions. There are those kinds of questions that will arise. But from both a short-term and a long-term point of view, obviously dealing with the pandemic and the costs within a company and the impact on its operations is clearly something that is consistent with ordinary corporate governance and CSR. And then taking the long-term view about the impacts of that and what it means for the future direction of the company, as well as the climate change stuff. All of those things are in scope, in my view, in looking at what should the company be focusing upon for the interests of its members, the interests of society, the interests of the future prosperity of the company, and so on.
Thank you, Dr. Horgan. The next question is for you, Professor Hans. The question is that how should a corporation strive to bring a practical balance between corporate visions and fulfilling the need for diversity within their corporation? Is it easy to derail from the organization's vision in order to fulfill the need to implement such diversity into their organization?
Well, thanks, Karan. I'm not sure it's a legal question. I mean, the part that's legal, I'll try to answer. But I guess the other thing about vision, I mean, all corporations now do this vision thing, and then they have their missions and so on. So that part is good to have. But how do you translate that into action where these things happen, right? I think that, firstly, I think Brian and Michael's been talking about a lot of disclosures and so on. These things are necessary, right? So even if you don't have real sanctions, the comply and explain allows people to make judgments on these companies, whether they follow or not, right? But I would say that more than that, I think we need to scientifically look at the need for diversity as a meritocratic thing. Because as I was saying, when we are down to the 100th man who's of the majority race in the country, he's not going to be very good compared to the top person who's a minority and so on. So there is something there that we have to start scouring the world again for the best people, for the best jobs. And I think the word diversity may be wrong, especially meritocracy, right? How can it be that you're down to your 100th man on the board when the first woman isn't still there?
I see. That's. I think that should answer the question. Thank you so much, Professor Hans. And the last question for this session from the audience is for you, Professor Adams. And the question is that what changes would you suggest in the field of international commercial laws and company laws in order to keep up with the new virtual or digital transition? Would these changes also ensure faster resolution of matters?
What a wonderful question, and I'm not sure I really have time to do it justice. I think I'd like to pick up on Professor Han's comment earlier around the benefits of technology and making sure that the laws surrounding them, both actual legislation and obviously the delegated legislation, is more technology neutral. I mean, as things have got faster and quicker, and again, we can each for our jurisdiction. It wasn't that long ago that we got excited about 10 megabits a second on the internet. My home has a standard, what we call the NBN, on 40 to 50. I walk into the university and I actually get 400 megabits a second. Now, at 400, you can do anything you want. It really, and we're not going to be that far away from 1,000 megabits a second. Now, that opens up moral questions around haves and have-nots, those with easy access to technology, the developing world, how can we support, even the use of satellites for technology. So there's some interesting aspects there. But I really do think the availability of information, in fact, I was recently giving a presentation for the 25th anniversary of the Coventry Law Journal, which I happen to be a visiting professor there, and we were looking at the impact of comparative legal scholarship. Now, coming out of the UK, they were looking at reflections around the EU law, and of course, because of Brexit, they're reevaluating a lot of that. But here we are across a number of jurisdictions. And when I first started as an academic, and I have to say my thesis was done on a typewriter, and we had microfiche, and of course now our students, when they're doing their PhDs, it's a click here and a click there. They can instantaneously translate documents. There is greater access. There's official sites giving us access to legislation and the latest case law. So I think there is actually a period of time, and particularly in the area of governance, if you're sitting on a board, so in Australia, the majority of the large companies, their headquarters will be in Sydney or Melbourne, to some extent in Perth, but when it comes down, it's really, and Sydney to Melbourne is about an hour and 20 flight time. And directors, prior to COVID, would be living in Sydney, go down to Melbourne for a board meeting, and they would say something along the lines of, oh, when I was at X company, which I'm on the board, we did this and that. And then there would be this very personalised cross-seeding of ideas and concepts and challenges across the legal divide. What we're now finding is that boards with good director training, and obviously we are educating lawyers in a particular way, that they won't just be looking at Sydney and Melbourne, they will be looking at best practice in Singapore, in Pakistan, in India, that the world becomes much more available. Now there's a time lag, and I think COVID has really shown the sharing of scientific information in a rapid way. I mean, I don't know about you, but the AstraZeneca vaccine in particular, 2 billion people have used it worldwide. That is more data than we've probably ever had on any medical treatment. And I know the lab that creates it in India is actually an absolute world-class facility, and we know that because of the other things they have done. In my generation, things like polio were a problem, and now we're having second onset polio. But again, the difference is the data, the information is now rapidly available. So I think laws are definitely being impacted by that transferring of technology and available of transparency of information. I hope that goes some way to answering part of that question.
I'm sure, Professor Adams. Thank you so much. I couldn't agree more with that. But this concludes our session, and I can't thank you all enough for sparing time and being available for this session. It was truly an enriching experience for me, and I'm sure our audience was also equally engaged in our discussion. I would just request our audience to stay tuned. We are going to start with our next session, which is a special dialogue on redefining the future of legal education, and the special dialogue will start shortly. Thank you so much, panelists, and thank you so much, audience, for being a part of this session. This is me signing off. Thank you so much.
Welcome back, everyone, to the Global Law School Summit organized by OP Jindal Global University. My name is Prateek Bhattacharya. I'm an Associate Dean and Associate Professor at Jindal Global Law School. In this session, this special dialogue 5, we will be discussing redefining the future of legal education, digital transformation, and virtual sustainability. I'd like to welcome our distinguished speakers, Mr. Falgun Kompali, who is the co-founder of UpGrad, and Professor Anand Prakash Mishra, who is an Associate Dean and Associate Professor at Jindal Global Law School, as well as the Director of Law Admissions. We are also waiting for Professor Vivekanandan, who's the Vice Chancellor of Hidayatullah National University, who will be joining us shortly. In the meantime, what we thought we would do is we just introduce the topic and just get the ball rolling on that topic discussion. So just to introduce what this particular session is about. We are of course now in a digital age, very clearly and very unarguably. And we are now more than 2 decades into the 21st century, and the marvels of new information and communication technologies, what's known as ICTs, have made our day-to-day lives increasingly connected and global. The knowledge and information of the world is literally available to us at the click of a button, and the technological revolution has become an indispensable part of postmodernism. Never before has education witnessed such a marked upheaval, with technology helping teachers push conventional boundaries to improve their students' learning outcomes to the best extent possible. ICTs have also been proven to facilitate positive results when they are used for conceptual understanding of the subject as opposed to mere memorization of content. In this rapidly changing landscape, it is imperative to address the importance of self-improvement through exploring new and innovative pedagogies in legal education to ensure that the coherence which ought to be galvanized by global legal studies is kept intact as universities transform themselves into the digital space. While the incidence of globalization has been characterized by historical discontinuity, legal studies must be resilient and protect their identity and heritage, without which common law doctrines such as stare decisis may struggle to survive. It therefore becomes the job of law schools to keep past practices linked to future expectations in a sustainable manner. This can be done by making use of blended modes of learning, such as the flipped classroom model, use of ICT tools to supplement the talk and chalk teaching learning method, and digitalization of library resources, with an aim to prepare law students for the globalizing world. The need for virtual sustainability of legal education goes hand in hand with the need of law schools to invest in capacity building of teachers for encouraging them to adapt their pedagogies to the 21st century classroom. The COVID-19 pandemic has accelerated this digital transformation of the law school classroom and underscored the redundancies of some of our practices, ideologies, and pedagogies. As even courts of law and law offices contemplate permanently shifting to a hybrid mode of work, conventional practices such as paper filing of court documents and in-person meetings or hearings may not continue. Moreover, the limitations that were previously imposed by distance and jurisdiction have been dispelled with, permitting flexibility to where legal professionals are based out of. In the same vein, global legal education should endeavor to take a page out of the COVID-19 playbook and complement face-to-face classroom activities with pedagogical and curriculum reforms that leaves behind the traditional unidirectional oral transmission of information that has engendered a climate of rote learning in India and demotivated degree earners, and an ICT-driven, learner-centric teaching learning environment would encourage students to engage in active and independent learning and also increase their access to global resources. And so with that, what I'd like to do is just to get the ball rolling, I'm going to just go into a Q&A format. My first question to Mr. Falgun Kompali is regarding generally, I suppose, education as well as legal education. Now, as legal education enters the digital space, how would you gauge the willingness of prospective students to welcome this digital transformation? Because, of course, there's legal education, but generally in education in India, there may be some degree of skepticism or hesitation, which is coming from the students, from prospective students. So, in your experience, have you witnessed such hesitation, such skepticism, and how willing are the students to adapt to a digital learning environment?
Sure, great. Thanks a lot, Professor Prateek. Pleasure to be here. To answer your question, I think in our experience of digital education over the last 7 years, One of the things we have observed is that initially there is always hesitation for people who are used to doing things a certain way. It could be the faculty, the universities, the learners, the corporates who hire students. All of them have certain hesitations. But I think there are two parts to it. The first part is there is a massive set of audience who are very eager and hungry to learn, but do not have access to this existing infrastructure. It's because they stay somewhere else, they cannot leave their job. There are multiple reasons, right? So this uptake and acceptance starts with people who do not have the option of full-time on-campus education. And they are saying that, okay, look, I don't have an option, so let me start with this particular strong value proposition that I have, which I can do in order to accelerate my career. So that's where it typically starts. And once we are able to deliver very strong experiences and outcomes for them, both in terms of learning outcomes and career outcomes, I think that's when the tide starts to shift, not just for them, but also for the traditional, more conservative learners who, as you said, might have had some hesitation. Because by then we would have created a strong word of mouth. We would have had enough advocacy built in, and they would have a lot of proof of concept in terms of learners doing this successfully online, getting outcomes. And that's where the hesitance starts breaking down for all the stakeholders involved. We have seen this happen multiple times with various programs that we've launched, where the hesitancy with parents, with hesitancy with students, hesitancy with universities, hesitancy with corporates, over time has melted down as we have started with this non-traditional set of learners, delivered strong outcomes for them, and we have used that proof of concept to go into more traditional spaces to ensure we can create more impact.
Great, thank you. And I completely agree. It takes time for us to get used to something which has changed. And once we're used to a particular mindset, you have to give it time for people to get familiar with a fresh mindset. But on the same point and to the same question, Professor Mishra, from as Director of Law Admissions, do you see in legal education particularly some kind of unwillingness or hesitancy among students to engage in new forms of education which is not out in the classroom?
So thank you so much, Professor Prateek, and such a nice input from Falgun. I will like to say when we are discussing redefining legal education, and particularly in a context when still COVID and related, I will say, virtual learning and online learning mode is on in the country. Digital learning is the future. If we are thinking about the future of not just legal education, but entire higher education, digital is the future. If we look at the legal profession as such, during COVID, both the High Courts and Supreme Court, I have data, 1.38 crore cases have been decided through virtual court hearings. And 1.38 crores is a large number. Out of that, 48 lakh were decided by the High Courts and 89 lakh by the district courts. So a lot of districts even, though the ratio is much smaller in the districts where most of, and you know our country, particularly the judicial system, our biggest problem is pendency of cases. So digital is the only way. When our lawyers are digital lawyers, our judges are digital judges, our courts are digital courts, and of course the legal education has to completely transform itself to become, I mean, of course, we cannot manage without brick and mortar institutions. Our law school campuses, the campus education is paramount, but the digital influx has to be increased substantially. It's not the time when we studied law. I joined my LLB in the year 2000. And of course, we started with a yahoo.com email account, and slowly we learned even typing on computers. It was quite new to use computers and laptops. Those were times of cyber cafes where you pay on hourly basis. And this 2021, I think it's time when our entire legal and higher education system should be transformed, and the digital component should substantially take over, and that will help us. That's the only way I see. If I look at over, say, 5 crore pending cases in Indian courts, and that to be resolved, if pendency of cases, those kind of bigger issues to be solved, it can be done only through the digital way. It cannot be done manually. It cannot be, humanly impossible to achieve that kind of judicial targets to dispose of cases. So this is a very apt topic when we think about redefining legal education. Technology and digital transformation of law schools is the way.
Thank you, Professor Mishra. And that's very true. If we want to be as efficient a legal system as possible, we do need to have both physical and some kind of online platforms for both learning and for practicing. And that's a good segue to my next question, which I'm going to first request Professor Mishra to respond to this first before gets to it. So, as we know, legal education tends to be very, I would say, for lack of a better word, dry. And because the mode of learning that we have grown up on is a unidirectional oral transmission of information. One person in a classroom, the lecturer or the professor just talking, and that's it. And maybe questions at the end of the class. And that kind of encourages rote learning, which is not the correct approach. So, Professor Mishra, do you believe that that we can now, that this same approach can be used even in an online format, in a virtual format, that we should, that same teaching practice can continue, or whether it's important to make use of ICTs, of communication and technology, of new digital tools to find new ways of teaching and learning?
So, Professor Prateek, COVID has taught us virtual learning, online learning, and online teaching in a hard way, but we have successfully mastered it almost. If we look at the Jindal Global Law School and University experience, our academic delivery in terms of classes, our examination, evaluation, submission of assignments, research papers, everything, almost 100% of academic delivery, as well as from a students and faculty point of view, has been done very successfully in an online format. So we can't, we can't reduce the importance of physical campus. Nothing can match that, and that is absolutely needed. But more and more digital component need to be added in our classrooms, and particularly when we are discussing global legal education cannot happen in brick and mortar campuses. Global legal education requires global interaction. It requires, scholars, academics, students from around the world interacting with each other. And that cannot be done on campuses. The travel could be limited. So digital is the key, how the global interactions, global engagement can happen in legal education in a big way. And we can globalize the way of learning of law, and in a way, the mission to produce not just law graduates capable for the domestic jurisdiction, but also lawyers who are actually global legal professional who can work successfully in any of the other jurisdictions with the same confidence and comfort.
Thank you, Professor Mishra. At this point, I'd like to welcome Professor Vivekanandan as our distinguished speaker to this session. Professor Vivekanandan, we were just discussing the point of how legal education traditionally is, it's a unilateral oral transmission of information with the professor doing all the talking and the students just listening and writing down notes. And whether that encourages rote learning, and what are the ways that we need to step out of that particular mindset. Just before I move to Falgun, Professor Vivekanandan, would you have any thoughts about how the traditional model of legal education in terms of oral transmission, whether that should be copy pasted into a digital learning platform, or whether we need to explore new pedagogies?
Due apologies for little getting delayed today to join your program. And thanks to digital, I could join even 5 minutes, 10 minutes late. I presume if you had a physical program, I would have been stuck in Raipur, would have now come. So that is one way of demonstrating the utility what we're talking about digital. I come to 2-3 quick questions. As you said, the very first point is the problem is looking that as a binary, that physical or digital. That is never there in life. It is both. The moment you started writing letters in the good old yellow postcard, we have transformed communication and connectivity in a different way. And it is again, referral point is pandemic. Yes, pandemic had a big crisis management, I agree. Pre-pandemic also, the biggest connectivity among different stakeholders, thanks to Mark Zuckerberg, right? There is a lot of connectivity happen. So the question, what I'm telling is, it is sudden a kind of, I would rather say it is not a very major issue to talk about digital, but at the same time, since it's a continuous process of digital for more than a year and a half, I would say more than students coming to campus, we really want students to be in campus, right? Because the teachers, in my opinion, frankly, enjoyed the first semester without students because they thought, they can do a lot of work, they're not pulled here and there. But now I see all my teachers telling, sir, let's reopen fast because they also want that connectivity. So in such case, we are only talking about how judiciously we have to do. And second, I agree with you that cut and paste you said, that was existing pre-digital era also. PowerPoints have been mostly what you call as, 10-year-old edition PowerPoints used to be done. Because when PowerPoints came and all this LCD became a norm about a decade back, it was again a big excitement for students because you could really connect what you're talking. Then what happens is, over a period of time, students even predicted what will be the PowerPoint because except for some comma changes and few things, it was not happening. And students also had one more thing, sir, can I get your PPT? I used to steadfastly refuse in my early days. I tell them, this PPT is not for you, it is for me, right? So that I don't start in a highway and get into a gully. And then I don't know how to come back also sometimes. And this is a problem of serious professors, that they will be totally out of track at times. So I said, my PPT tells me, this is my boundary, this is where I am. And also, I can take a recap when I come to the next class. A oral lecture, I can't really take a recap when I come next class. So I can even go back and tell this the last 2 slides, I put it and do that. So this problem existed before this digital platform in the sense, I call this is a live digital platform that was more what you call as a static digital work what we did. So naturally, it is a continuous innovation process that how people are going to really lose attention span in a digital thing, how to do that. And this many teachers do complain to me that they see a lot of squares with names and one doesn't know whether they are there or not, or whether they are reacting or not. So naturally, I tell, if you are doing these digital classes, you need every 5 minutes, pretend you don't know something and ask the students, right? Don't ask them a quiz and so they don't want to answer. You tell, I am a little confused here, do you have any view? You will suddenly see a lot of views coming from the other side and you will know that people are there. So nutshell, I would say that we are managing a huge crisis. Hopefully, things will be under control, even though they're talking another wave. At least the preparedness is very heavy. Tracing methods, hospitals, norms, many things are in place. That's why they feel even there could be another wave, the impact could be nowhere compared to what happened 1 year back. The world is, different parts have really geared up. But now, as the point is, presuming best case scenario, January things subside and everybody we start our regular classes, and then or it continues. There again, why you are talking digital from global education? Let me tell you, any person living in Bangalore will know, traveling from your home to a particular institute and lecturing and coming is almost like going to Singapore and coming. That is the kind of mess in many cities we are in. So naturally, it's not just global. Even I presume, my prediction is, within the campus itself, you will have a lot of clarification session, mentoring, many things is going to happen where they sit in the room, they're going to connect with you. That is going to happen within, I'm telling about 40, 50 acre campuses, the average campus of law schools. So the other one, what you said is going to be really fantastic. What you call as, in fact, you're going to have more inputs thanks to digital platform. You're going to get people who would be wary of traveling. There are very erudite professors who are little elderly who don't want to travel, but they all will be able to do. This is an important case. I remember 10 years back, with which I'll give it to the other panelists, around more than a decade or that, Mr. Lakshmi Kumaran came to Nalsar University. Fantastic 2-part lecture he gave. So students were clamoring. I was also telling, sir, why don't you be a honorary professor and then teach us? Because tax, is a weak link in any law school. Because in the sense, if you're a little smart, market takes you away, right? Except for maybe Jindal can pay, others cannot pay. So this is the situation we were in. But Lakshmi Kumaran said, I would love to spend 2 hours with you. But which 2 hours in a day you tell me from Delhi I can spend with you, right? I'm ready to do 8 to 10 night or 7 to 9. Please arrange video classes. I will certainly love almost 5 days in a week. I will engage pro bono. I don't need to pay me. I will come. This I'm talking approximately 15 years maybe. At that time, we know it's all infrastructure is not easy, video conference, the technologies were also thing. So now I met Mr. Lakshmi Kumaran for a meeting we organized. Then I asked him, you promised me, 15 years back, you will spend 2 hours. He said, Professor, 15 years back, my practice was not that great. Now my practice is quite a lot. I cannot spend 2 hours a day, he said. So why I'm bringing this humorously is this what you call as the very intelligent way of using this is going to augment many things. Probably we move faster thanks to the pandemic. And for that matter, I've been generally a critic of legal profession. They are generally having hesitation to be technology friendly. A typical lawyer has to have a lot of books at the back. Then only there is an image that is a lawyer, even though 100 times of the books can come into a palm top, but there is a perception issue that has been there for quite some time. But I do think the very younger generations are completely changing this notion. And so this debate is going to be some more time between, I call it quote unquote traditionalists, and then, what you call as the digital professors, right? But sooner or later, I think the traditionalists will, accept that this will be a reality sometime. And students definitely are postmodernist, I would call it, when it comes to, many of these digital platforms. So I really think it's going to do, and we are planning, even January reopening, we are planning few programs totally only online. Add-on, but that we are not going to compromise some foundation, other thing which is going to be physical, because I do believe that it's like universities are not just learning place. It is, I call it as socializing place, right? You socialize. That's your space to understand each other, to get into problems with each other, how to solve the problems. All that growth happens in the terrain called university, and imparting skills is one part of the story. There is another part of a worldview which you are getting in being part of university. So let's all hope. Thank you.
Thank you, Professor Vivekanandan. Those were the excellent points, and I completely agree on the disconnect. In the initial days, it was quite difficult teaching online, and you didn't know if students were understanding things until you saw their answer scripts, and then maybe you realized the disconnect then. I'd like to ask Falgun particularly on this line of thought about these a digital platform service provider. What kind of tools can we use in terms of education, particularly in legal education, which we can borrow, and as we move to this hybrid model that both Professor Vivekanandan and Professor Mishra discussed?
Okay, I think just to add to what Professor Vivekanandan and Professor Mishra said, I think our view is that eventually there will be three sets of audience. There will be a small set of audience who will want to come on campus. That's their preference. They can afford to do that, and they will continue to have that experience. There will be a large set of audience that will do online for better access, and that will be fully online. But we believe that there will be a significantly larger set of people who will have this blended experience, where even on campus, I would rather do some classes sitting in the hostel rather than come to class, because that's my way of engaging productively at this point of time. So I think we will need to enable that infrastructure, and the transition is not going to be easy for anybody. It's like e-commerce back in the day, 10 years back, when I was hesitant even to order a book online. Now I'm very comfortable ordering even a television online or clothes online, just because of the way the infrastructure and the entire thing has been built out. So I think that transition will take place, and I think it will just empower the faculty, the universities, and also a much larger set of students. Second, in terms of engagement, we do see it as a challenge that sometimes in these online classes, students are not engaged. But I think the first key aspect that we have seen is that it's all about how the faculty is driving the conversation. And we've shared these examples with all of our faculty, where we've said that, look, there are some people who do a brilliant job at it. It comes naturally to them in terms of, as Professor Vivekanand just mentioned, pausing, asking questions, engaging the audience. And it's a very different style. And if there are other faculty members who struggle with it, who might be better at engaging in the classroom, but again, they struggle to do it online, right? So there, I think one of the things that we are really working on to improve is provide faculty with much stronger feedback in terms of which set of students are engaging, how they are engaging, and where they are dropping off. This is typically hard to do in an offline classroom, where, for example, I went to IIT Delhi, and I can say that most of my classes were not great, right? I was not paying attention in most of my classes, in all honesty. I was also in the classroom, but I was sitting at the back, doodling or sleeping or doing something else or thinking of something else. So even in a classroom, sometimes the engagement is not fantastic. But the problem in the classroom is that the faculty never get that feedback. For us in the digital medium, what happens is we want to imagine the classroom as a classroom with a single student. And it's possible to do in the digital classroom, although there are 100 people, because you can, given the data that you have on that learner, we can figure out whether or not that learner is engaged based on when they join, when they drop off, is their video live, are they submitting their assignments on time, which questions they're getting wrong, how many minutes are they spending on the platform, how many times in a week they log in. So for example, even for the LLM program that we run, which is a duration program, we collect about 150,000 data points on the learner. Simple stuff like, does Professor Prateek like to study on the weekend or the weekday? Does Professor Mishra like to submit his assignments just in time, or does he do pre-work? So based on all of this, we can customize the experience for the learners and provide faculty with the feedback in order to develop their own style of teaching, which I think is a long process. But that's the process that we're trying to enable to make these classes more engaging. Obviously, the current technology that we have works to a certain extent in terms of Zoom, in terms of the tools that we have created ourselves. But again, there I think there is a long way to go in terms of coming up with more exciting ideas and exciting infrastructure to be able to deliver this much better.
Falgun, that's extremely helpful. And that actually brings me to the next question and link to the previous question. So of course, there are traditional modes of teaching in a classroom. And as you discussed, as you mentioned, that there are important things which digital platforms can provide us, such as data on what exactly the students, why they are nodding off in a class and not paying attention, and what is it that they're interested in. But are there certain tools, for example, can we use a flipped classroom model or breakout sessions Is that something which we can adapt to even a physical classroom? Do you think that makes sense? And or is there anything really in the traditional style of learning that can be retained, or do we just let that go completely and completely shift to a new style of learning?
That's for me, right?
Yes, yes, yes.
So I think we do see a lot of value in offline interaction. Right. So, for example, most of our programs have a blended component where the one-way delivery you spoke about, Professor Pratik, earlier, we think a lot of that one-way delivery can happen online, either live or in an asynchronous format. But when it comes, I think there is a lot of value, both social interaction value and also intellectual brainstorming value that can come out of sitting in a room with 4 people and discussing ideas without too much structure and somebody just guiding that conversation. And I think that's where we find that these interactions are very helpful. And we try to facilitate them and say that, look, in a regular course, our belief is that about, let's take a 2-year master's course in any campus, right? We believe about 80% of that can be effectively done online in terms of, as I said, either with live delivery or with asynchronous delivery. But there is that 10, 15, 20% component depending on the course and the pedagogy, where there is very strong value to doing things online, both in terms of driving student interaction and networks, and also faculty to student interaction. And most of this is about, as I said, one, challenging and learning from each other, which is a very important component of any educational experience. That is sometimes difficult to achieve online, at least with the current technology that we have. And second, having a more open-ended, unstructured, yet moderated conversation where you can let your mind run free and come up with ideas and then figure out how to take that forward in a more structured manner. I think those are the 2 elements where today online honestly does not do as good a job as what can happen before people sit in a room. And that's where we are currently running those experiences offline. But technology is evolving so fast. Recently, I was doing a demo of a VR company in the US where everybody can wear a VR headset and they can be in 10 different places, but at the same time feel like they're in a classroom. So all of those interactions also, as I said, the technology and the infrastructure will evolve. We see that it is very possible that in 5 to 10 years, the 100% experience can be virtual, given how these things are evolving. But for now, these are the few components which we believe offline works better in terms of driving value.
Thank you. That's very helpful. And yeah, I mean, virtual reality education would maybe be very interesting in the future. I'd like to ask Professor Mishra, just on, in terms of traditional classroom style teaching, if you had to, if there was one nagging point which in the traditional classroom which you would have preferred not to have been there back in your days in law school, what is it that we definitely need to let go of in terms of traditional classroom legal education?
So, Professor Pratik, that's a actually very interesting question, and it needs an honest answer. There is no way in a present or traditional scheme of things where there is a mandatory attendance requirement, physical attendance requirement put by Bar Council of India as per the legal education rules. And I will like to tell the audience and this panel, Professor Vivekanandan is a veteran, a stalwart, and he knows this. Our Bar Council rules, even today, it has not incorporated anything about virtual learning or online learning or online education in its system. So whatever legal education has to be imparted, it has to be imparted in the physical mode. And it's during the COVID time, the rules are actually created to enable law schools offering their courses and, So I'm talking about the LLB program, the bachelor's degree program. Now we need substantial, when our courts are making all those amendments, when the Court Fees Act has been amended in most of the states, and those where it is pending, the Supreme Court and of course the Judiciary has instructed in a way, the governments are in the process of amending the Court Fees Act. even the rules relating to e-filing. Supreme Court has even made e-Seva Kendra provisions at the High Court and District Court level. So this digital transformation is a must. We can't manage without it. And if we look at our times or the traditional model where I think the blended learning could be a great uh, enabler in terms of those drawbacks, those issues which we faced in pure traditional system. For example, attending a particular lecture which may not be as interesting, or a subject which is you may not be liking to focus as a student, and you may not be in a position to attend classes at a particular time due to some issue, and you want to attend that lecture later. There was no way available. But in blended learning format, if the lecture is available at the same time in an online format, you can attend it at your convenience, say in the night or any time. It's not mandatory that during that particular 5 or 6 hours during the day, you have to be present on campus to ensure your attendance is actually recorded so that you are enabled to take your LLB exams. So when we are discussing redefining the future of legal education, my view is transformation of legal education requires a lot of digital component, and it's certainly sustainable. The virtual learning, the digital learning is a sustainable mode for the whole country, not just for legal education, entire higher education, and particularly in law, in social sciences, in humanities, in the non-STEM, non-medicine areas where laboratories and something like physical involvement of individuals in labs and those things are not as mandatory requirement. And in future, our law schools have to train students not just for legal research and academic writing and reading and those things online, but even about e-filing, about virtual hearings, about virtual court system, about making them comfortable as a lawyer and legal professional in pure digital environment, because that is where is going to be the future of not just legal education, but legal profession.
Thank you, Professor Mishra. I think all students in the audience would completely agree on the relaxation of the attendance requirement. And not just the students, it's also the teachers, because we are, of course, required to take attendance, and it does become a bit of an administrative hassle. And on that point, moving to Professor Vivekanandan on building teachers' capabilities, do you, of course, there are the students who are more tech savvy, so to speak, and more ready to adapt to tools, to technology. But a lot of teachers, a lot of law school professors, particularly older ones, they find it very difficult to adapt. So, in terms of capacity building, how do you believe law schools can improve their teacher capacity building capabilities and essentially help the teachers teach better in a blended mode?
Let us say that I take it for not older in the sense people above 50, 60, there are very good teachers who are still contributing, heavily. I leave them out. They're very minuscule, and they have always some people with them. There are followers, teachers who sit, because we used to go to classes when some iconic constitutional teacher, few of us goes to hang around in the class. So they do have the help of others helping. But there's a middle range people whom I call that who are not early birds to technology. We did face certain issues in the beginning. For example, including not just digital transmission, about Turnitin, about many things. And we had some periodic workshops. At least 3 or 4 we conducted for, of course, my faculty's numbers are less. So we used to have a kind of training program where I involve much younger teachers who are, very much at ease. So I tell them to go sit with them, help to do. And in fact, we even contracted a lawyer come technician, in the sense technical guy who was part of HNLU alumni. He is now my consultant for my website and many things. He did some programs. We had not only that, we had peculiar programs like online submission. And then they say they submitted and we didn't get it here. And then we did some level of forensic investigation because I didn't simply want to allow a new type of fraudulent practice to start. So we do have tools. We went into there, asked them to open their PC, ask permission to give, and then check whether it really went out of their laptop. So that way we sent a message. Look, in the physical form of exam, you have invigilators hanging around. It's very easy. But in this type of online things, you have some different issues coming. So in the beginning, it was a little frustrating, but I would say that at least last one semester, I would say it's all solved in a very big way. And now teachers are comfortable. So what it means is we have to do some kind of quick, fast tracking these issues and do. And as you said, there's only a fear of the unknown. Once you tell them it's such a ease, it can be done. I have seen many, many teachers do that. And now I would say, earlier we were running around some outside design experts for posters. Now I find half a dozen teachers for their programs create really impressive posters. So how did you learn? They said, sir, we had some websites. We are now part of Poster My Wall and we keep doing this. So as you said that it's a matter of just crossing that small fear barrier and suddenly they will see there is a lovely world of technology that side and which they can use. And so I don't think so it's an insurmountable problem, but we need to keep some periodic, what you call as training or hand-holding, which I think people will easily cross over.
Thank you, Professor Vivekanandan. That's a very that actually takes me to, of course, the fact that what you discussed, that there are so many options which are available suddenly for a teacher, so many tools to use. And that also ties into my next question, which is that, which I'll request Falgun to answer first. With regard to education and education technology service providers, over the last few years, so many have mushroomed. There are so many platforms of LMS, of learning management systems across the world. And is there any consistency which you see is being followed by each of these platforms in terms of imparting education? Or if there isn't, is there a need for consistency? Or is it better that that universities and teachers get to pick and choose what they want?
So Professor Pratik, I think the way we see it is that there are some standard features that come with any LMS, right? And those I think are consistent and standard pretty much across any LMS that you would use. But I think given the way this has spiked over the last 24 months because of COVID and the usage, there are a lot of learnings for all of us to implement and innovate in terms of how these LMSs can perform and the kind of flexibility that it can give faculty and universities. So let me just give you an example, right? One of our partners and the faculty came up and said that, look, typically in a class, I do a cold call, right? So I just say that, look, I spot this one student in the class and I ask him a question and he has to answer it in 30 seconds. So this is generally a pedagogical tool I use to engage my students better. Now, can we do this online? This would not be a standard feature in most LMSs. But then we said, look, is it helpful? If it does help, then we will build it into our LMS as part of one of the features. Similarly, there are, for example, when students are doing a technology or a data course. Now, a lot of times, some of the LMSs do not allow students to code on the platform seamlessly. They have to go to another console and they have to code. And then it's two different platforms. So it's a kind of a disparate experience. So now we have said, let's invest in creating something that is integrated so that the whole experience is end-to-end seamless, the data collection and the learnings from that can be integrated. So we see that we have a full 100 people technology team that is constantly just working on getting feedback from our faculty and university partners and saying, how can we improvise on making this LMS better and efficient every day, so that, as I said, as technology evolves, we are able to provide the kind of support that will ensure that the quality of this learning and the interactivity and experience of this learning is as good as on campus or even better moving forward. So I think it's a constant evolutionary journey. It's just still very early days. So I think while there will be some basic consistent features, on top of that, I think almost everybody is trying to innovate to see how we can provide more tools and flexibility to faculty and universities and give them the comfort that, look, we are not shoeboxed into forcefully using something, but we have the freedom to say that, look, this is what I am comfortable doing. This is how I'm comfortable teaching. Can I do this on this platform? So I think it'll keep evolving. And I think it's going to be a fairly fast-paced evolution for the next few years.
Thank you. So those are some excellent points, and I'm sure it's of course a very competitive landscape in the education technology industry. And one of the reasons, as you correctly pointed out, is there is huge scope for hybrid learning to become better than traditional classroom learning, because physical classrooms do have their limitations. And on that point, what I wanted to, I'm going to direct this next question to Professor Mishra, and then it can be answered by everyone else. Do you see any kind of pushback from students in terms of they are now too comfortable with sitting at home, maybe because of health reasons or otherwise, but they're a little too comfortable with the availability of options that has come with hybrid learning, and they might not want to come back to the physical classroom?
So here I will go with what Professor Vivekanandan said, that the first semester of due to COVID was fine for the faculty and for the student both. But now nobody wants to be in the same online situation. Everybody wants to come to the campus. And I mean, I completely agree that the university campuses are not just the place of learning, but also socializing, or whatever better word you use, the peer learning and learning from the environment, and in a way, holistic development of an individual can be done only on a campus and not purely through online learning. So this blended mode, I believe, is the future. Blended mode means the technology, and there has to be a balance to be created. We can't allow the students to, for that matter, if there are, possibilities to take, say, all the lectures virtually, or all the lectures compulsorily in the physical classroom. It has to be a mix. It has to be a very judicious mix, which is actually making things better for both the faculty and the student.
Thank you, Professor Mishra. Professor Vivekanandan, you've been an educator for decades. Would you believe that this hybrid learning is possible in legal education, particularly given the unique nature of how law is and how text heavy it is?
Yeah, I would say, is it possible in legal education? The question should be around, it's only in legal education it's possible compared to science or technology, because that has an entirely different physical component. Here, what the lawyers, would-be lawyers miss is about the whole dynamics of, moving with others, what do you call us, picking up the arguments, putting it, that they may miss. But when you say the education quotient, it's quite easy for legal education to do this. So coming back to the point, the students themselves, very interesting, when we said we will open up in between, they said we will come, we will do online class sitting from hostel, right? And then I said, that's okay, no problem, because classrooms you have to give social distance. That is not feasible because classrooms are made for X number of people. But then we did open up, but did not come, because then I realized we condition what we put is, once you come to campus, you cannot go out even once, right? They thought that is not possible. At least at home, they can go out and come. And coming back to this space, what I keep telling people is most of the average Indian student lives in a 1000 SFT, 1200 SFT space with the entire family. They love the family, all that. But that is not the space when you compare to a campus. A campus is as a different mind space, I call it. It is a mind space which is not feasible at home. So all of us also presume that all of us work from home, teachers. I think, we also at a point of time, we are constrained to be in a smaller space. So my proposition is students with, for example, one simple example, out of 900 students, we understood some statistics in my university. Around 450 have done a Coursera course. Coursera gave a limited offer, free. 450 students have enrolled and completed, which means they are swimming beautifully on this type of platform. But as Professor Mishra pointed out, it is a judicious mix, which depends upon institute to institute and the type of programs offered and the kind of network what institutes have. But all of them need a minimum digital infrastructure now, which was not there earlier. Now everybody talks about digital infrastructure. And let me tell you frankly, we invested about 10-15 lakhs just before pandemic on video conferencing. Now with the Zoom and other things, everyone is carrying a video conferencing with them. Now I don't know what to do with that huge investments I made, because at that time these things were there, but we never even looked this side for a WebEx or Zoom. Suddenly WebEx and Zoom has become, I'm giving two names, but there could be others, which has what you call as non-negotiable, I call it. Right? Non-negotiable, whether you do online or not, this license people are taking, and I'm sure always technology prices come down with a large number of users coming in. So my proposition, as I said, that we are debating, but the debate will slowly fade away, where everybody will find, their own, level of the mixture, whether it's going to be 70-30, whether it's going to be 50-50 or 80-20. This all depends about individual or the diverse institutes and their, approaches.
Thank you, Professor Vivekanandan. I'm now going to move to the audience questions, and we have just a few minutes left. So I request that our answers just be as precise as possible. So the first question that we've received is, if we consider this digital transfer of permanent mode of imparting legal education, at least for the next few years, is it going to impact the education of students who reside in remote areas of India or may not have enough resources to access the ongoing legal education, digital legal education? Do you believe that it is the institution's responsibility to ensure that the education they are aiming to impart reaches these students by providing sufficient resources? Professor Vivekanandan, I know you've worked on access to legal education in the past. Would you have any thoughts on this particular point?
So can I get the crux of this question again?
Essentially, how do you ensure access to legal education in remote people who, assuming that we are continuing with this mode of learning, some kind of hybrid mode of learning, and how would a person in remote areas of India who does not have good internet, who maybe does not have electricity also on a regular basis, what is it that we can do, universities can do, educational institutions can do to assist those students?
Okay, that is a question we face not only in terms of class, when the consortium of law school wanted to conduct their examination, whether it was even at a point we thought online, then this was a major concern about access issue. So, as you said, the access issue was there pre-pandemic also. But it has become acute because the whole physical thing has been shut down. Then you become dependent only on this. So some of the schools, what we experimented was sending CD-ROMs, by post, etc. So that they do have. That is only a temporary solution. So probably I was even contemplating that I'm collecting X amount of fee for X amount of infrastructure. But if I'm not actually having the utility of that through students, whether I can, give them, I give them a concession with which you can buy your bandwidth and do a few things. But as I said, it is not a quick fix solution. I only remember an interesting anecdote which could be fitting here. In the early 1900s, it was Ford, the owner of the Ford company, when he announced a grand scheme that he had a model called T, which he was developing. I'm talking when automobile itself is not part of the cycle. He said every American should have one car. That is the announcement he made. And people really laughed at him because cobblestones, roads in New York and many places had horse-drawn carriages. And horse dung will be there everywhere. Methane gas used to come. People used to have terrible things. They said, they called, you are talking about a machine, which is called a car at the time, a real, kind of inventive thing. And you're talking about, have you ever seen the roads? And you're talking about expensive cars in the roads. Then Ford did one answer. He said, let expensive cars come first. Good roads will come next. It is not the other way, he said. People who buy cars now, they will clamor with the municipality to put the good roads because they want the cars to run properly. So sometimes what happens is that we don't ideally create a IT infrastructure and then move on to something. Something we have moved on, then you will find, as they say, necessity is the mother of invention. Suddenly you will find some working model, some finance model, many things can come into place to mitigate this access issue. So the answer to the question, it's a concern, but it is not something which cannot be solved. It can be solved because we don't have a magic wand to do a few things to go back and forth. So it is, as I said, when these things roll out, then we have to hit the road and running and make something. So we need to concentrate on that segment, but not but to imagine we'll come to standstill and roll back. I don't think so. In the past history, for anything for that matter, it has happened like that.
So Pratik, I know we are out of time, but just one thing I wanted to add to what Professor Vivekanand just said, I think it's very important, is I think infrastructure gets built over time. It won't happen overnight. And that's where having the right car first is important for people to push for the right roads to happen. And in that context, I think one of the things that we're talking about right now is saying that a student from a village X who was on campus, now that he has gone back, is not able to get the same kind of access because of this, right? That is definitely a problem and we need to solve it. But one of the other things we need to also understand is that there is a village Y in which there are 50 people who never were coming to campus, but this is giving them the opportunity to have the same kind of experience online. So while the better roads get built, in the long term, this is a much more equitable and democratized solution as compared to expecting all these places to have campuses, because that is never going to happen. If they're going to reach quality education at scale, online is the best way to do it. Right now, the infrastructure is not great, but that's our only hope in terms of getting it to the kind of penetration we need.
Thank you very much. We are, as you correctly pointed out, we are out of time. And most of the other questions, I note that we've answered them in some way or the other already during our discussion. There's one question which I think I'd like to address, just regarding what if there's a constant back and forth? What if another variant comes? And we know, of course, there's news of the Omicron variant currently. And what if we have this knee-jerk reaction of physical classroom and then 3 months later again online and again physical? So I think all of us would agree on this, that we need to not have either online only or either physical only. The future of the virtual sustainability of legal education really is some kind of a hybrid learning model. And that is, of course, applicable to all education. But as Professor Vivekanand correctly pointed out, applicable specifically to legal education, because if the legal profession is adapting, why not legal education? All right. With that, I'd like to thank all of our distinguished speakers for taking time out today and for joining us. For those members in the audience, please do stay tuned for the next session, which will start in the next 10 minutes on radicalizing the theory, postmodernism in jurisprudence. Thank you, everyone, and thank you especially to Professor Vivekanandan, Professor Mishra, and Mr. Fatim Gopali for attending today. Thank you.
Thank you.
Thank
It's
you,
a
Professor.
pleasure to
Thank you.
all of you.
Good afternoon. I'm Sandeep Kendo, and I'm a professor at Jindal Global University Law School. I welcome you to the thematic session on radicalizing the theory, postmodernism in jurisprudence. Some critics underscore the failure of modern, mainstream, or generalized and distinctive legal method-based jurisprudence for explaining the law, which is often complex and diverse in the multicultural contemporary. Therefore, postmodernism in jurisprudence is an interpretive effort to offer unique and critical insights to understanding law and legal decision-making. In contrary to the universal truths or generalized or foundational and existential theories of jurisprudence, the postmodern effort focuses on the particular with law, politics, and cultural considerations. Postmodern's interpretive aesthetic explores and describes the construction of legal text, narratives, and institutions as influenced by historical, linguistic, social, or cultural aspects. However, is it possible to reconcile modern and postmodern jurisprudence? What are the implications of postmodern jurisprudence with the future of legal studies? Our objective in this session is to share some of the thinking about what implications postmodernism has for jurisprudence. There are three panelists in this session. Professor Dr. N.K. Jayakumar is an eminent jurist and the law advisor to the Chief Minister of the state of Kerala in India. Professor Dr. Ranbir Singh is the former Vice Chancellor of the National Law University, Delhi, and is the council member of the Association of Commonwealth Universities, United Kingdom. Professor Dr. Martin Skop is the Dean of the Faculty of Law at Masaryk University, Czech Republic. This session is streaming live on YouTube, and a very diverse audience comprising law students, academics, and practitioners have logged in. I will take a few questions from the audience towards the end of the session and conclude the panel. I now begin with asking the first question to the panelists, and each panelist will have 3 to 4 minutes to respond to each of the questions. And we can start with Dr. Jayakumar. The first question is, how does postmodernism offer an alternative to legal theories in jurisprudence? Dr. Jayakumar, please.
Unmute yourself. Yes. Can you hear me now? Yes.
Yes, please.
Yes. Thank you. In fact, your question how does postmodernism offer an alternative to legal theories in jurisprudence? But I doubt whether postmodernism has offered an alternative to legal theories in jurisprudence. Postmodernism itself is not a unified movement in jurisprudence, but there are different voices, different versions. With the result that postmodernism means many things to many people. It doesn't have a uniform body of ideas. But of course, there are certain central ideas which we can identify with postmodernism. And even their differences of opinion you may identify. We all agree that what we describe as modernism, following enlightenment, has inspired or provoked jurisprudence to come with an alternative. This alternative, of course, is against so many established things in legal theory, challenges the meta-narratives, and attempts to offer an alternative through interpretivism or philosophical hermeneutics, whatever. But now the question is, as far as India is concerned, we have not even understood properly legal modernism. The legal theories which are associated with so-called modernism, like law and economics or feminist legal theory or critical legal studies. Even these strands, schools of jurisprudence, have not found sufficient attention from the academia in our country. So discussing postmodernism in this context is a little, an adventure, I feel. But at the same time, there are so many things which are very relevant to the Indian context in the postmodernist concept. One is the multiculturalism that is very much there in our society, where theories of law which were propounded and nourished in legal systems which do not have this kind of a multicultural society, so much pluralism, may not be suitable. The integrated theories that have come. But we have been following, or we have been slavishly following the theories of legal positivism or the natural law theory, the conflicts and contradictions between these theories. But I feel that even, Kelson's theory has not been properly discussed, understood in India. I have heard Supreme Court judges, not less than 2 Supreme Court judges, in my presence on the same platform, stating that Constitution is the grand norm of our system. When I tried to point out that it's a mistaken idea of grand norm, Kelson never meant a constitution to be the grand norm of a legal system. These judges were not able to absorb that idea. So, modernism as well as postmodernism have not received any attention from the jurisprudence in our country. And I'm sure that this discussion will initiate our students and our faculty who are present in this program to attempt such an exercise, academic exercise.
Dr. Jayakumar, let's move to the next panelist because we're going to come back to many of these related questions again, and we'll delve into some of these aspects in more detail. Dr. Ranbir Singh, please.
Let me start with Lloyd, the very famous jurist, who said, postmodernism is a notoriously ambiguous concept. Taking a clue from what my dear friend Professor Jayakumar said, that the concept, it has no clear definition. Different people have to say different things. So the period of postmodernism is well described by Toynbee as one of the anarchy. And I don't think when we say it is a period of anarchy or kind of a concept which is more based on this kind of a concept of total relativism as opposed to the modern period. As in the middle class is marked by, we know that there was social stability, there was rationalism, there was progress. At the same time, postmodernism is a time of just reverses, time of troubles, collapse of rationalism and progress. Thus, postmodernism is a movement against modern science. In fact, the later part of the 20th century saw the rise of postmodernism to the forefront of legal theory, as we know. Postmodernists are also referred as anti-foundationalists. They in fact shake the very foundations of law in which we believed it was built. So the students of critical legal studies, the movement which generated a long back, CLC we call it, claimed that law cannot have any foundation, as they believe there is no foundation for objective knowledge of any law. So they tend to break those stereotypes in fact. So postmodernists argue that the principles of law could never reflect the universal truth, as we believed earlier, the modern times. According to these scholars, it is senseless to talk whether the law is right or wrong, moral or immoral, as they note the law is whatever the most powerful cultural group in society makes it. And there also is a difficulty. Sometimes we have to find out or have to really go into the background of who the most powerful cultural group is. So that is also a kind of a very, very conflicting situation. If one has to pigeonhole the postmodern legal reconstruction, the basis would be that postmodernism undresses the judges and law. They make it more, bring it to the forefront, the truth of the law and what is happening in the courts. And makers of the immortal authority to determine truth that governs the society, that we were led to believe this. The influence of postmodernism in law raises bedrock challenges to the legal system alike. If law is not objective, if it does not embody values to which we all should have, then why and also criticize to be bound by it? If law is a naked assertion of power, as they believe, by one group on another, so postmodernist theory are exerting a huge influence in the courtroom and also in the legislature, despite difficulty in measuring such influences. I think this backdrop is very, very important for understanding postmodern jurisprudence. We can take.
Sure. Thank you, Professor Dr. Ranbir Singh. Professor Martin, please.
Thank you very much, and good afternoon. I will agree with previous speakers just to say that postmodernism is very difficult to define. We can consist of many theories, movements, persons, from, I don't know, Michel Foucault, Jacques Derrida, Lacan, and Lyotard, and many other, not only French, but also German, American, English, and worldwide known academics. But the question was, if it is alternative to legal theory, I'm not sure, just because I'm not sure if it is alternative or, as Professor Ranbir Singh mentions, the progress or the development. Because the postmodernism tries to be more sensitive, aware, or critical, to try to get the justice or the social justice in society and in law, to be aware that many concepts, many legal terms are in favor of only one movement in society. And the postmodernism can offer us some possible instruments or possible tools or theories to try to establish the critical approaches to the power rooted in society and rooted in law. So from the pure theoretical approach, it is alternative. But I think that is not alternative, but development of the legal theory. Thank you.
Thank you, Professor Scope. I think we can combine the next two questions, and they're very relevant and related. What complexity or diversity in the law allows postmodernism a say? Is it possible to reconcile the mainstream jurisprudence and postmodern's ideals of multicultural or varied and circumstantial explanations of the law and legal decision making? These are the two questions, and they're related. Professor Jayakumar.
Yeah, it's better to combine these two questions and discuss. What complexity or diversity in the law allows postmodernism say. In fact, not really the complexity or diversity in the law, but rather treating law as a system which does not accommodate pluralism or cultural diversity. In fact, law and culture is one of the recurring themes in postmodernist jurisprudence. And the failure of mainstream legal theory is perhaps their inadequate attention being paid to the cultural aspects of it. There's a multiculturalism that in some societies exists in some societies. Now, I doubt whether it is possible to reconcile mainstream jurisprudence and postmodernism, because the basic premises are different, approach is different, perspectives are different. So, when we speak of postmodernism, they deconstruct. But deconstruction is, of course, it has a negative dimension. So they have to reconstruct as well. So deconstruction and reconstruction, which is a continuous process, which has to go on in order to revitalize a legal system. This is what postmodernists envisage. Whereas the mainstream jurisprudence is rather bent upon or fixated upon the idea of a unified integrated system. So it is difficult. Reconciliation of mainstream jurisprudence and postmodernism, I think, is not a possible task. Varied and circumstantial explanation of the law and legal decision making. Legal decision making again, especially when we put the focus on the judicial decision making. Postmodernism, I feel, is not very new. When Cardoso was speaking to the students of Yale University in the year 1921, which subsequently got published as a book, Nature of the Judicial Process, he was speaking about judges taking decisions, and choices are there. Choices are inherent in the judicial process. The judge's personality, the social background, how he was brought up, what kind of people with whom he interacted. So many factors which totally make up the personality of the judge will play a decisive role in judicial decision making. So when postmodernists say they may use a different terminology, but the essential idea, I think, is the same. As far as India is concerned, there are so many themes which are essentially, they deserve to be and basic stuff, origin of the, yes. And how do the basic structure theory from a postmodernistic perspective. So even from the mainstream jurisprudence angle, we have not approached such a fundamental constitutional development in India. A revolutionary concept has been introduced by the judiciary, but a jurisprudential analysis of that concept is yet to be made. Postmodernism can definitely offer valuable insights to understand our constitutional doctrines, our judicial decision-making, the process, as well as the conflict of values that are involved. So I don't think that the possibility of reconciling mainstream jurisprudence and postmodern ideals and multicultural and varied circumstantial explanations is not a task which we have to attempt. At each pursue its own path. Postmodernism has its own approach, even though, as my friend Denbir remarked, postmodernism is not a unified thought process. It is not to get understood easily. There are several streams of thought which are identified as postmodernist.
Dr. Jayakumar, we'll come to the approach and different streams in a bit. Let's get a quick response from Dr. Singh.
Sure.
My concern, the whole discussion is postmodernism has some extent lacked crucial characteristics of modern society in a number of ways. As postmodernism has led to the inadequacy of traditional social categories. Say, for example, we take African Americans. In that context, if we will look into this, the International Court of Criminal Court was formed to try to those who commit crimes against humanity. But because of social differences under postmodernism, the ICC has only tried Africans. No single white has been tried for it, even when whites themselves commit such crimes. For example, American soldiers in Iraq have committed several crimes, but they are not tried. The above statements, provisions of the law and actions of the international organs have done nothing but to leave world social identity fractured under postmodernism instead of it creating social harmony, and breaches the social differences, and there is no room for reconciliation. So in that situation, postmodernism theory has created more uphill than good, as in the modern age is the individualistic tendency in postmodernism, which looks at the individual other than the societies. It advocates for man for himself. This has resulted into tribalism, racism, poverty, hunger, since every man is for himself and no one cares for the other. In Europe, where postmodernism is the order of the day, most people don't know their neighbors. When one gets an accident, instead of being helped, other people just bypass him or her. This has created conflicting narratives, incongruable points of view, and now to be a person is to be more or less conventional location for the eddies and cross currents of various words, images, pictures, and other representations that intersect in some way at some given point in metaphysical space. This clearly shows the lack of modern characters. They argue that traditional culture, theory, politics, spacious invention, intellectuals in search of a new discourse and sources of culture capital. However, the emerging postmodern discourses and problematic raise issues which resist easy dismissal of facile incorporation into already established paradigms. Even though postmodern theory is against traditional culture, modern theory and politics, it has not entirely ignored it completely. For example, postmodernism is also a response to called the legitimization of the crisis. It is argued that modern bureaucratic state has become dysfunctional because it colonized the other world, has interfered with the functioning of the systems. If you go by Santos, who argues that social relations interact, merge and conflict in dynamic, volatile combinations, and bring back the place where it was not before. For example, postmodernism has encouraged the alternative dispute resolution and community policing. This has done of course, a positive step. And to illustrate, the Arbitration and the Reconciliation Act, the Civil Procedure Rules, have both provided for the alternative dispute resolution instead of litigation in courts. This indicates that postmodernism has accommodated traditional modern age within itself. So it is not all the time that it has rejected what was modern, but it has also accepted what was modern, but in a different light, in a altogether different situation.
Thank you, Dr. Singh. Professor Scope.
Yes, thank you. I think it's difficult to say, again, just because the postmodernism will never be mainstream in society and in legal thought or in legal philosophy. Just because it is against the iron cage of everydayness and of rationality of normal culture. We are ready to think in some way. We use hidden, secret, or covered speech or language layers. This is our everydayness. And the postmodernism is a critical approach to doubt these layers in our speeches, in our language, and in our thought. And through this difficultness, it will never be the mainstream. It will be still some minor part of legal and social thought in a society. But, or however, it is important to criticize these layers, these power holders, just because the space for postmodernism is in societies that are homogeneous, they are not multicultural. Just because there is a unity in society, or we can say so-called unity in society, we are forgetting a specific parts of it, the gender issues, the racial issues in some societies, specific social strata issues. So there is no homogeneous society, and the postmodernism tries to speak about this for some members of society, hidden parts of society. They try to speak about minor social strata, about genders that are not in our everydayness speeches. And this is the space for postmodernism. And it also means it never be the mainstream, just because of the impact laid on something we can call problematic issues and problematic questions in society. Thank you.
Thank you, Professor Scope. I think in many ways, the panelists have also answered my next question, which was, should postmodernism offer interpretive strategy standards for understanding law? And I would open it to the three panelists if they think they would want to add more to address to this particular questions. I know in the previous answers, many of you have covered some of the aspects. So the question was, should postmodernism offer interpretive strategy standards for understanding law, just the way legal methods and jurisprudence has a standardized sort of framework? Is it possible, rather? Can we conceive that postmodernism can offer an interpretive strategy standards for understanding law? Dr. Jayakumar, sorry, Dr. Scope, you raised your hand first. Go ahead.
Well, I'm sorry, but yes, my answer is yes, just because it offers the multidisciplinary approach to interpretive strategies. As you mentioned it as at the beginning, we should adopt the narrative strategies, but also we should criticize the normal way, so-called normal interpretive narratives in our society and in legal interpretation. Just what we have in law. We have the interpretative and strategy and application strategy. We are trying to interpret and apply the law. This is what we are doing, dealing with. And the postmodernism can offer the picture or the approach from different disciplines, from philosophy, this is normal, but from literature, from economics, from critical economics, from sociology, psychology, and any other disciplines. And this is important, not to be rooted in the classical legal approach to, for example, interpretation, but to study this text in its complexity, to study it in the context of society and in the culture, and use, for example, the literature as the very useful approach to criticize and learn at the same time the legal text, normative text, statutes, or the decision of a court. So the postmodernism can offer this multidisciplinary approach to any methodology we have in law. And I think this is the main importance of any postmodern approach to the law. Thank you.
Dr. Jayakumar.
Yeah, I will just add one more point.
Yes.
To the question, should postmodernism offer interpretive strategy standards for understanding law? Postmodernism is very often identified with interpretivism. But one thing that I want to point out is most of the postmodernists have focused on language. Without language, law cannot exist. And the indeterminate nature of language, indeterminacy of language is a very important factor to be considered when we try to understand law. That is what makes interpretation difficult and sometimes, questionable. So this aspect also has to be considered while examining the interpretive strategy offered by postmodernism.
Thank you, Dr. Jayakumar. Dr. Singh, did you have anything to add to that?
Let me make it very simple, probably. Postmodernism is a general and wide-ranging term, as we have been discussing, which is applied to literature, not necessarily that is applying only to law, art, philosophy, architecture, fiction, and cultural and literary criticism, among others. Postmodernism is largely a reaction to the assumed certainty of scientific or objective efforts to explain reality. In a sense, it stems from a recognition that reality is not simply mirrored in human understanding, but rather is constructed as the mind tries to understand its own particular and personal reality. And to be very, very brief, probably, in conclusion, I can say postmodernism and modernism are somewhat intertwined in the sense, and it is in reality very hard to draw a distinct line between the two theories, except for the fact that the latter developed from the former. And that process has to continue. And there is absolutely no disagreement on that. The pre-modern, and then we shifted to modern, and the transition to postmodern, modern, and that is a welcome step that brought certain very fundamental and foundational questions for society, and at the same time did not offer solutions, created confusions. And in any study, this will anyway continue. And that desire for knowledge never stops, it continues.
Right. Thank you, Dr. Singh. The next question is postmodern jurisprudence primarily a descriptive project? And then how does it relate with law's prescriptive nature? In the sense that postmodernism would describe what's going on. And how does it really fit in with law's prescriptive nature? Dr. Jayakumar, please.
I don't know whether the prescriptive nature of law is accepted by postmodernists. My understanding is that they don't. Postmodern jurisprudence is, of course, a primarily descriptive project. And this contrast in the descriptive nature of postmodernism and the prescriptive nature of law, it is an obvious contradiction. But that contradiction can survive. I don't find any difficulty in a different line of thought. It's a kind of breakthrough in legal theory and legal thought. When postmodernism came with theories which are totally at variance with the existing theories of law. Even though they never had enunciated the unified theory of looking at law or defining law, they've always accepted the contradictions, the divergences, the pluralities, the cultural diversities. All these are taken care of. Now, even basic concepts like rule of law, I think there's a specific question on that. We will come to that later. Even on rule of law, postmodern theory has a different approach, totally different approach, perspective. So this does not necessarily bother us, the descriptive and prescriptive divergence. Not a big question, I think. Yeah.
All right. Thank you, Dr. Jayakumar. Dr. Singh?
Let us look at postmodern scholars like Derrida, who proposes deconstruction as a method of unraveling the assumptions in which various laws are based and then examining these assumptions with the purpose of exposing the dogmas underlying the same. For instance, deconstruction would demand examining the notion of subject as assumed in law. That is, as an independent, self-contained, self-controlled being, how much a notion is inherently violent in other ways of existence of human being based on interrelated and interdependent nature of human beings as being constituted by totality in which they exist. So Derrida would argue that Western philosophers established the notion of a human being only by excluding and suppressing interdependent and interrelated nature of human existence. Deconstruction, therefore, encourages purposeful and self-reflective intervention by questioning the assumptions, revealing the exclusions, and by placing in the center those who have been excluded. It thus enables critics to revisit the system from the position of marginalized and subordinated. So to that extent, it is a welcome step or welcome development as far as the study of postmodernism or deconstruction is concerned.
Thank you, Dr. Singh. Dr. Scope.
Thank you for this question, because it's difficult to answer. For the first time, we have to say that it is difficult to separate between the descriptive and prescriptive approach to postmodernism. Just because to prescribe what to do is important to know what exists in society. So the good description is important condition for good prescription. And the postmodernism describes what we are doing, how we are living our lives in society, and what does the society do in effect. Not only in what is spoken about, but what is the life about. So this is the complexity of sociology, psychology, philosophy, history, and so on. So of all social studies. And if we want to prescribe, and law is prescriptive discipline, if we want to prescribe what to do, we need a postmodernism description of society. So the value of postmodernism is in this description, because it will never say what we have to do or what we ought to do, because the task is not to prescribe, but only describe what is in society. Thank you.
Thank you, Dr. Scope. I'll jump to some other question, which is much more, because in the discussion we have covered subsequent questions. So let me look for some question that is a little divergent than what we have been discussing. And I think we can discuss. Some critics would argue that modern theories in jurisprudence have failed the rule of law ideal. And this is where perhaps postmodernism jurisprudence may have a say. Your take on that, Dr. Jayakumar.
In fact, in most of the postmodern jurisprudential writings, there is a rejection of the possibility of rule of law. And I've seen someone making an assertion that there has never been rule of law anywhere in the world so far. They maintain that language is indeterminate and social practices are historically contingent. There is no firm foundation upon which a theory of rule-governed behavior can rest. Rule of law requires determinate objective rules that function as guides for and secure interpretive subjects. Joseph Singer argues that if traditional legal theories are correct about the importance of determinacy to the rule of law, then by their own criteria, the rule of law has never existed anywhere. This is what I mentioned earlier. How can we understand the rule of law in a modern context with postmodern thought? Is rule of law possible in a postmodern world? Rule of law continues to play an embedded and central role in contemporary jurisprudence as a focus in the modern exchanges between positivists, realists, natural law theories, and critical theories. Now the question is whether idea of rule of law is coherent in the light of postmodern critiques of language and objectivity. So the basic tenets of postmodernism challenge the very rationale, the very existence of rule of law, and they deny the possibility of rule of law in a modern
Dr.
society.
Singh, thank you, Dr. Jayakumar. Dr. Singh, please.
There are very serious criticism against postmodernism. You look at Chomsky has argued that postmodernism is meaningless because it adds nothing to analytical and empirical knowledge. He asked why postmodernist intellectuals would respond like people in their fields when asked seriously, what are the principles of their theories? Or what evidence are they based? What do they explain? And wasn't already obvious? These are fair requests for anyone to make. If they can't be met, then I did suggest recourse to human advice in similar circumstances to the flames. In a similar vein, Richard Dawkins also says that they are intellectual imposters. I mean, that's a very strong term used, not offering any concrete solutions. And he goes on to say, suppose you are an intellectual imposter with nothing to say, but with strong ambitions to succeed in life, collect a coterie of revered disciples and have students around the world, or your pages with respectful yellow highlighters. What kind of literary style would you cultivate? Not a lucid one. Surely for clarity would expose your lack of content. So this lack of content theory on the part of Richard Dawkins speaks in a different tone as far as postmodernism is concerned. I think we have to look at these angles very, very strongly. Whether postmodernism is a kind of a modern word which the intellectuals will use in their discussions and discourse while explaining the theories of law, or it offers real-time situations. Because in the event of confusion, in the very concept of postmodernism, because people say different things, and this is a very serious question to be discussed further, whether they offer any very concrete solutions for improving law or for society, probably.
Thank you, Dr. Singh. Dr. Scope.
Thank you. I think that postmodernism supports the rule of law. That, on the other side, they try to ask the questions, what is the law? Is it unbiased? Is it impartial? Is it clear? Is it equal to each member of society? Or isn't it some voice of rich people in society, of some conservative structures, for example, in society? So the postmodernism is for the rule of law. But the question is, what is the law? Is it something that we can use without any doubt, or is it something we still should doubt and problematize and criticize? And I think the postmodernism want to say, yes, why not to be under the law? But we should all the time, every minute, every second, persuade people that the law is not only the will of the leading part of society, but is something that is equal to each member of any culture. So the problem is not in the rule of law, but the problem is in the word law. Thank you.
Thank you, Dr. Scope. I will take a few questions from the audience before concluding the panel. And I have received 4 questions, and let me take the 2 and I'll state the 2 together because they are forward-looking sort of questions. And the question by the audience is, do you consider the study of postmodernism crucial enough to be implemented in legal education? How exactly can law schools be able to implement this field of study? And next question is, how would it the next question, which is related, is how would the postmodernism theory influence the future of legal education, keeping in mind the Indian society of the 21st century? So these are 2 forward-looking questions by the audience. There are more, but I think we can start with these. Dr. Jayakumar, please.
These are very, very important questions. I don't know whether law students have raised these questions or somebody else. Anyway, what exactly is the relevance of postmodern jurisprudence as far as the legal academies are concerned? I would say very emphatically that postmodern jurisprudence must necessarily form an important part of the legal curriculum, because it is very, very important that the law is contextualized. We have right to equality in the Constitution. We have the rule against discrimination in our Constitution, which is fundamental right guaranteed by Constitution. But what exactly happens in our society? Is there equality in society? Is there social justice in society? These questions must also form a part of the legal education process. Recently, I saw a movie made in Tamil. Name of the movie is Day-3. I don't know whether Hindi version has appeared and been shown here. But see, that is a movie which shows the plight of the marginalized sections of the community. How justice is denied, how they are tortured. One custodial death takes place in a police station. And the fight of the widow, that person who was killed by the police. And how the law can assist. There's a lawyer, a progressive lawyer who comes to her rescue. And when the case reaches the High Court, 2 judges of the High Court are also very, very humanist judges. So some justice is done. But there are situations where such situations where justice remains an illusion. They can only dream of justice, but justice never comes to them. Unless these realities also form a part of the curriculum, I would say legal education remains incomplete. So the best way to put a jurisprudential gloss to this kind of analysis is through postmodern jurisprudential studies. Yeah.
Thank you, Dr. Jayakumar. Dr. Singh, please.
The influence of postmodernism in law raises bedrock challenges to the legal system. If law is not objective, if it does not embody values to which we all should adhere, then why should citizens be bound by it? Is law merely a naked assertion of power by one group over another? Most observers concede to the fact that most modern theories of law are exerting a huge influence today in the courtroom and the legislatures and also in the classroom. That's what we were serious about. Despite the difficulty in measuring such influence, Peter Shank says postmodernism has emerged to become a dominant in legal theory as any paradigm in the past. Another author surmises that aspects of modern philosophy, postmodern philosophy, have by now through infiltrated academic legal analysis. Though the characteristics of modern society include the information revolution, like globalization, we talk, human rights, we talk, advocacy, environmental conservation, we are talking recently, and minority rights, we are serious about, emancipation is diverse. It is important to place postmodernism in a maze. Given the diversity of contemporary issues, postmodernism, of course, has acquired a very, very important place in spite of the criticism.
Thank you, Dr. Singh. Dr. Scope.
Thank you for these questions. They are very important. However, I think that postmodernism will never be a large part of legal education, just because it is difficult to find one unifying general methodology of postmodernism. So it's difficult to interpret for students and for any other audience. It is difficult to catch the postmodernism in one time and in one theory. If we try to introduce some modern techniques to legal education, like using cartoons, using artificial literature, using modern technologies, movies, whatever, it is only the form, not the content. To introduce the postmodernism in the context, we should read the text with new eyes, with new approaches. This is an important part of legal education, just to see the law, the legal rules, the decision of court from different perspectives. From perspective of deprived social strata, for example, that this never be the major part of legal education. It is important part. It is part that is needed to be in legal education, but it will, in my eyes, never be the majority for it because it's too complex and too complicated for any kind of education, not only legal education. Thank you.
Thank you, Dr. Scoop. Since we still have 4 minutes left, roughly 3 to 4 minutes, maybe we can consider one more question by the audience. And the question is, would postmodernism be able to address the difficulties of a society like gender or caste bias and discrimination arising from the patriarchal society, Dr. Jayakumar?
Yeah, that's a difficult question, but I would say, the nature of discrimination, nature of injustice, it's on changing. For example, feminism wanted to focus on, exploitation of women or suppression of women, but then we found that even within women, even among women, there are sections who are most the subjects of targets of oppression, suppression. Black women in America, or Dalit women in India. So a kind of Dalit feminist jurisprudence is emerged, or black feminist jurisprudence is emerged. So, but that's why I said earlier that postmodern jurisprudence must necessarily form a part of our legal education process, because the emerging problems will have to be accommodated, incorporated. Two things I would mention now. Just mention. One is the impact of technology. How technology has changed the concept of freedom of speech, the concept of privacy, so many things. Similarly, pandemic. The pandemic has affected our lives, our rights, our duties, everything. So, has there been any attempt to study the impact of the pandemic on law or legal rights and duties? No, not yet. Apart from the Epidemic Diseases Act, which was enacted in 1897, the year 1897, we don't have any legal regime to address the problems which are thrown up by the pandemic. So,
thank you, Dr. Jay.
Yeah.
Thank you, Dr. Jayakumar. Sorry to cut you short. We have 2 minutes more. I'll give you 1 minute to Dr. Singh and 1 minute to Dr. Scope. Dr. Singh, please.
Okay. Let's look at what Balkin points to 3 dimensions of jurisprudence in the postmodern sense. First, subjects bring purpose to the understanding of law, right? Legal understanding is purposive activity of subjects. Secondly, judgments about the law rest on the nature of self. And thirdly, subjectivity is important to study the law because legal understanding is also a source of power over these subjects. Legal understanding thus makes the legal subject a locus of ideological power. So in that sense, postmodernism does play a very, very important role.
Thank you, Dr. Singh. Dr. Scope.
I think that this is really important. Just because the postmodernism is not only about discrimination, but it is about normality. And it means that what we consider to be normal may or may not be normal in a fact. And what we are dealing with is the ideology, as mentioned before by Professor Rambir Singh, because ideology covers our eyes and led us to think that something is normal, something is natural, and in fact, it is not. So this is not only about discrimination, but about the covering of our eyes and mind. Thank you.
Thank you, Dr. Scope. Unfortunately, we do not have time for any more questions, but we will have the opportunity to again in the next Global Law School Summit next year, perhaps, and we will take this discussion forward. I thank Dr. Jayakumar, Dr. Ranbir Singh, and Dr. Martin Scope for their enlightening views in this session. A round of applause for our panel. Have a good afternoon and thank you.
Thank you very much, Madam.
Thank you, distinguished speakers. Thank you, Professor Sandeep Kindo, for your fantastic moderation, and it was an absolutely amazing, enlightening discussion. I request all the audience to stay connected. Our next session is going to be another special dialogue, properties of property law, the changing epistemology of property law. We'll commence in another 10 to 15 minutes. Please stay tuned. Thank you, everyone.
Thank you.
Welcome to the 7th special dialogue on properties of property law, the changing epistemology of property law. I'm Alok Prabhu. I'm a teaching faculty at Jindal Global Law School. And I'll introduce, before giving a context to the entire discussion, I will briefly introduce the panelists to the session. We have today with us Professor Jianlin Chen. He's an associate professor at Melbourne Law School, Australia, and has worked previously at the University of Hong Kong and has research experience both in US and in Asian subcontinent. Professor Jianlin Chen has varied interest, and among them of our concern today is property. Professor Chen has published a very interesting book in 2017 titled The Law and Religious Market Theory, brought out by Cambridge University Press. I welcome you, Professor Chen, to the session today. We have with us Dr. Namita Wahi. Namita Wahi is a senior fellow at Center for Policy Research, New Delhi, where she leads the Land Rights Initiative and is a visiting fellow at the Center for Law and Social Transformation in Bergen. She holds an SJD from Harvard Law School. Namita's research interests are broadly in the areas of property rights, social and economic right, and eminent domain or expropriation law. She has written extensively on these issues and in various academic journals and edited volumes, as well as newspapers and magazines. Namita has taught courses in these areas at Harvard Law School and Department of Government there, and at the National University of Judicial Sciences, Kolkata in India. Before entering academia, Dr. Namita was a litigator with Davis Park and Wardwell in New York. We are also looking forward to the upcoming book, which is titled History of the Fundamental Right to Property in the Indian Constitution. I welcome Dr. Namita Wahi to the session today. We have with us Professor Swati Malik, who is also my colleague at Jindal Law School. Professor Swati Malik has varied interest, and one of them is, of course, property. Professor Swati has research experience in both in United States and in India. I welcome Professor Swati Malik to the discussion today. Before giving a context to this entire theme, because the notion of property, as we all understand, is generally people call it as a elephant in the dark room, because property as a notion is a very unifying concept, which is for different disciplines. They have their own understanding of what property is as a concept. So for economists, they have a different take on what property is. For lawyers, they have a very different take on what property rights are. For political theorists, property forms one of the basic reasons why state was created. So social contract theory has a very strong foundation on property. So as a concept, this is both a unifying concept, yet it has quite complex and conflicting issues surrounding it. So no two properties seems to be alike. We all identify property in physical things, in ideas, in rights, in legal interest. But none of these property, in many sense, there is no relation between those things apart from being called as a property right. But over a period of time, if you look at it as a theoretical understanding, we have multiple theories. We have ancient theories, we have modern theories. All these theories, to some extent, it suggests that the particular theoretical framework that has created has never been sufficient. So we have classical theories which were mostly categorized as a monist theory, which had a value formation, particularly on the concept of, for example, for Locke, it was based on labor. For Hegel, it was based on personhood. For Kant, it was based on libertarian concepts. For Bentham, it was based on the value of efficiency. Also, we have justice-based concept of property. For example, we have entitlement theory from Nozick. We have Rawlsian idea of what property rights are. He has combined it very well with his idea of justice. We have capability approach from Amartya Sen and philosophers like Martha Nussbaum, who have incorporated the ideas of property rights within their theory. So looking at all these theories, the trouble for any property law scholar is to first get a hang of what all theories are there. So we couldn't generally avoid even the ancient theories, because one of the current theories, for example, the theory of human flourishing, has its origin in the Aristotelian idea. So we have to probably start from Aristotle or Socrates or probably beyond that to understand, the larger terrain of property. That's the wider terrain we have in front of us. So for any property scholar to even to get a hang of the larger theoretical framework is a daunting task. So, and especially this is because it's not a purely legal concept. It's equally an economic concept. It's equally a political concept. There are, of course, sociological, anthropological take on it. So, as a concept, it has always struggled. It was always in crisis. And apart from the theoretical crisis, we have seen over a period of time there were factual instances that has happened. For example, World War or pandemic or economic crisis that has forced us to take a relook at the fundamentals of what property is. So now that we have a pandemic going on, one major trouble which I personally find is that this is unlike any other previous crisis, which forces us to take a relook at property, especially because it's an economic crisis, it's having social political crisis. Then we have issues like climate change that has again forced us to think about the basic notion of what property means for the common man. What is a meaningful life for him? What is this human flourishing for him? And how does property rights play out? So, considering this particular situation, it's an opportunity for us to unlearn. Now, I'm not being very pessimistic about it, but still, it's an opportunity for us to rethink about the fundamentals of property, and that's what probably the venture today is to reflect upon the fundamentals of what property rights are, theoretical framework of it, the empirical ideas of it. And today's panelists are from across the spectrum. So I think that that's an added advantage for us. So one of the primary questions which comes to my mind is on the Indian context, and I will ask Professor Dr. Namita Wahi to reflect upon it and give her suggestions. So, do you think that because your work had primarily been on land rights in India, do you think that this most basic concept of our understanding of what property is, probably the first thing that comes to our mind is immovable property or access to land rights? How do we see it in this current situation? Because we have, due to climate change also, we have migrations, we have development projects are there, which has forced us to migrate from one part to the other. And then we have a situation where the current pandemic has taught us that some of the access to material goods may not be enough. The urban space may not be a very conducive environment for a certain section of population. So how important is access to land rights as of now for us? Is it, do we need to go beyond it?
Thank you, Alok. Thank you for inviting me, and to the organizers, Jindal Global University. Alok, you've packed in a lot in your opening remarks. And so if I can begin to sort of unpack some of the questions that you've raised. So first of all, the very concept of property rights, I want to talk about that first, and then get on to the pandemic and the climate crisis and all the other things that are happening. So, I think when you spoke about the fact that economists, political theorists lawyers have a different conception of property, I think therein lies the answer. So I think we can only sort of, speak to the issue from the perspective that we are coming from. And the perspective that I have always taken, based on, my work on the ground and my understanding of property, which I think is closest to the ground reality, which is this idea that is there in our laws as well, is that property is a bundle of rights. And this comes from Hofeld, it comes from legal realist literature. If property is a bundle of rights, then you're not talking really about the right to a tangible thing. And therein, I think, is a difference between the work that I've done in this space and the economist understanding of property, someone like De Soto's understanding of property, Hernando De Soto's understanding of property, which is that it is not the right to a tangible physical object, but rather property rights are really about rights with respect to something between people. And as lawyers, we know that property consists of title rights, use rights, possession rights, usufructuary rights, transfer, alienation, inheritance, mortgage, those rights. So it's a bundle of rights. And because it is a bundle of rights, it can be configured in many different ways. So that you can have title, but you may not have possession. You may have possession, but you may not have the right to transfer. You may have title and possession, but you may not have the right to transfer. And if we look at legislation all around us, in fact, we are about to launch this project on mapping Indian land laws, where we've collected and analyzed and summarized over 500 land laws in India. I mean, there's so much laws, so many laws relating to land. And what we find is that we have laws already that create those various configurations of the bundle. Whether it is your rent control legislation, which imposes a limitation on your ability as the owner to raise the rent, thereby protecting tenancy rights, or it is your agricultural tenancy reform laws, which exist that actually secure rights to tenants against owners. So we already have laws that recognize different configurations of the bundle. And if that's the case, then it's a question of, what rights are you trying to protect and what rights are you not trying to protect? And I think the work that I'm doing, you mentioned the forthcoming book is, and I think you mentioned a very important concept, which is development. So the argument, as many of our viewers would know, but for those who don't, India had a fundamental right to property in the constitution. And it was a right that was highly contentious in its adoption. In fact, the debate was most contentious on the adoption of this fundamental right. And then it went through a series of amendments and it was ultimately abolished. It's the only fundamental right to have been abolished. And the argument that I make in the book is that the contention was really not so much about property, but really about the fundamental conflict that exists between the rights discourse on the one hand, which is a dignitarian discourse in the way that it was conceived by Ambedkar and others in the constitution, in the sense that not everybody had the same rights in the country that became independent, whether we speak about women's rights or Dalit rights or Adivasi rights. And so when you say that someone has a right to property or a right to life or a right to liberty, you are actually just recognizing equality, the fact that everyone should have those rights. But there is a fundamental contradiction with the development discourse because that is premised on the state being able to take various measures, depriving people of their land rights and property rights and so on, in order to bring about processes of economic development, which is exactly what you were referring to, which is about displacement of people for big development projects like dams, for your infrastructure projects like highways and airports and things like that. And it is a question of when we talk about land rights, we are talking about the people who are getting displaced. And these people may have title to the land, they may have possessory rights, there may be a conflict in the way that they recognize their rights to the land vis-a-vis the way the government recognizes the right to land. So that is where, we have to think about that these are also property rights. That they're, people tend to, say land rights versus property rights. I mean, actually, these are also property rights. There may be a certain configuration of the bundle, and there may be a different configuration of the bundle in urban areas. And I think that's why the issue is not, the property rights were abolished. That might have actually, worked to the disadvantage of people who were marginalized, who were dispossessed, and who were being dispossessed through the process of economic development. I'm mindful of the time, so I'll just quickly respond to the pandemic and climate crisis question. People have different views of the pandemic. I think it'll be a long time before we are able to unpack what the impact of the pandemic has been. My own view of the pandemic is that it has basically exacerbated, highlighted existing inequalities. It's just brought to the fore inequalities that were already there, but we were perhaps not so mindful of. And therein, specifically to the pandemic question, lies the question of intellectual property rights. And there, I think, the point that you raised about classic political theory, the advantages to be conferred by property, the balancing of the interests of the people who are putting in their research and innovation versus the public benefit. I think, again, there is a balance that has to be drawn there. And I think that balance can be drawn in different ways. Clearly, the way that balance has been drawn both during the pandemic and previously. I mean, we've had other pandemics, and we've had, other crises like the AIDS crisis, where, the poorer countries like in Africa and all, they were much worse off than the richer countries. And it took a while for that course correction to happen, if it ever happened properly. And we are seeing the same thing again. The new variant that is coming about is because we have not vaccinated people in Africa. And, the earlier Delta variant was because we had not, been able to vaccinate at that point of time people in India. So I think we'll just keep having variants because richer countries are going to give booster shots to their population, but the countries that don't have will, continue to have variants which are going to spread to other countries, and we're in it together. And I think that's the point of the pandemic, that we're in it together. So I'll stop there and speak in the next round.
So one of the important points which you have raised is on the constitutional understanding of property. I would have some reflections on it from Professor Swati Malik, because she's in academia, and so under the constitutional law, we do not have property as fundamental right, as Dr. Namita has suggested, and it has been repealed in 1978. Even I guess in the United States, as they have not taken it as a fundamental right, and there had been multiple systems which have coexisted within a society. For example, one parallel which I would like to draw is about the case of the indigenous population. So the tribals have a very different notion of what property is. Their understanding of property is quite different from what the modern state, the regulations of state, the constitutional framework of state has provided. Process, what do you think that there are there under the constitutional framework, and even when you look at the concept of property within the constitution, do you think that there are possibilities of multiple systems that could exist within the constitutional framework, or the power that the state has shown? Even in the case of United States, in many other cases, there have been differences, because in some countries you have treaties which has been specifically created between the indigenous population and the state, which came about in 17th century or during the time of the creation of state itself. But in India, that has not happened. We do not have a treaty. So when we have a treaty, it's about a contract between equal partners. But here we have laws which the colonial masters have created. So we have laws that has been constitutional. So how do we see that? Do we understand that the Constitution provides us enough scope and flexibility to coexist within different systems in place?
Thank you for the question, Alok. So even though I feel that even though we don't have a fundamental right to property anymore, but we still have a legal right to property under Article 300A of the Constitution. So that is one area where we can actually explore the right to property. And as we see, there is a growing trend with the latest court judgments that actually under the doctrine of eminent domain, that, and we have seen the Land Acquisition and Rehabilitation Act 2013 as well, that there are serious questions when the state is interfering with the legal right of property of the individuals as well, that there are questions about lack of compensation to the to the people who are losing their lands because of different dam projects. We saw this in the Narmada Dam project as well, that there were many people who were displaced from their properties, but they were not adequately compensated. We see this in cases of tribal populations as well. So there are arguments under the Forest Rights Act as well that we need a greater community participation in order to ensure that property rights are better protected for the marginalized portions of the society. So when I see that, that's why this is the reason that there have been these constant debates about reintroduction of, a fundamental right to property, specifically when we see the situations of marginalized population, because the state has not been active in properly ensuring that these people are effectively compensated under the LAR Act. And there are so many lacuna, even though there have been suggestions that we need to improve the community participation, we need approval from specific portion of the population before the land is actually assigned for different projects. So these issues are actually raising the concern. So I think that when the state is exercising eminent domain, we need to have effective methods of compensation, and that's why we need to effectively recognize the legal right to property and to take it more seriously. So with the introduction of special economic zones, and we saw this in the case of labor codes as well, how the government is repetitively taking a pro-industrialist approach. So we saw this in the case of projects as well. We saw this in the case of nano project as well. When there were greater issues of displacement. So I feel that the state is the one who needs to take an active role. We need to have effective methods of compensation for the people who are losing their rights, because it is difficult to say that urbanization and industrialization is going to stop at any rate. So that means that we need better methods of coping with the system and to recognize better property rights for the marginalized.
So these reflections, in some sense, because Professor Chen is specifically working on natural resources, I would, the question that comes to my mind is, for Professor Chen, how do you see, because you have worked in 3 different jurisdictions and you are currently teaching in Australia, so in Taiwan, in Hong Kong, in China, we have seen tremendous amount of development, and specifically, on issues of displacement, on issues of compensation, because in India, probably one of the, as Professor Swati has mentioned, one of the major contention had been the point of contention had been one of compensation. Though in constitutional framework, especially in India, we do not have when we adopted our provisions within the constitution from United States, we have specifically avoided 2 particular clauses which they had. So it's the due process clause and the concept of compensation there. So in India we had diluted so much, but how do you see the issue of property rights associated with natural resources?
Oh, so thank you, Alok, and thank you, Namita and Swati, because I think for this question, it's not just about natural resources, but it's actually relates, or at least what I want to just share is relates to what Namati says about the constitutional rights and what Swati says about the problems relating to eminent domain. In particular, what we can term as perhaps corruption or inefficiency by the government by taking the land but not paying the fair share, but then transferring it perhaps with some side money on the side to reach benefactor, etc. Because I want to speak from the experience of Singapore, which interestingly doesn't have property rights in its constitution as well. But Singapore is also a place in which 80% of the population owns their own home. So it's a place in which, on one hand, there's property right. It's not a constitutional right, but it's a place where many people, including those disadvantaged, what we call disadvantaged and the poor, actually have ownership of many property. And I think this speaks, to what I feel is an important conceptual dichotomy between the way to understand constitutional protection of property rights. And I think there's 2 parts to it. One is the distinction between the allocation of property rights and the protection thereof. So I think in a sense, the injustice we see nowadays in many parts of the world, developed and developing countries, it's not necessarily a problem of too strong property right protection, but rather insufficient allocation. And I think this is alluded again from what we hear from Nawati and Swati, where after the abolishment of property rights protection in India, there's a task of coming back. But perhaps what the ideal way will be that property right is protected, well protected under the law, but it's also well allocated by the state. And so this leads us to the second dichotomy, is that the constitutional right protection of private property is meant to serve as a constraint of the government. And of course, in the ideal world, the government will use the power afforded to it by the lack of such constitutional protection to take the land and redistribute it, reallocate it to the parties which is it deserve. And throughout the process, ensures that those which are allocated, those owners of those property, insofar as the government is not trying to regulate its action or reallocate, have proper legal protection. And so I sometimes see the debate on, and not just on land, this is the same thing with natural resources. It is that tension, that distrust of government which motivate. And perhaps it's not just the motivation for this call for private property right, but it's also the source of the problem caused by the lack of property right, whether in terms of its legal protection or the constitutional protection. And I just want to end off with a bit of research specifically on natural resource rights, which I thought is quite illuminating. So I did a state, I look at the United States, states by state, how they classify cloud water. So basically the water in the cloud as whether are they state-owned or not. And so looking at all 50 states on how they deal with cloud water, there are 4 states which says that cloud water belongs to the state. So basically the state exerting property right, state ownership property rights over those natural resources. But there's another 20, 30 states which have regulation affecting how individual can affect cloud seeding and other forms of weather modification, how they can use those resources. And the interesting finding is that those states which proclaim state ownership over cloud water doesn't actually have more regulation as compared to states which regulate the use of those resources without explicitly saying that those belong to the state.
all the troubles probably now UK is having. So Professor Caroline Hunter has joined us. Caroline Hunter teaches at York Law School, has done considerable work in the area of housing. And currently, for the last couple of years, UK, like many other European countries, is facing the issue of immigration, and housing is a huge issue there. Professor Caroline Hunter, do you really see that the issue of housing as something which comes out of the state power, or which has to be inscribed within the constitutional framework, because UK does not have a written constitution? So the kind of normative culture that has created, do you think that UK has something to learn from Singapore, or UK has a very different way of looking at it?
Yeah. Hello, and I'm sorry I'm late. The times moved in November, and I put the wrong time because I put it anyway. I'm really sorry about that. So just to talk about the idea of rights, I have to say I'm a bit of a skeptic about rights, and I suppose that comes from a little bit looking at what happens in South Africa in terms of the right to housing, and what happened in the case of Groom Boot, where she died before she was rehoused. And it seems to me we forget a lot that actually we have what we need is resources from the state, if it's the state who's going to provide them, because actually giving people rights often doesn't lead to better housing. Or we need to have very particular rights against landlords, if that's the problem, not against the state. And I think that's where I start from. So I write about the rights for, in terms of housing, and and I look at other countries where there's a right to housing, and I think actually if I look what we have in the UK, we have problems with it, but we have a lot of rights for the individual against whether it's as I say, the landlord, or if they've got a mortgage, against the mortgager. All that sort of thing is more important than a right to housing. And the other thing I suppose I want to talk about, because you're talking about refugees and so on, is of course they have no rights to property. When they get to the country, as we're seeing at the moment, they have absolutely no property at all. And of course, a right to property is of no help to them whatsoever. And so they always have to go to the state, certainly in the UK, for anything and everything. And of course, the state treats them terribly. So I think if we're talking about a right to property, that is not going to help at all.
Right. So one particular idea that comes to my mind when Professor Carolyn Hunter specifically mentioned about the state should have wherewithal, the capacity. So probably Dr. Namita Wahi would be more capable to answer this this problem. The problem is that even when we adopted provisions of property right as fundamental right within the constitutional framework, we have probably created a right-based approach to property rights. That means we were not. So the balancing of obligations in terms of rights, we were more looking at rights rather than obligations. So for some people, when we look at property, they first for them the first thing is that right in person. I have, because my property rights comes out of my person. It's an extension. My any right over external objects, over land, over vehicles, over any other things comes out primarily because I am there. It's a part of my personality. It's an extension of my personality. So if we consider that particular property rights as an extension of my being, then do you see that in the Indian Constitution that we have not been able to understand property rights in its varied dimension? So probably if you look at case laws till 1978, the most contentious issue was on land, on immovable property. But we had the court had been silent with regard to different other forms of property that were existing. For example, my body. What about my body as my property? Because through it, if you look at Aristotle, people have spoken about it, and various theoretical frameworks have already been created. So the contemporary theory of human flourishing, for example, it is based on this Aristotelian notion, and even for Hegel, his idea of personhood theory comes out of first the question that comes out in our mind is that because I am there, I have legitimate interest over external objects because that's how I could live a meaningful life. So this question that the individual is there, he does not have access to external objects, but by virtue of being born as a human being and being in a society, I have certain rights, property rights, which is not basically external, but still fundamentally there are certain other rights which are there. This particular debate has never occurred, or it has occurred once in a while, and this silence or this vacuum in in the constitutional case laws that has emerged till 1978 and even after that. Do you think that this is a problem?
Thanks, Alok. So, first of all, I want to say that I agree with Swati and Jamlin that it's the question is not about whether something is a legal right or a constitutional right, but rather we also need to look at the institutions and the processes that are going to enforce those rights. So I'm completely on board with all of you on that. But I do think that, and going to your specific question, Alok, so when we look at the Constituent Assembly that debated the fundamental right to property, actually it's a myth, and this is the thing that I'm trying to sort of set aside with my work, which is that, frankly, the Zamindars pretty much lost in the adoption of the constitutional property clause. And I think the problem was that there was a lot of disparate views within the Constituent Assembly. The Zamindars were, of course, one strong lobby, but and what Swati is talking about, the industrial interests being prioritized. What I argue is that was the formulation that was adopted in the fundamental right to property itself. So it's not something that is happening now. It's happening more now because there's more money for development projects, more industrialization happening now, just scale is more. But in terms of actual commitment to the process of industrialization, capital formation, and economic development, that is what framed the final adoption of the right to property. And in that sense, that is the fundamental contradiction, which is why I don't, comparative constitutional law, we tend to look at different jurisdictions. I personally don't find it that helpful to look at what has happened in developed countries vis-a-vis what's happening in developing countries who have been former colonies, whether of England or France or any of these other countries, because the colonial setup was something, you may not need rights in England because you have a well-functioning setup, but when you are colonial, subjects, you need rights. And that was the entire, like if you look at the Indian the freedom struggle, starting from the 1895 Home Rule Bill, which was at the time of the founding of the Congress, the Indian National Congress. It's all about rights, because you just don't have any rights. You have a completely arbitrary colonial state who can come and, kill you, maim you, like push you out of your house if you want to protest against illegal laws. I mean, there's no illegal laws because the British colonial state decides what exactly it's going to be done. So you need rights. You need all rights. You need rights of property. You need rights to life, liberty, because you don't have that when you're a subject. When you become a citizen is when you have rights. Developing countries people became citizens post-independence. Whether it's South Africa, whether it's India, you don't have rights in an apartheid state. So you do need rights. But I agree with Caroline that it's not, it's a necessary, it's not a sufficient condition. You need resources to back those rights, definitely, but you need rights, because without them, you're just subjects and not citizens. So that's the first part. I completely agree with Jianglin as well, that you need to have allocations, and at the same time, you need to have protection of property rights. And I think India did embark on that with the land reform laws that were passed. And I'm just completing a study of all property rights cases that were decided by the high courts and the Supreme Court. This is like thousands of cases. And while it is true that a lot of cases were brought by zamindars, but a lot of cases were brought by people who were just affected by the big transitions that were happening. And it was not entirely clear how that was going to affect them. And a lot of these cases are also brought by the urban, commercial and industrial interests. So it's not true that there were not different conceptions of property. In fact, what we also find is something we see today is the arbitrary use of criminal law. So a lot of the cases are actually, cases of confiscations, where people have, because it's not just land that was being reformed, there is the Essential Commodities Act. And suddenly there are a lot of disputes about whether you are afoul of the law. And that happens whenever you have a big change in the law. There is a rise in legal disputes. This is what we say in our land acquisition report also, because the law has changed and it has provided certain greater rights. And which is why I say when you have rights, you will see more litigation, but that's not necessarily a bad thing. It may lead to more inefficiency in the system, but it may be more equitable, especially because we are in a post-colonial state. I don't think that much has changed. I think constitutions do matter because so again, the distinction between the post colonies and the ones that were never colonies, is the fact that our laws, as you know, have been grandfathered under the Constitution. So we have a lot of colonial laws. We just got rid of the 1894 Land Acquisition Act. So yes, the Constitution matters because the Constitution was a blueprint for the future. And therein, I do think, therein is the disagreement that I have in the particular context of India, why constitutional rights matter more than legal rights, because legal rights, like of this 500 laws database that we have created, 500 land laws, 150 are colonial laws. And again, I want to make a nuanced distinction that out of those 150 colonial laws, not all laws are bad, or not all laws are, of a colonial state mindset. Some of those laws are also to protect interests of particular groups like Adivasis. And that brings me to the natural resources law question, as well as the question you posed to me in the first round, which is about climate change. You know, I think I've been working on Adivasi rights for many, many years now. And I think the biggest takeaway I have taken away from that is not that Adivasis need protection, but rather we need to adopt the Adivasi mindset or consciousness of looking at our world. So for example, they don't talk about property, land rights and water rights and as different rights. What they have this concept of Jal Jungle Zameen, which is water, forest, and land. And they understand that we are part of this one ecosystem. Our problem, the reason why climate change is upon us and we are having to battle this is because we never regarded ourselves as part of an ecosystem. We felt that we could go ahead and do whatever we wanted because somewhere we are superior to the rest of the environment. And that is exactly the consciousness which has gotten us into this problem. Whereas the Adivasi consciousness is that the forest, the land, and the water is part of an ecosystem, and you can't just go in and destroy the forest to bring out coal because you want to provide electricity to everyone without understanding that there are going to be disastrous consequences, especially if you do it at a scale and in ecologically fragile and sensitive areas without doing processes properly. And that brings me to the point about the fact that we don't really have a state where processes work. I have been, I've obviously been in the policy space, in the academic space. I've also been a lawyer, and I have been part of projects. I have seen, how, the process that is supposed to be followed is being followed, but minutes of public hearings are doctored. Something is said in the public hearing and something else is reported. Even when an environment impact assessment is conducted, I have seen in the Mundra case, for example, that a different location is given for the project on the basis of which the EIA is cleared. And and actually the project is on a different location, where if it was fact, and these are like government bodies that are doing these studies. So there is a lot of corruption, you can call it, or you can call it a complete sort of state industrial nexus that allows for these things to happen, that allows for us to basically operate on greed and not see ourselves as part of a larger ecosystem. And that's what leads us to issues. And then we talk about natural resources, management and things like that. But I think more than doing for Adivasi land rights, I think if we adopt the Adivasi mindset or the indigenous people's mindset, I think we'd probably all benefit and make the world a better place.
To some extent, you are directly critiquing this idea of seeing property as subject to market. So, because property becomes so contested because it is subjected to market, that means, we are not attuned to seeing, for example, for a indigenous person, it does not occur in his mind that, no, this should be sold. This is my mother. The land is my mother. It's, as you rightly said, it's a part of me. I'm a part of the land. So this is not to be, subjected to the market for commercial interest. And this particular idea, that I would like to, come to Professor Swati. Do you do you agree that the kind of laws that we had, the constitutional framework that we had, so probably in terms of rights, or even sometimes, creating, because for a indigenous person, it's not through the constitution that these rights flows to him. He had been there pre-state. He had been there. He had already existed. So how do you see that? The kind of conflict that we see can be resolved, because the constitutional framework to a large extent have failed the tribal population over a period of time.
I completely agree that, we need a change in the system. And earlier you were talking about theory of human flourishing, and you were saying that, we need to think about, the good of the society and good of the others as well when we are theorizing the property rights, right? So this also comes to my mind when it comes to rights of Adivasi communities and other marginalized groups as well, that perhaps just having if having a constitutional right was in itself a solution, then this would not have caused so many legal battles, which eventually led to, abolition of the right to property. So just having a right, as Professor Caroline mentioned, is not enough. We need a effective system of enforcement of that right as well. So when I see what I see is a solution in terms of, the theory you were talking about, theory of maximizing human welfare, theory of flourishing, and that was Professor Amartya Sen's idea as well, that when we talk about, resources, we have to see, the impact of those resources as well. So when we look at the rights of the marginalized group specifically, like, in the pandemic, we saw how the economic divide is increasing, how we saw that this has been labeled as a pandemic of inequality, basically, how we saw how rich people are actually boarding jets and, leaving the country. On the other hand, then we have people belonging to certain sectors of the society who are not even vaccinated. And as Professor Vahi was talking about, that, how we see that, in African countries also, we see that because of lack of resources, how, we are on the third wave now, right? So what I feel that this is a problem inherently, what you are hinting at is a problem of inequality of resources which exists in the society, and whether we can solve it through constitutionally recognizing a right to property, or whether, having a legal right in itself is enough. So what I feel is that we need a better state intervention when it comes to protection of the rights of the communities like Adivasi communities. Second is we need to, think about this in terms of distributive justice theories, that, resources need to be better allocated and not concentrated, to the limited few, which is causing these problems. Because on the one hand, we saw during the pandemic how the economic divide is actually increasing, and on the other hand, if we look at the statistics, only 30% population of the world actually owns the land, right? That is the reality. So just saying we have a constitutional right of property is not enough. We need an effective method of enforcement of that right as well. Because, in the pandemic, it has been also seen, there have been arguments about better recognition of rights of property for women as well. We saw during the pandemic how, because of lack of property rights, when women were losing their jobs and when they have the entire burden of their family care and they were struggling with issues of domestic violence as well, having better property rights, may have solved some of their problems in these times. So same comes to, Adivasis and communities. So when we are going for all these projects and when we are going for displacement of communities, we still need, some bare minimum. Like we saw during the pandemic how the government, there have been arguments about relaxation of IPR, right? So because, the idea is that, the governments are also promoting the research to certain extent when it comes to vaccines. So, it would be better to relax the intellectual property rights for a while, and, eventually, when the pandemic is better controlled, then we can talk about stronger property rights. So I feel that, it's important to talk about distribution of resources in an effective way. We also saw measures like by the government of Delhi when, they were actually requesting the hotel owners to, use their premises as hospitals, basically. So again, there is a private right of property there, but then we were talking about relaxation of that right for the benefit of greater public. So the solution I see here is that we have to start thinking beyond oneself. We have to start thinking in terms of human flourishing as well when it comes to property rights, because when we talk about the right to property, we also have to think about right to health, right to freedom, and we have to think about the idea of flourishing as a society as a whole. So we just cannot argue always, so we have to think more about for this in terms of better distribution of rights rather than just talking about recognition of right to property.
But we have the same in the UK in terms of, actually, we did some things which are unthinkable actually in the pandemic. So we stopped evicting any tenants. So nobody was evicted, and homeless people were all largely put in hotels. So we had nobody on the streets. So it can be done if we want to.
Yeah, I was just about to ask you this particular question that there are some interesting models that exist, especially some of your works have given alternatives in comparison to ownership. You have said that housing can be provided by different kinds of models. Do you think that especially in the context of migration, do you think that there are certain models that can be replicated around the world? Because this is not just a problem with UK or some of the European countries, but also the problem of housing. This is a basic requirement, as Professor Swati is saying. There can be different models that can be replicated. Do you think that some alternative methods are there possible?
I'm not sure that we have other models. Our models are basically on around property rights. So, and different levels of property rights, from having no rights up to some, a license to be in some place up to ownership. And I think our problem is we certainly in the West, and I don't know, if there are other models elsewhere, but essentially we idolize ownership, and that's our problem, individual ownership. And that's what our rights to property are based on. And we need to think a lot more about relationships rather than ownership.
And can I just jump in on Carolyn's point? So, and just add to that, I think not only must we think more about ownership in addition to relationship, I think we need to think on two further dimensions. So one, I think has been alluded to, and that is the responsibility which comes with ownership rights, right? That if you own something, what must you do for the community? But I think another aspect, which I think is just as important, but much less talked about, I suppose because of its controversy, is that it also, when we talk about ownership rights, property rights, it also have to come with the ability to use it wisely to advance the benefit on its owner. So I think this is particularly important when we look at the allocation. So we know that, and I think that the team coming out, especially from Swati, is that, which I agree, is the government must allocate resource, and this is what Karen says, to allocate resource, give property rights to those which are disadvantaged. And of course, once given, I think the issue of them misusing it to the detriment of community, that is not much an issue. That's more for big corporation and whatnot. But what is actually just as important is, do they have the capability to use those property rights allocated to them efficiently to advance their own interests? And we know that utilization of property, resource, money management, financial resource management is a skill which takes time and resource to acquire. And so this is where, if Singapore experiences anything to go by, it suggests that some form of controversial but perhaps necessary paternalistic restriction on the use of those property rights which are allocated to the disadvantaged community may be warranted at least in the initial transition phase such that they can build up. So to put it again, one key aspect why Singapore can achieve 80% home ownership is because it has a compulsory saving scheme. So the way it forces the population to finance, to devote, to ensure that they can finance the mortgage is by requiring them to set aside like 20% of their salary into a fund which can be only used to service the mortgage. So it actually restricts, in a sense, their rights to their own money in a way such that for the greater good, so they direct them away from consumption, which it doesn't build wealth, into investment, which is their own home, which can build wealth. So I think that is the aspect which I'm just throwing out there. I'm not endorsing it. And of course, Singapore is a small island, much less population. So whatever experience it doesn't necessarily can be generalized anywhere elsewhere. But I does suggest it does indicate that looking at how to build out the capability of property right owners to manage their resource to their own benefit is something which any allocation scheme must pay attention to.
We were just about to scratch the skin of property rights, and time is running out. So I would come up with an audience question. This can be addressed by anyone, especially this is a question that is significant for different jurisdictions. It's on climate change. So from the audience, the question has been put. So climate change induced migration brings demographic changes in neighboring states. How does this affect the approach of native people on their property, especially considering tribal rights on property? So for example, climate change has also suggested that over a period of time, some of the low-lying areas would be underwater. So it's not just applicable to tribal population, but also to people who are well settled in places like Bombay or probably in Singapore. How do you see it? I would like quick comments from all the panelists. Professor Carolyn Hunter.
Sorry. Goodness, that's a big question. I'm not sure. Well, I don't think individual property rights will help with this. I think we need to think bigger. We need to think about our relationship. So in the UK, we do have issues of storms and so on, making huge difference. We've just had one the last week where the electricity is still not back on for certain areas of the country for a week, which for us seems terrible. So I guess we have to think about this in terms of our relationship with each other across the world. I'm not convinced that property rights is the way to deal with that.
Professor Chen?
So my sense is that perhaps I'm looking at a dystopian future where climate change will be equal to some massive natural disaster, and in a sense to mitigate and manage all the fallout, it will require state to almost take on a war footing in which it have more power, hopefully with more responsibility, and use those power, but to really like in a context of a war setting, make drastic, radical and dramatic a reallocation, rearrangement of resources to meet, to ensure the proper survival of a huge chunk of population which is affected. But of course, it is a very dystopian future because whenever government has so much power, it never looks good, right? So,
Professor Swati Malik.
I feel that property rights can be one of the solutions for this. Because when we talk about climate change, basically we are talking about resources, and when we talk about resources, we talk about property rights. So studies have suggest that better property rights and effective allocation of resources actually have good impact on environment. For example, there was a study which was done in Ethiopia, where it was found that once property rights were recognized for general public, they started, using better techniques for agriculture, and it had positive impacts on food security. Also, recognition if property rights, like there was this example of Indonesia, where in the Sembugan region, when the rainforests were depleting, but when property rights were allocated, then there was a drive for reforestation, and it has improved the situation. I feel that we need better management of resources, so I would like to argue for better recognition of property rights, but along with it a better distribution of it, of the property rights as well. So we need to involve the community, as Professor Caroline was mentioning about relationships. So we need to focus on our relationship with the resources and our relationship with the environment. And I believe that having better property rights and ensuring better property rights for greater public will encourage community participation, and better community participation will have positive impact on the environment, and it will help in addressing the challenges posed by climate change. We saw this, like, for example, in the Chipko movement, where community was greatly involved, and they were involved in the to stop the deforestation. So because forest resources, climate change at the end of the day is result of misuse of resources. That is one of the reasons. So better allocation of resources through property rights can be one of the possible solutions for addressing this problem.
Dr. Namita Wahi, your closing comments?
Thank you. I just want to say that, even without the climate crisis, Adivasis or indigenous communities all over the world have disproportionately borne the burden of economic development. Just to give some statistics from India, Adivasis in India constitute only 8.6% of our population, but they constitute 40% of the people who have been displaced for economic development projects, mostly dams, mines, wildlife parks, and sanctuaries. In the 50-year period from 1950 to 1999, they constitute 40% of the population that has been displaced, including some who have been displaced twice in one lifetime. So just to put that out there, because they have already borne the burden of economic development. I think the answer to the question that you're posing, like what's going to happen when we have this major climate crisis, I think it goes back to what you started out with, Alok, which is the free market versus the state. So for example, if you have an environmental disaster, whether it's the California wildfires, or it's the hurricanes, or it is the flooding that we've had with cyclones and so on in India. I mean, if you are rich, you'll buy insurance for your home, right? So in any crisis, if you leave it to the market, the rich are going to turn out better than the poor. But if we take Jianlin's example of Singapore, the state forces or provides, or what Caroline was saying, what the UK government has done during the pandemic is to make sure that everyone has insurance or everyone has some social security protection, we can actually mitigate that. And I just want to say this because I think what's happened is that because there has been so many issues with the way the state has functioned, at least in the policy space, we are seeing a withdrawal of the state. In fact, we are seeing in India today, we are seeing privatization of many state, institutions and organizations that have actually done well. So we are seeing a complete shift to a privatization model without any understanding and perhaps almost an assurance that the free market is never going to work out well for the underprivileged. And yet we are seeing this sort of handover to the private sector of so many things. So I think we have to, definitely, I mean, have rights, hold the state accountable. For me, rights are an accountability mechanism. And I completely agree with Caroline and others that, you have to have those rights against other people as well. Like horizontality in application of rights is as important as the vertical individual state relationship. But I think we have to be, and that leads to the larger political theory questions that you started out with, Alok, is that the role of the state, the relationship of the state to property and to economic development, and the role of the private sector and the role of the free market. And I think those are questions that probably deserve continued discussion in the coming days.
I'm so thankful to every panelist. Actually, we have crossed the mandate on time. I hope this would be a continuing dialogue. At some point of time, we will again continue with this dialogue. And I'm so thankful that I had been given this opportunity to be part of this discussion, even in a small way. Thank you so much. Thank you, Srijit. Over to you.
Thank you to the moderator and to all the distinguished speakers. That was a very enlightening discussion. Audience, please stay tuned. Our next session will start in a few minutes from now. It's going to be a new constellation, the inclusive epistemology of global legal studies. Thank you, everyone.
Thank you.
Good afternoon, one and all present. I am Dr. Jasmeet Gulati, Professor of Law at Jindal Global Law School. I welcome you all to the 19th session of the Global Law Schools Summit. In this session, we will be deliberating upon global legal studies as a discipline. The theme of the session reflects on a new constellation, the inclusive epistemology of global legal studies. I have with me the experts from the field, and it is an honor for me to introduce the panelists for the session. We have for this session Professor Colin Scott, who is the Principal and Vice President of Equality, Diversity and Inclusion from University College Dublin, Ireland. Professor Dr. S. Shantakumar, who is the Director, Gujarat National Law University, Gandhinagar. I'm also happy to introduce Professor Dr. Shiv Prasad Swaminathan, who is the Professor and Associate Dean, Jindal Global Law School, and Professor Dr. Mizanur Rahman, who is the Assistant Director of Center for Postgraduate Legal Studies at Jindal Global University. For the audience watching us on YouTube, I would like to share with you the format of the session, where I shall briefly introduce the theme of the session, which will be followed by the Q&A round, where we will hear the views of our panelists. And we also have certain questions framed for them, but we will be inviting questions from the audience as well. Global legal studies has only emerged out of global studies, which is not a discipline sensu stricto, but it has an interdisciplinary approach and is impacted by other disciplines, including economics, politics, history, sociology, and international relations. A new generation of global legal study scholarship is building by investigating the depth of law's power for people and for their governments. Mark Fathi Masood, in his recent article on Reflections on the Future of Global Legal Studies, states that the future of global legal studies will involve bridging the study of law with politics, society, history, religion, and human behavior. The approach and the ideology concerning the global legal studies is inclusive insofar as its subjects and objects are concerned. It has to overcome the challenges put forth by the modernity and postmodernism. The fading away of physical boundaries because of globalization and the emergence of globalizing world has to be kept in mind while talking of new kind of governance model, which would be acceptable for deliberations and practical utilities for the new generation of lawyers. The epistemology that has developed analyzes the changes that are being brought about by globalization and its implications, which are not only legal, but affects global economy, global trade, global relations, global politics, with all its challenges, for instance, climate change, including global warming. Global legal studies would include global processes along with the challenges, as mentioned, for example, global warming, ozone depletion, etc. The actors in the globalizing world and the globalizing legal order, which are no more limited to legal persons, includes the multinational corporations, the elites, NGOs, social networks, cultural groups, market forces, and so forth, which are very much part of the global legal studies. We are talking of this new constellation that has come out of the era of globalization, where while reading global legal studies as a new approach is required, which would be based on all these disciplines. Global studies create global citizens, and similarly, global legal studies would create a new army of global legal professionals who would have an inclusive approach, which would be interdisciplinary rather than comparative. On the other hand, global forces may also trigger local and domestic reactions that deepen tensions. Global forces sometimes encourage new forms of economic and legal integration that harmonizes across local legal and economic systems. It is expected that they would be more tolerant and inquisitive. The world is reorganizing itself to deal with such challenges and more. For example, recently we saw the global response through the global fight against COVID-19. The approach was global rather than international because the goal was single. That is, fighting COVID-19 through vaccinations and social distancing. Since the problem is global, therefore the problem-solving techniques are also to be employed globally rather than locally. The social distancing, in fact, brought the world together as we see even today, at one platform where through virtual proximity, the time and space became meaningless. It's a new world order that reflects the collective spirit of global. The purpose of this session is to explore the epistemological inquiry that global legal studies provides us to understand the conditions, challenges, demands, and needs of the contemporary times, giving due consideration to the history and having foresight for the future. Having discussed the theme of this session, I would like to invite the speakers to give their views on some of the questions that we have in mind. I'm going to invite Professor Colin Scott to please share your views on the different countries that are following different legal systems. And even where the same legal system is followed, it is tailor-made to the needs of its own society. A global legal approach imagines a sense of commonality and universalization across borders. How would such differences be accommodated then? For example, judges or even arbitrators of different international courts and tribunals, they often belong to different legal systems. And this often results in them adopting a lens which is colored with their domestic experience while adjudicating matters. So what do you think about this?
Thank you very much, and thank you for the invitation to speak. It's a great visionary activity, I think, to run this global conference on the challenges around global legal studies, and I'm very pleased to be involved. Looking at your question about how we deal with the challenges of different legal systems, creating a problem for the operation of global law, I think the answer might come at a number of different levels. Clearly, national legal systems do have different norms, different procedures that make the operation of law across borders very, very difficult. But from my own perspective, some of that focus on national rules and national procedures is falling away because of the operation of law transnationally. So in many instances, we are thinking about transnational regimes in which the parties to agreements, which may be contracts or they may be treaties, are setting down norms and also procedures for vindicating those norms. And in that context, the national rules and national courts are perhaps less significant than we might at first think. And even if we said, well, the national rules and the national procedures and institutions are very important, even if we said that, we might still find that transnational institutional structures and procedures and norms operated without regard to national level. And so from a normative perspective, we might be limited by what's happening in practice around the emergence of regimes for which national procedures and national norms are less important. Now, that said, there have, of course, been exercises to try and create more uniformity around rules, for example, relating to contracts and trade. And that process is, I think, not unimportant. But that also, of course, creates norms and process levels above the state. And what I see overall, and might be helpful just to conclude my remarks on this topic, is a form of legal pluralism emerging, in which we have the national alongside the transnational and also alongside the international, with efforts to create more uniform norms. It's part of our role, I think, is to understand, explore, and to map these changes and this emergence of a pluralistic approach to both the norms and procedures. That's one of the key challenges, I think, for global legal studies. Thank you.
Thank you, Professor Scott. I would like to invite Professor Shanta Kumar for my next question. It is a matter of academic curiosity as well as practical relevance to explore how this global system of laws is changing the existing system. Is it directed towards expanding the scope of the existing systems, or is it growing with the intention to encompass all systems of laws, for instance, global administrative law, global constitutionalism, global sports law, or global lex mercatoria, leading to the global system becoming the grand norm that determines relations across the denominations of governance? Professor Shanta Kumar.
Thank you. The outset, I thank Jindal for organizing this very intellectually stimulating summit and with this session on global legal studies. So my special appreciations to Professor Raj and to all the professors there who are organizing this summit. Now coming to this question, if you look at the global system of law, it is so diverse. So we all accept that it's very diverse, and the impact of it is felt in all the domains. And therefore, the academic curiosity, no doubt, it provides areas on which the system can be improved. It is with the research in the legal system, a well-effective global legal system can be achieved. The global system of laws has been revolutionized with the intrusion of governmental and non-governmental international organizations. The impact can be seen in the public and private international law domain. On the one hand, you see organizations like ECOSOC has formulated a strong organizational structure for the protection of human rights based on the Vienna Convention of 1994, ensuring that the nations formulate the Human Rights Act under the domestic law of multiple nations, and has formulated the International Human Rights Commission for providing protection where the state fails. In fact, it is the annual report of the HRC that is, if you look at the annual report, that is the result of research that enables us actually, enables us to point out to the flaws in that system. If you look at the private domain, it is the academic curiosity that has made UNCITRAL formulate the working groups concentrating on different areas, such as the working group on e-commerce and the working group on arbitration, etc. And the UNCTAD has added in formulating the Hamburg and the Rotterdam Conventions on carriage of goods by sea. The UNCITRAL principles on commercial contracting is another example of it. It is therefore, my opinion is that this system is growing with the intention to encompass all the systems of law, leading to a global system becoming the grand norm. So that is my view, and thanks for this opportunity.
Thank you, Professor Shanta Kumar. I would like to invite Professor Shiv Prasad Swaminathan's views on what is the epistemic motive of global legal studies. Is it to harmonize the legal system or clarify the differences and divergences in the legal system?
Thank you very much for that question, Jasmeet. Now, I think that here we should begin with the word epistema itself, the Greek word epistema, from which the term epistemology comes. Now, epistema is something that in Greek philosophy also always related to a science, and it is science that has universalizing ambition. But the law, especially the common law that we have inherited in India, and that Professor Scott has also inherited in Ireland, that has always been regarded as a skill, and that in Greek was called as a techne, which is quite different from an epistema. And when it comes to skill, the mode of cognizing that area is not through scientific knowledge or through rules and norms, but rather tacit knowledge. And tacit knowledge is knowledge that cannot be reduced to the form of rules, norms, and propositions. So there is little surprise here that the civil law, which is spoken of in terms of a science, is understood in terms of norms and rules and codes, and of course the civil law codes are great examples of that, while the common law is not. And the key thing about tacit knowledge is that it is acquired through a form of osmosis. By absorbing culture, it's a form of learning by doing, as it were. And if the law, or at least some systems of law, such as the common law, are largely dominated by tacit knowledge, I think that it must give us pause, because what that means is that here is a system that cannot be that easily understood from afar by a universalist or a globalist epistemology. Now, closer to my own field, so I work in legal theory. And the one thing that we have seen recently is that there has been an explosion of theories in various areas of law, like, for example, contract law, which have these universalist ambitions. So there are scholars sitting in Argentina, Chile, UK, Singapore, Canada, and so on and so forth, who are creating universalist contract theories. These are theories that try to uncover the rationalist structure, the epistemological basis of all of contract law, whatever that means. So these are not theories of any jurisdiction in particular. And so there is definitely something very odd about these theories, because if they are a theory of every place, then they are also a theory of no place. And the law in action, the law in courts, has absolutely no relation to these theories, and this has actually led to a large number of legal theorists calling for a sort of moratorium on this form of theorizing, which fills up volumes but does nothing on the ground. And this reminds me of the words of the Roman poet Horace. Mountains were moved, but they only produced a mouse. And I think that that's one of the biggest challenges in the way of when it comes to the epistemology of global legal studies. Thanks.
Thank you, Professor Shiv. Thank you for the inputs. My next question I would want to ask Professor Mizanor. Is global legal studies an aspirational academic pursuit without any practical significance? Or is it a nascent epistemology meant to transform the way we look at the world? Professor Mezano? I think I might come back to him after later, after some time. So,
sorry, my mic was muted. Sorry.
That's all right.
Sorry. So thanks, Jasmeet, for this question, and thanks for the invitation to speak on this occasion. I will be reflecting on the question. I think I will take the lead from C. Prasad, where he raised the idea of epistemology, which obviously not going by the word strict meaning of the term episteme, which is kind of a knowledge, but it's more about the way of looking, a way of seeing, how we look in a particular phenomenon or in a particular arena, whatever you say. So law as a discipline, I think, is a kind of closed discipline historically or conventionally, where if you look into the theory of Nicholas Luhmann, who actually kind of pointed out that a legal system is a kind of self-contained system. Obviously, there was something that he proposed that it's the systems actually interact. So it's not really that the discipline of law, the legal education, or coming from that kind of dimension, that global legal studies is not simply an aspiration. I think, to kind of, considering historically that law has obviously a very complex, or the legal education obviously has a complex relationship with the practice of law, but somehow, if we look into the meaning of practice, even how law actually changes over a period of time, that is kind of influenced by the practice. What is happening on the ground, that somehow actually influence, somehow actually push for the changes that occur in the discipline of law, or the way we think about the law, or the way we look into how law operates. And the same thing actually happened happening at the global level. When we're looking how actually law operates at the global level, we are seeing increasing interaction between the different legal fields, or if you call soft fields, or different levels. And that's why the idea of the legal pluralism, or the global legal pluralism, so different scholars actually termed this phenomenon, this interaction. So from a point of view of whether it's an aspiration or it's a practical utility of the global legal studies, I think we should focus on the term or the terminology. What does actually the global means? And if the term global means an increasing interaction, and therefore it's an imperative that we should focus on the relationship between the global. And obviously the term global does not simply means big. The global actually is simply a global local interaction, and somehow what happens at the global level, the international level, the transnational level, somehow that affects or kind of interacts what is happening at the local level, and what is happening at the local level, such as if you look into the social movements or the labor movements, what is happening at the local level somehow also kind of translates or kind of interacts or kind of moves kind of bottom up perspective that changes the global law or the way we look into the operation of the law at the global level. So in a sense that I will say that's obviously in one sense academically might be it's an aspiration. Obviously we can we can kind of begin and keep the conversation going. What does the term global means, and what does the term global legal studies means? And obviously there are debates. How to actually think about the global, and it's kind of the complexity of the global, the multifaceted, multi-sided nature of the global, and that obviously translates to global legal studies. global legal studies are going to need to be kind of, need to be opened up for different voices. And coming to that from there, if you look at the practical utility, and obviously we have the aspiration to teach our students in the next generation of lawyers or professionals how to actually think and how to think about the law and how to actually kind of open their mind for thinking more broadly. I mean, if the term global means big and broad, at the same time, it also includes the local, which is small, then how the big and the small, how the global and the local actually interacts, and how that brings a lot of changes that happen at the domestic level, at the regional level, or international level, or even if you use the term transnational level. So it's an aspiration in terms of debate, in terms of conversation, in terms of thinking differently. So that's kind of epistemological excavation, how we actually think about it. At the same time, you also have an imperative to kind of teach our students how to think more broadly, looking into law in a broader, pluralistic perspective. So, thank you.
Thank you, Professor Mizanur. Thank you for your views on this. I would like to invite views from Professor Shanta Kumar. With the increasing challenges of the 21st century, does global legal studies acknowledge the limitations of the current system of laws? Is global legal studies an exploration of how to make inclusivity the norm? Professor Shanta Kumar, can we have your views on this, please?
Can I request you to have the question again?
Yes, please. So I was just asking that with the increasing challenges of the 21st century, does global legal studies acknowledge the limitations of the current system of laws? Is global legal studies an exploration of how to make inclusivity the norm?
See, if we look at the global legal studies, the global legal studies actually looks into an advanced and systematic understanding of specialized subject areas, which affords to an ideal platform for students to acquire expertise and knowledge informed by research-led teaching. So this is an approach. So this global legal studies actually takes a global approach to questions of law and legal regulation. And it includes a comparative research with both the national and international case studies. So therefore, I don't personally feel that this global legal studies movement will be anything away from having an inclusive approach. It will also have an inclusive approach, because having a global approach to questions of law, it includes a comparative approach. And comparative approach, of course, you take cognizance of everything what happens locally, nationally, and globally.
Right. Thank you. Thank you, Professor Shanta Kumar. I would like to invite Professor Scott's views on my next question. That is, in today's day and age, sovereignty of states still holds value. Different countries adopt different approaches when it comes to the participatory character or of its non-state actors. In such a background, how would the global approach be able to accommodate the differences? Professor Scott.
Thank you for the question about sovereignty. So I think that perhaps there are two aspects to the question. Given the variation in the ways that non-state actors are recognized within different legal systems, not simply in terms of participation, but also the mechanisms to give validity to, and to implement legal norms, how could difference between those different approaches be accommodated? But given that non-state actors will act whether or not the global approach accommodates them, it's more important perhaps to recognize the power and importance of non-state actors, firms, associations of firms, but also NGOs. I think this is where the interface with political studies and international relations is very important, to recognize power in quite a number of locations. There are numerous private regimes for setting standards globally, which are non-state and have a loose linkage to the UN. And there are also, as we've heard already, a variety of international regimes, which are, the international regimes, of course, are sometimes talked about as pooling of sovereignty, in the sense of states working together to develop solutions to common problems. But the non-state activity is very difficult to characterize in that way, and does, I think, raise a challenge for traditional conceptions of sovereignty, which can either be used to say that these private actions are illegitimate and raise real democratic challenges, or perhaps call for a different theorization. And I think of John Keene's work on democracy, which looks beyond representative democracy to identify the roles of many different non-state actors in monitoring state activity and in providing alternative to representative democracy. Not that I think representative democracy is over, but rather that it is being complemented perhaps by a range of other actors and mechanisms. And if I could come back and link this to the question about epistemology. We've talked about law as a discipline. I wonder whether law is a discipline or whether it's a field of practice to which legal education is a significant contributor. And if it is a field of practice, of course, it is also a field of study and research. But from a research perspective, law as a field is not just about the articulation of legal norms and processes, but also understanding the wider impact of law and the changing role of law. I think that's where the role of the law and society research, socio-legal research, in projecting law as not just a field of practice, but also a field of study, is really important. And it bears on the question of sovereignty, because from a field of practice point of view, we might be very frustrated by these changes in norms and practices and the impact on sovereignty. But from a field of study, field of research perspective, it opens up an extraordinary range of different legal processes for us to understand from perhaps a perspective of legal pluralism or some other perspective that recognizes the range of different sources of legal power, not just those we've traditionally identified as being from the sovereign states or the pooling of sovereignty through the international.
All right. Thank you, Professor Scott. Very well said. In fact, in the previous question also, you highlighted about legal pluralism, and just trying to link this to what you were saying regarding the sovereignty, and at the same time also being when we consider the role of non-state actors, and when state has not much role to play in there. So I'm coming back to Professor Shiv, and I have a question for you, Professor Shiv, that if global legal studies would help in reimagining or reorganizing the world, then shouldn't the very foundation that needs to be reimagined or reorganized be corrected first?
That's I think that's a very foundational question that goes back to the issues of epistemology that we were exploring previously. And I think that it would be very helpful to actually look at the past in order to see what the future will actually in fact look like. Because even though it was not called as as a globalizing revolution, we have already seen this happen with English law in the 19th century. Very similar epistemological revolution. So until the 19th century, the English law was never taught at universities. So it was always regarded as something to be apprenticed into by reading in chambers or by hanging out in the Inns of Court, having a certain number of dinners, as they used to call it. Now, all of this changed in a kind of a rationalistic fervor that swept 19th century England, starting with Bentham and codification. There was also a parliamentary committee on the reform of legal education in the year 1845. And all of this actually led to the birth of a new form of pedagogy at places like Oxford, Cambridge, London, etc. Now, prior to this, there were hardly any chairs of English law, and I can only think of two chairs of English law before that. One was the Vinerian chair that was set up in the year 1758, that was occupied by Blackstone, and there was one in Cambridge, I think it was the Downing chair. And all of this changed in the 19th century when new chairs were set up in Oxford, Cambridge, London. And Albert, when Dicey's inaugural lecture, even the title of that lecture is extremely instructive, and it has a direct connection to the question you asked just now. So he says, can the English law be taught at universities? That is the title of his lecture. And he does recognize that the English law has always been regarded as a skill or a form of practice, as Professor Scott put it earlier. And he equated the lawyer to a brickmaker who had an expertise in a certain skill. And the question was that what can we offer to this brickmaker? And Dicey said that we professors are actually going to offer you a science, a science that actually underlies your craft. Now, according to many scholars, this actually creates a tension. Like, for example, Michael Loban says that this creates a tension between the lecture room and the courtroom in English law, which is actually still not resolved. Because what this does is that it changes the very epistemological framework of how you in fact look at the law. Because the model that was being given by Dicey was the model of rules and norms, etc., that were borrowed from the civil law world. And it is these very same professors like Dicey who also started writing textbooks where the law was portrayed in the form of rules and exceptions. Incidentally, if you look at Dicey's textbook, even now, Dicey and Morris on private international law, it is still in the form of rules and exceptions, and that actually creates a very misleading impression, because that is not the epistemological structure of the of the law, of the practicing lawyer, and the practicing lawyer knows that this academic form of law is actually far divorced from the reality of the English common law. Let me just give you one other example of this, and that again speaks to the same point of about how do you know the law and the epistemology of the law. So it was at this time that for the first time the need was felt to give a kind of formula for trying to find out the ratio of a case. And the need for this was felt because now suddenly you have transformed your case law into a system of rules where the assumption is that in each case you will also find a rule which is in the ratio of that case. And so if you so if you even go to an elementary book on legal methods, you will find that all of these debates only begin in the 1890s. How do you exactly find the ratio of a case? And quite embarrassingly, you still don't have an answer because of this tension that that the epistemological structure that is being used to actually cognize this underlying practice or discipline itself doesn't actually is not actually suited for that at all. And so I feel that the answer to this, to the question you asked, therefore, is not at all a straightforward one, because I think that these tensions run very deep, and I think that it's not that straightforward to actually resolve these tensions, because the very fundamental nature of these practices is quite different, according to me. Thanks.
Thank you, Professor Shiv. I understand from where you're coming that these tensions are very deep and it's not actually easy. And that's why the need to frame such questions, just to know whether we are able to reach any conclusions. I'm coming back to Professor Mizanur for his views on my next question. That is, a criticism of the global approach is that it results in isolation of disciplines. That is, disciplines have a tendency to divorce themselves from others. And by adopting such an approach for the discipline of law, wouldn't one be moving backward instead of forward towards one's positivistic lineage?
Thanks, Jasmeet, for the question. So I'll go back and kind of start from what I said before, that historically and traditionally, law has been, as a discipline, has been kind of looked as a kind of closed system. It actually kind of sometimes resists, sometimes rejects outside perspectives, outside views. And that somehow kind of contested and changed later with the law and society approach and many other law and approaches that kind of started later. And when you look into in the past 10, 15 years, with the emergence of globalization, suddenly there's a shift from a jurisdiction-based positivistic outlook from there, suddenly there's a sudden change to understand and look into the law as a broader discipline that kind of changed, somehow impacted by the global processes. And if we accept that the term global includes or encompasses multiple voices, is a multi-layered, multi-sided, includes multiple experiences, voices, and conversations, then obviously, if we stick to this positivistic, self-contained, closed a system of thinking, or legal thinking, or the legal system, then definitely we are going back to what we studied, or the foundational understanding of what does the law means and how the law kind of operates within territorial boundaries. Somehow, with the emergence of globalization, there is a kind of not just the deterritorialization of the laws or the legal processes, but there is also a deterritorialization of thinking. So the thinking somehow moved, the legal thinking or the thinking about the law, thinking about the law's functioning, operation somehow kind of moved from the disciplinary boundary to include, to kind of encompass thinking from other disciplines. And not only that, and if you kind of look into the very term global legal studies, which actually came from or borrowed from the global studies itself, and even in that sub-discipline or discipline, or even not even a discipline, the global studies, where many scholars actually talked about decolonizing the global studies. And that also kind of brings us to think about decolonizing legal thinking, not just having a kind of colonized thinking of how law operates, how law functions. And I just want to kind of close this conversation. I mean, my views kind of pointing to William Twining's Montesquieu lecture in 2011 on globalization and legal scholarship, where he actually pointed out that to understand the relationship between law and globalization, that obviously that's the aspiration that we should kind of teach our students the relationship between the global and the legal, requires a kind of also kind of rejecting, resisting, and kind of moving beyond the ethnocentric biases of the Western law. And that obviously, so moving forward, that is a kind of progressive thinking about including multiple voices into the understanding of the global law, the global legal processes. And that also includes voices from the South, somehow, which remain marginalized in the global studies itself, and coming from the global legal thinking. So definitely it kind of moving forward, taking forward the conversation regarding the global legal studies includes moving forward. It's kind of progressing towards something which is unsettled, which is kind of require more thinking.
Thank you, Professor Mizuno. So, I mean, we, as you said, that we're going to move forward to that. And I'm just thinking about the discontinuity in a sense. And for my last question, I'm inviting Professor Shanta Kumar to please address this last question to come from the audience side. That if discontinuity, in a sense, allows for a fresh start, which Professor Mizuno also talked about, what would become of the voices that were previously suppressed? For instance, if the voices or experiences of the third world nations were not taken into consideration in describing international legal history, wouldn't an approach that allows for a fresh start belittle their contribution to history? Also, if the international legal history is not fully representative of all voices, including the third world, on what basis a conclusion can be drawn that there has been a discontinuity to begin with?
Thanks for this question. A very interesting question. If we look at global legal studies, so global legal studies, as rightly pointed out by one of the previous speakers, is a nascent epistemology, which is meant to transform the way we look at the world. It actually focuses on, and it should focus on intersections of global and domestic legal regimes, markets, politics, history, technologies, and cultures. It also should look into the way transnational law shapes and is shaped by the circumstances of its development, application, interpretation, and contestation in a wide variety of contexts. In fact, some of them transcending national borders. In other words, it is an understanding and analysis of domestic involvements in globalization and transnational law. Since globalization and transnationalism, they alter the very meaning of territory in various ways. Therefore, my view is that global legal studies actually looks into the development and transition, including the rule of law, law and development, comparative economic law, trade, sustainable development, human rights, democracy, democracy and governance, including comparative constitutionalism, implementing socio-economic rights, and humanitarianism. Therefore, I personally feel that it is definitely a required academic pursuit with a lot of practical significance, and also to transform the way we look at the legal studies in this world. So this is what I wish to see for this.
Thank you, Professor Shantakumar, for the inputs. So I have one more question from the audience, and I would like to invite the views from Professor Collins. It is pertaining to globalization. Professor Scott, I'm addressing it to you. That in a period of increasing globalization and consequent practice and study of global adjudicatory procedures and legal paradigms, do universalist theories assist in creating efficient normative legal frameworks?
Thanks. Yeah, so there certainly is work to create more efficient legal frameworks. There's work done through, as we've mentioned, the various international bodies, and there are also private endeavors to try and create more effective legal frameworks. Indeed, some of these are based on sort of commercial objectives. You think about in the area of international swaps and derivatives, we see the development of instruments privately to try to get a reasonably universal application of norms to create expectations around contracts that can be common across different jurisdictions, even though they're implemented privately. But I think that aspiration to effective universal norms is really only a small part of what is signaled by global studies. And I think global legal studies, and I think a lot of the opportunity comes from some of the things that have been mentioned by colleagues on the panel here around addressing power, inequalities. And I think one of the opportunities we have is to more effectively link global legal studies to the UN Sustainable Development Goals, and to think about hunger and poverty, to think about gender inequality. Notice we're chaired by you, Professor Gulati, but we're four men talking about these issues, and there's an opportunity for obviously a broader base for a discussion. And then the theme of partnership within the UN Sustainable Development Goals, how we are partnering today for this discussion across boundaries, but how we partner more broadly across disciplines, how we partner institutionally, how we partner with governments, partner with NGOs, partner internationally. There are so many themes in the UN Sustainable Development Goals that I think global legal studies, if it engaged thoroughly with those themes and with other disciplines, could advance the most urgent challenges that we face as a society, as a global society, as has been highlighted around climate, around food security, around peace and security, and wider inequalities. And I think if global legal studies is not addressing those urgent societal challenges, then it is failing as a field of endeavor. And that's the challenge I set for us all, including myself.
Thank you, Professor Scott. Very well said. And with your concluding remarks, where you highlighted the challenges also that we all have to face along with welcoming this new move, which has already set in. And that we have also going to start talking about this as a new discipline of global legal studies. So thank you very much. I would like to take this opportunity to thank all the panelists on behalf of Jindal Global University, Jindal Global Law School, for sparing time for us and giving your inputs, giving your views and your expertise, expert comments for this particular session. I thank you all. And it has been a great learning experience for me as well. So before we leave, I would like to invite Professor Srijit for the concluding remarks. Thank you.
Thank you. Thank you very much to all the distinguished speakers and also to the moderator. Thank you very much. It was a pleasure hosting you and to listen to your wonderful discussions. So audience, please stay connected. We'll be commencing the next session at 4:15 Indian Standard Time. The session is going to be on the revolution of representation, new subjects in law. Until then, goodbye.
Thank you very much.
Hi, my name is Mohsin Alam Bhatt. I'm a professor at Jindal Global Law School, and I'll be moderating this panel in the Global Law School Summit. Our panel is called The Revolution of Representation, and we have some absolutely wonderful panelists joining us today. By way of an overview of what the panel is meant to look at, these are really exciting times for legal education, and law is, simultaneously a highly localized and a universal subject. And law's localization is based on the predominant authority of the state, whose political and institutional processes determine the content and legitimacy of law that we practice and we teach. But law also has a universal form. Modern law, irrespective of which state, is a product of colonial heritage, of transplantation, of borrowing and inspiration. The contemporary moment of globalization emphasizes and potentially transforms these local and universal features. There's a geographical dimension. The teaching of law has to reckon with new jurisdictions and legal regimes, and there are new interactions, conflicts, and synergies. Globalization has also resulted in a thematic expansion and deepening. We have incorporated and perhaps need to further incorporate new substantive areas of law. And in terms of the methodological dimension, there are new modes of teaching that have become more pertinent than ever before. We need to rely on comparative and transnational methods, case studies, nuances towards new, alien, and distant legal cultures. So I would like to explore both the challenges and opportunities posed by these dynamics, and also to whatever extent we can incorporate what has really happened to legal education over the last 2 years and what kind of potential it has for the future. And as we said, we are really lucky to have a wonderful panel with us with a remarkable range of global experience. I'll keep the longer introductions for later, but for now, I would just want to quickly welcome our panelists. So we have with us Professor Jane Aiken, who's the Dean of Wake Forest Law, North Carolina. Professor Purvi Pokharial, who's the founding Dean of the Law School at Forensic Justice and Policy Studies at the National Forensic Sciences University in Gandhinagar in Gujarat in India. And she's just finished her tenure as the head of the Institute of Law at NIRMA. So congratulations. Professor Werner Scholz, who's the head of the Southampton Law School in the UK, and Professor Lutz Christian Wolf, who's the Dean of the Faculty of Law at the Chinese University of Hong Kong. So if I may now move on to the panelists, what we'll do here is we have a very short period of time, just an hour, but the aim is that I'll start off the conversation with questions. I'll frame them quite broadly and really invite the speakers to address both the themes of the panel and also the question in a conversation format. And perhaps depending on time, after a couple of rounds, we can start getting questions and comments from the audience. So let me start with Professor Jane Aiken. And as a way of a slightly longer introduction for the benefit of the audience, Professor Aiken has a wide experience in teaching both doctrinal and clinical courses. She started the Community Justice Project in 2010, which was a clinical project, when she was the Vice Dean at Georgetown University Law Center. And she's a wonderful example of a global legal academic, much like everybody else on our panel. She's quite familiar with our region. She was in Nepal in 2001, 2002 as the Fulbright Scholar. So coming to you, Professor Aiken, I wanted to ask you about the question of clinical legal education and how clinical legal education itself is transforming, can be institutionalized better. And let me sort of frame the question as following. To what extent do you think clinical legal education both needs institutionalization, but also diversification from within? What are the challenges of representation and diversification when it comes to clinical education?
I think that's a very important topic when we're talking about the challenges to legal education. And as many of you know, the American Bar Association now requires 6 credits of experiential education to accredit law schools in the United States, which is the largest number of credits that are actually required. That has really opened the door to a lot of expansion of our notion of clinical education in the form of experiential education. And I think, we've always had challenges, for example, for global clinics. And the size of clinics when you're doing direct representation means that a lot of students don't get that opportunity. I think one of the expansions that are happening that is exciting, that is now coming into being, is the concept of complex simulations, which allow you to do international collaboration in which parties play roles in a complex simulation and have to deal with the kind of concerns that are front and center for most law schools right now around environmental sustainability, civil rights, criminal law, those kinds of things that give students an immersive experience in which they can see themselves in action and get feedback on how they proceed. So I'm very excited both about the growth of real client clinics, but also new forms of simulation and experiential education that will broaden the number of students who are exposed.
Thank you, Professor Ekin. Before I come to Professor Bokharia, I just wanted to, on that point, get Professor Scholz in it. Again, for the audience, Professor Scholz has a wide experience and expertise in environment law, including setting up the Global Environmental Law Center in 2020 in the University of Western Cape in South Africa. So to Professor Scholz, on this question of both clinical legal education and more like a transnational project of getting students and schools from different parts of the world together, environment and climate change in particular seems to be quite a powerful programmatic focus. What have your experiences been in bringing all these different institutions together under that particular programmatic mold? And what kind of opportunities exist for the future?
Thank you very much for the question. Obviously, you've mentioned the fact that there's a local element, national element to law. But obviously, in terms of the discussion that we have here today, the issue of global norms are extremely important. And I think it hasn't, so that the drive of contemporary normative questions, which are frequently global. And you've just mentioned environmental law as one of the, I think, most opportune subjects in order to facilitate a form of global law clinics. So I think that is a very important thing in order to ensure that in the context of the shared global questions, that there's a case made out for global clinical education, where there's a need for a global reach. That's the one, I think, very important thing in order to ensure that we expose our students to global norms. We have a guild-like profession, which, of course, where we have regulatory authorities that to an extent determine the curriculum. But I do think clinical legal education in terms of this sort of the global shared problems that we have can be really important in order to expose our students and provide them with flexibility and understanding of global norms. So there needs to be a commitment to legal education and reform in order to ensure that we have a social justice mission, I think, as well. And clinical legal education, global clinical legal education can actually provide that driver. And then, of course, there's an opportunity in this instance for clinical law teachers to collaborate in sort of to set up or to establish a network of to an extent, a global movement in clinical schools. And I think these new substantive areas in law provide interesting points of facilitation and cooperation in order to pursue these matters where we previously, to an extent, focused on the more national areas, especially in terms of clinical legal education. So I think it's a very opportune moment in order to pursue these issues. And I also think there are certain other substantive areas in law, such as, for instance, global animal law, where we can use global clinical legal education movements in order to facilitate or in order to ensure that we have collaboration and expose our students to these global norms.
Thank you. To you, Professor Bokharia, again, for the audience, you've had wide academic background in areas of law and political process, gender and criminal law, intellectual property law, and of course, legal education. And we know that you're a keen supporter of the clinical legal education in India, and you've contributed in various capacities and in various institutions. Again, sticking to the theme of clinical legal education for this part of the conversation, how do you think we in India can further improve both institutionalization of clinical legal education? What are the specific problems that we are facing? Because this has been part of a long effort to try and institutionalize clinical legal education. And from my little experience, it seems that we still don't have a clear model. And in addition to that, now we have additional challenges. We've had 2 years of COVID, but also emergence of new focus areas. So both in terms of the practical institutional question, as well as the substantive question of adding more focus areas, I'd be curious to know what your thoughts are.
Thank you for asking these questions, because as a legal educationist, we have been deliberating about various models and how to make these models more successful and relevant in terms of the Indian legal environment that we have been deliberating at various forums. So I would say that when it comes to the clinical legal education model for India, it is in search of its identity, because India is as diverse as we know in all these focus areas. The same way, the clinical legal education is very diverse, the way in which it is being operated by different law schools. But when it comes to the institutionalizing of the clinical legal education, probably the most important task that we are yet to do is pertaining to the incorporating in the curriculum, as Jane has rightly pointed out, how do we make a credit-based clinical legal education program, credit-based clinics. So most of the law schools in India, probably they do not have a right kind of human resources, the right kind of intellectual resources in terms of the training, the clinical professors who are being specialized in this area. And probably we probably may not have enough time. Look at the whole legal education curriculum is so heavily loaded. We teach almost 30 credits in a semester, and the semester has to be over in 90 days. Now, how do we justify this around 25 to 30 credits? And then when it comes to the clinical legal education, and specifically the clinic part, it requires tremendous amounts of the efforts in terms of the planning, in terms of the exploration, in terms of the intellectual resources, training resources. So probably these are some of the issues which every clinic teacher, I would say, at every law schools in India is struggling. And there has been a series of meeting and the academic forums with the principals, with the directors, with the dean, with the management, but still we are not able to come out with very unique model which can be a role model for other law schools to follow. I'm very fortunate to understand that Jindal Global Law School is taking a lead in this as well. I had happened to meet Professor Deepika a few days back, and the way in which you are trying to come out with the clinical legal education model, we can create a benchmark with standard operating procedures to follow, so that the other law school can get benefit out of it. So we are in search of its own identity when it comes to the clinical legal education model for India.
Thank you, Professor Pokharial. I wanted to move on to Professor Wolf and now sort of broadening the debate a bit more, because one of the things I reckon we need to take quite seriously is the changing global context, both in terms of the technological aspect, but also normative aspect. And through that, I wanted to basically ask Professor Wolf, but before, for the audience, Professor Wolf has a compelling transnational experience in legal education. He's written on commercial law, and also quite extensively on legal pedagogy. Professor Wolf, my question was that obviously, globalization is not something new. Even globalization of the last 2 centuries was sort of a shift in the way globalization perhaps happened, but globalization is part of the human condition, perhaps. How would you understand the current moment of globalization? Are we witnessing something new? Particularly what I'm thinking about is the fate of the global legal order. And is there something to be said about the altering globalization context with respect to that normative order? And if it is that something that should inform the way we think about not just clinical education, but legal education in a broader sense? I don't want to use the word crisis yet, but I hope you do address that too.
Thank you very much. That's of course a very, very broad topic. I would try to make 3 points. First of all, the global legal order is of course changing because we see new players emerging, and these new players try to introduce new rules, and that of course will lead to changes, substantive changes, procedural changes, and these need to be addressed. I don't see that as a crisis because it's just a normal and natural development. The second point I would like to make is that's really a crisis, and that is issues like climate change, which need to be addressed, which have been mentioned earlier. These now take or should take top position in our the points that we need to address in legal education and elsewhere. So here is something mankind need to address, and legal education needs to follow. Let me add 2 points. I said 3 points earlier, but probably it's 4 points. The second point is, of course, COVID, which is changing legal education. We are all now trained in providing legal education online, and that will, in the long run, substantively affect the way how we think about legal education and the way how we deliver legal education. I think we were all surprised how well all this worked out in the end, but it will change the way how we approach legal education. The last point I want to make is something you mentioned, I think, in a half sentence, and that's technology, legal technologies. I think we need to be aware of the fact that legal practice is changing at a dramatic pace, that legal technologies are becoming part of legal work around the globe. And at the moment, this is hardly addressed in legal education to the extent that it should be addressed. So that, I think, will be a major, major shift, a paradigm shift in legal practice, but also legal education, of course, has to follow. We need to respond. We need to train our students to be able to cope with these challenges. There are predictions that in 30 years, half of the legal jobs will get killed by legal technologies, by the use of legal technologies. I don't believe that we won't have lawyers in the future, but we need different lawyers. And these lawyers need to address all these points that I've just made. They need to be able to address the changing global order. They need to deal with those urgent issues like climate change. They need to be able to deal with the technological challenges that we are facing.
Thank you, Professor Wolf. I wanted to take one theme which you picked up, which is the question of technology, and also sort of a closer institutional synergy potentially that is emerging in different law schools in different parts of the world, because we share certain common global challenges. And take that to Professor Ekin. Professor Ekin, you had mentioned this notion of complex simulations, but even looking at it from outside the strict contours of clinical legal education, how do you think, in very practical institutional terms, can we generate these complex simulations or collaborations across continents? In your experience, what have been the challenges, very practical challenges, and what can institutions across the world do to come together in very practical ways, institutional ways, to overcome those challenges? Because I imagine you would think that much more needs to happen in creating these sort of common programmatic collaborations and pedagogical ones.
Thank you. I think that's an incredibly important question, and there's a precursor to when being able to have these kind of collaborations, and that is that all law schools should help our students understand that law is global and increasingly global. And for the US, for example, after what Professor Wolf was pointing to, there is a reordering that is happening, and the US used to be on top of everything, and we are no longer. And that changes the need in the US to make more partnerships across the world, and to look to the world to tell us how things are changing in many ways and help us out of what has become in the United States a real skepticism about law. Okay, so the first question is, how do we make sure our students understand that? Once they understand that, the incentive to be involved in clinical and experiential education that has global context becomes completely obvious. So that's one thing that I think we have to do in legal education, is to broaden our field in ways that isn't just dabbling in global law, but rather understanding that we have to do this. And I think once we do that, we will have a demand. And what we've learned is, of course, that as students raise demands for more experiential and clinical education, law schools are required to provide it. And frankly, we have known for a long time that the learning that comes from the experience is far more powerful. Now, the biggest challenge, I think, building those collaborations is common language. That is an issue for all of us, I think, in many ways. How do you make a partnership with an Eastern European country, for example, where there's very few people who speak those languages? So that's an issue. But the other issues are time. You know, it's very early in the morning for me. So partnering with your law school would be a commitment for all of us. There are those kind of practical realities that just have to be worked out. The beauty of a simulation as opposed to a direct client is that you can do those in different time zones and then come together at a common time for the interactions across our borders.
Thank you. Professor Pokhriyal, one of the things which Professor Wolf mentioned was the changing nature of the demand, the professional market itself. I imagine that for many legal systems, it used to be a relatively straightforward question about what to teach students because we knew how the market would behave. There's been, particularly in India over the last 3 decades, but I'm sure in numerous other economies, perhaps at the first level, an expansion of the kind of legal expertise you need, and now the opposite, which is what Professor Wolf said, perhaps a drying up over the next many years or decades of legal expertise by all sorts of technologies. Both looking at the Indian context, but global as well, but Indian would help our audience too. How are people like you who are leading institutions thinking about those challenges of the changing economy and changing mode of production of intellectual resources when it comes to legal education? And what kind of diversity of subjects, of methodologies and pedagogies do you think are needed or will be needed tomorrow to make our students better prepared?
Thank you for asking these questions, because the kind of an experimentation that I'm doing with my law school as of now at National Forensic Sciences University, which is we have a 5-year integrated program with data analytics and law. So, in a sense that we do teach a course like data mining, deep learning, machine learning, artificial intelligence, math, statistics, programming. So because this is a very ambitious kind of a program that we have introduced and probably one of its kind in India, so far my knowledge goes. So this is what we could see that 10 years down the line, as Professor Wolf has rightly pointed out, we are going to we need a different lawyers with a different kind of skill sets. So because what we are observing today, datafication of every human activity, and data footprint is so huge. So how do we prepare the lawyers who are being able to integrate the data analytics skills in and bringing that knowledge in the legal professions. And how do they study the pattern that is evolving through different datas that we are witnessing, and how do this data analytics is helping law, legal system, and policymakers in a longer way to go. So 10, 20 years down the line, we need lawyers with these kind of skills that what you have realized, and we have tried to experimented with this data analytics and law program, wherein the students are not exposed to any kind of a political theory and sociology in detail to begin with in the pre-law, what we call in the Indian law schools, but they are being exposed to mathematics, statistics, machine learning, programming, and these kind of courses. And and everyone, I've seen and I've been reviewing the curriculum of most of the law schools in India. I think everyone has more or less realized the importance of the integration of the evolving technology with law, and how the artificial intelligence and the machine learning is going to shape the legal profession 10 years, 20 years down the line, and how we are gearing up as an academicians, as a law school, with reference to the knowledge base, with reference to their understanding, and with reference to the kind of a new range of skills that is going to be in demand. So almost everyone has realized more or less, and they have been trying to map up their curriculum with reference to these evolving skills, the evolving demand market with reference to the legal professions, and this is precisely what we have been observing in the globally across many law schools. And I have seen that everyone has now started thinking about, as Professor Akin has also said, we are rethinking and reordering the pedagogy, our curriculum, our courses, and our approach towards the legal education.
Thank you, Professor Pokhriyal. I wanted to come to Professor Schultz. One of the interesting things which Professor Akin said was that with the changing world, the people in the US are looking for collaborations. I imagine that goes for most other places as well. And with your experience working in multiple continents, in Africa and the UK and Europe, Europe being arguably two separate or the same continent, let me sort of frame the question rather broadly. Do we still have centers of legal education in the world? Or have we approached a moment of globalization or a moment of history where we can't think of centers anymore? And does that change the way people in different continents think about the discipline of law and what needs to go into collaborating in other places? I think we would particularly be interested to know how you, for instance, have set up centers in South Africa. You're engaging with Africa, also in the UK. How do those things work at a practical level, but also at the level of ideas? Where's the center and where's the periphery?
Thank you very much. As I've mentioned previously, the contemporary normative questions are indeed, to an extent, frequently global, and that has driven our collaboration. But there are certain important nuances to also take cognizance of, obviously. So I think the important thing is obviously that our legal education, as I've mentioned, is tied up to certain jurisdictions, and there's globalization challenges this insulation. The call for this globalization of the curriculum, but also internationalization in response to globalization at law schools, I think have been quite successful in certain areas. And that raises some interesting questions. The emergence of so-called global law schools, Jindal is obviously one of the global law schools, and the League of Global Law Schools, where there's a clear understanding of the importance of global norms and the necessity to equip students with understanding of global norms. So I think there's some difference between the emergence of global law schools and perhaps the response of internationalization in terms of maybe the global south. And that raises some interesting issues in terms of elitism, I think, to an extent, the availability of resources to respond to globalization. That has said, these factors obviously have an impact on the nature of collaboration between the global north and the global south. So I think those are some of the important issues that one needs to take cognizance of in this endeavor to pursue collaboration. So I think to an extent, there could be still a construct of the center in the sense that there may be, well, an emergence of the issue of the availability of resources for certain global law schools that are able to respond maybe more meaningful to the needs of and requirements of globalization and the way in which it's been done through internationalization. So I think there are certain important questions here that one would need to address in this context, as I've mentioned, especially in terms of elitism and the issue of the relationship between the global north and the global south. So I think there are certain important aspects to focus on. The importance, obviously, is to provide students with knowledge beyond the traditional confines of legal education and to develop this global mindset of students within a local context, obviously, and any response, obviously, to our profession, which to an extent still has a very strong focus on equipping students with skills to enter the legal profession in a certain jurisdiction.
Thank you. Professor Wolf, I wanted to invite you to perhaps reflect a bit more about part of your last comment, which was about the change in the mode of teaching, the online mode. What impact do you think the technologies that perhaps as a silver lining of the last 2 years of virtual teaching, what has that thrown up in your assessment in terms of opportunities? Now, one curiosity I personally have is, has the experience of the last 2 years shown that physical universities, physical classrooms are actually not that important anymore? Or perhaps that physical classrooms or physical gatherings may be better used in a different form? Does that, as a technological matter and a pedagogical matter, throw up something new or something interesting? And would you be concerned about some of the consequences of that if that is adopted at a mass scale?
Thank you for the question. If you see me moving around in strange ways, this is because my computer strangely tells me that the battery is low and I don't understand why. So if I disappear in a minute, I will reappear on a different screen. Apologies for this. Getting to your question, there was some discussion about half a year ago that in about 10 years' time, globally, there will only be 3 to 5 law schools left because they will teach everything online. They will work with partners in different parts of the world, and it would no longer be necessary to have local law schools because you can teach law through the internet everywhere and at every point.
I think Professor Wolf's prediction came true. In fact, in any case, intended to take the same question to Professor Aikens. So let me just do that, and then Professor Wolf can step in later. Professor Aikens, again, the question of both imagination of legal education after 2 years of COVID and technology, and what are the things which are promising and what are the things that are concerning?
Well, I actually take a different point from Professor Wolf, and that is, yes, we have more opportunity, I think, for conversations like this, which is wonderful, where we can actually see one another and have full conversations. That's great. But in legal education, the fact that we have enhanced technology and that will do a lot of the substantive work that lawyers do, that it can tell you everything you need to know about a subject matter. It can write a brief. It can evaluate depositions. It can do so much that lawyers typically did and that we typically educated them to do. But what they haven't taught you are human skills. And those are becoming much more valuable in order to know, what does a client need? What legal technology should we be using? What data that it should be useful to us, and when should we be skeptical of data? What kind of judgments and leadership is needed in this situation? And those are definitely benefited by interpersonal communication, face-to-face, person-to-person, and not through this medium. And so I'm a believer that the last 2 years have only reinforced our need for interpersonal face-to-face interactions. The one thing that I have learned the most is that so much of our decision-making as lawyers and as human beings is through informal conversations, informal decision-making. That does not happen in this setting. And those are critical to legal education.
Right. Thank you, Professor Ekin. I wanted to ask Professor Pokhriyal a related question. So one obviously is a question of skills. The other is a problem of equity. And that seems to me to have been an important concern over the last year and a half or two with online teaching and resources available to some students and not the other. Now, these questions of justice and equity were anyway rather perennial in our countries. In India and of course in other places as well. Do you think that, do you first of all think that the last 2 years may determine how legal education or education even outside, legal education is not an island, may evolve in India and perhaps in other places? And secondly, does that, in your view, raise concerns about equity apart from questions of skill, which Professor Ekin has mentioned?
Yes, I do agree that it raises a serious concerns of equity. But at the same point in time, I also would like to look at this situation as an opportunity. I have seen, and many of us might have observed in the rural part of India, where internet connectivity is a problem, bandwidth is a problem, but how some of the students and some of the very sincere students could face all the obstacles, could struggle with, and still they were continued with their studies. So, at that point in time, probably how can we bring the institutional social responsibility or the corporate social responsibility into questions that, can we devise some kind of a mechanism wherein we can create some kind of a public utility centers for online educations wherein these students who are not being able to access the internet, that may be made freely available, of course, with all kind of a COVID protocols and things like that, with all SOPs and all. But then we have to come forward with some kind of an institutional mechanism wherein we can create this kind of a centers of learning for them at every nook and corner, at every place, at the remotest place part of the country, so that the issues of access can be, to some extent, can be tackled with. But at the same point in time, I would always feel that every problem, this kind of a situation gives a lot of opportunity for us to evolve. And as a human being, as a learner, and I could see that, I have seen, many of you must also seen that, the small kids, even, the school-going kids, from a very poor background and the rural strata, now they could have their, handset, a smartphone, and they were trying to learn a lot of new things. So, COVID has really, the pandemic had a lot of suffering, but also has also given a lot of positivity in terms of these kind of an evolving as a learner. That's what I believe. The other thing is that what I always feel, apart from the issue of equity, it gives a lot of autonomy to an adult learner to learn at its own pace and at its own time, because especially the country like India, wherein the higher education system is very much regulated. Sometimes we can say that it is over-regulated, with everything with reference to the strict attendance rules and with reference to a lot of, what to teach and how to teach, and only you have to attend these professors' class, and not much liberty and autonomy that lies with the learners when it comes to the Indian higher education. But thanks to COVID, I feel that, the COVID could give that autonomy and freedom to learners to learn at their own pace. So, there is always a better side of every story. That's what I could see.
Thank you for pointing that out. I want to take the same question to Professor Schultz as well. The question of technology and pedagogy and promises and perils, so to say. If you may like to add something to this.
Thank you. I think my colleagues have really raised some important issues which I'd like to concur with. I'd just like to mention that I do think that the uncertainty of the pandemic has provided us with, in addition, opportunities to be innovative and creative in terms of pedagogical methods. I think it has also provided us with a mindset of agility, and that is something that I find very advantageous. It has created considerable suffering, as my colleagues have mentioned, but I do think it's possible to sort of distill lessons and optimize those lessons in future. So I think the one thing that I found quite interesting was, on the one hand, it provided opportunity, or it enhanced actually equality, diversity, and inclusion through access to online learning. On the other hand, obviously, there's the issue of access to internet in the global south, in certain African countries, and the need for supportive measures in order to ensure equity. So it is also, I think the picture is also one of, to an extent, a discrepancy between different continents and countries. But I do think the opportunities offered are quite interesting. And the one thing that we've learned from this at our law school is also to establish and develop online distance learning, not to replace interaction in-person learning, because that's one important thing that we've also learned. Students want to have in-person learning and that on-campus experience, and it's extremely important to have that interaction. But there's the opportunity to complement your educational offering in order to enhance equality, diversity, inclusion, with supportive measures to pursue equity through, for instance, online distance learning for part-time students who do not have the availability or opportunity to attend in-person learning. And I think also, of course, as a response to COVID, where we can then offer that to international students. I think that's important, but also to consider some other aspects that we've learned from this, such as the presentation of, focusing on more MOOCs and so forth. So I do think the pandemic has provided us with not only with suffering, but also an opportunity, or opportunities, maybe.
Thank you. We have Professor Wolf, who's connected again. Sorry for the technical issues. Professor Wolf, I would like you to finish your thoughts. You were talking about, I think your comment ended at a rather dramatic moment when you said the world will only have 2 or 3 law schools. And I was really curious, what was to follow?
Yeah, apologies for this. It was quite funny that I was talking about the challenges and the future of online teaching, and then my connection disappears. What I wanted to say is that I don't believe that we will see a concentration of law schools simply due to the ability that we now all have to teach online. I think there were 2 things. One, I think there's still a lot of room for local teaching, for diversity in teaching, for localized teaching rather than just global teaching. That's the first point. And the second point is that we here in Hong Kong have moved back to face-to-face teaching. And despite all the advantages and the convenience that online teaching provides, everybody in my faculty agrees that face-to-face teaching from a pedagogical point of view is the much better option. Therefore, I believe we will be able to use those abilities, online abilities that we have acquired, but the predominant way of teaching law and teaching other subjects will still be face-to-face if this is possible again once the pandemic is behind us.
Thank you, Professor Wolf. I have a few questions from the audience, and there were 2 I wanted to pose for the panel. The first question is about the burdens on law students. I'll just read out the question. What are the panel's views on the ever-increasing subject choices and consequent burdens on today's law students, specifically in terms of balancing core law subjects with the ever-increasing numbers of new age legal subjects? How should students balance the need for specialized study while avoiding early or ill-timed over-specialization? So I think there are 2 different questions here. One is a question of overburdening. The other is a question of sort of the way in which specialization is integrated in legal education. So perhaps let me come to Professor Ekin, if she could take up either both or one question, and then I would also request other panelists to answer.
I do think students are feeling a bit overwhelmed. And part of it is the very questions you've been asking. Where is legal education heading? Where is the legal market heading? What kind of role will lawyers play in the future? And it has put, I believe it has rightly put more pressure on legal education to determine what is the most important thing for our students to know, and especially provide them with a frame of what are we really looking at, and not divided into all these specializations, but rather what are we preparing you for? What is going to be, how do you leave law school more prepared for what's going to happen in 10 years than you are now? And unless we provide them guidance in that way, unless we really engage those questions, I think we've disserved these students, because it is overwhelming.
Professor Pokharial, would you like to take these questions?
Well, I do agree that this pandemic really is taking a toll when it comes to the experiential education. But at the same point in time, and specifically with reference to the Indian legal education system, I would say we hardly get a time to reflect upon what we are doing and how much we are teaching and what kind of a burden that we are giving to the students. So probably again, I would like to say that, you know, this pandemic has given a right amount of time to reflect upon our efforts, what we have been doing, and, you know, how much we are teaching and what is so relevant about whatever we are offering. So this kind of a reflective exercises on the part of the academicians, because they cannot teach everything online, would definitely give them a new kind of a directions to decide upon what is so important, what is vital in terms of the knowledge, in terms of the content, in terms of the skill part, in terms of some kind of an affective domain of their development. So, you know, how do we strike a balance between this, and how do we take this opportunity to turn them and learn them for the self-directed learning process? Because learning to learn is one of the very important skills that probably we not exposed to our students, and this pandemic gives us a lot of time to reflect upon engaging the students about learning to learn few things at their own and reflect upon about their learning.
Thank you. Professor Schultz, I wanted to come to you with the question of specialization or over-specialization. Perhaps reframing the question a tiny bit. Now, we are looking at, and I think one theme that is coming out in our conversation is proliferation of the range of issues and subjects that have to be taught. There's also a certain sense of dislocation, perhaps Professor Ecken didn't use that word, but a sense of alienation or a sense of uncertainty as well. So there is obviously a need for adding or proliferating the range of issues, a range of subjects, but that cannot be done. And there's obviously always a problem of hyper or super specialization. I suspect the way to respond to it could be to change the way we teach our existing courses, how our contracts law and our tort law, or how any of our standard traditional core courses are taught. Where do you agree? And if no, then why? And if so, how can that happen? Because that also requires the teachers to have completely different kinds of skills, that when they are teaching tort law, they should not only have a geographic sort of breadth, but they should also have a sense of, you know, what does the indigenous legal systems think about this particular issue? What do sort of a whole range of different kinds of legal institutional contexts allow us to think about these issues?
Thank you. I think this is a very difficult question and something that we've struggled with. It's a very laden question. Remember, I would also like to respond to some of the previous comments in relation to the questions you just asked, because we've recently struggled with it at the law school that I'm currently working at, due to the fact that there was a new, where it's a post-so-called SQE landscape, the new regulatory authority in terms of becoming a solicitor or barrister. So there's I think on the one hand, a considerable tension between, as I've mentioned, the link with the jurisdiction, on the one hand, sort of the need for to focus on the national subjects, the core subjects, And then the question, obviously, what are the core subjects and what are the reasons for having those core subjects? So I think that's a critical approach is very important. And then on one hand, the issue of the global requirements, and there's that tension, obviously, because there are also issues of employability that are important. We need to provide our students with a skill set in order to be employable and job ready and to meet requirements of the guild-like profession. So I think there are really difficult issues here at play. I think you've just mentioned the fact that there's a need for lecturers to also have a balance in terms of all those aspects, to be able to teach those core subjects, which are predominantly national, but also to have that sort of global perspective. So, and I think the danger is not only to overburden students, but also to overburden lecturers. And I think there also needs to be some realism in this instance. We are currently in the process of revalidating our LLB, and these are the questions that we've asked, and it's extremely difficult to find a balance, I think. I do, however, think that there's a very important issue, and that is obviously to ensure that we focus on, and I think one of the previous colleagues actually mentioned it, the focus on providing students with a certain critical mindset. That is very important. I think that is the predominant issue here, and also to then respond to the market and employability and so forth. But I do think that the issue of globalization can then augment knowledge and can also assist lecturers as well as students in order to be responsive to the needs for flexibility, and they need to have a global outlook, and also in order to be employable in terms of the needs of global firms. So it's a very difficult thing, whether I think we need to balance all these requirements that we currently face with the need for specialization. And what we've done to extent is to recognize that we still need to provide our students with core subjects. We still need to provide our students with certain legal skills for the national jurisdiction, but to augment that with an internationalization strategy through a provision of a set of options such as global environmental law, animal law, and so forth. So I think it's a very difficult issue, but I think there needs to be a realization of the predominant sort of requirements of legal education, that is that specific critical mindset, and maybe also a form of, I think, humane education that helps students develop skills of respect, of critical thinking skills, and also empathy and compassion.
Thank you, Professor Scholz. I want to take the same question to Professor Wolf. Perhaps also, I'm particularly curious about the issue of the lecturers and the so-called suppliers of legal education. So how do we deal with that institutional challenge of obviously making the legal pedagogical system responsive to the needs of the students and the market, but also respectful to the education provider, respectful to the character or the nature of the classroom itself, and empowering the lecturers and teachers as well as the students?
Thank you. I would like to start with saying that I agree with everything my colleagues have just said. I would like to rephrase it a little bit, and I think this addresses the student side and the lecturer side. We need to reflect and we need to see what are the goals of our teaching. And the goals of our teaching, as Professor Scholz mentioned, is to develop, to create critical, innovative, solution-oriented legal thinkers. That is, I think, our goal. And for that purpose, we cannot teach everything, but we can teach, we cannot teach legal answers, every legal answer, but we can teach our students how to develop these answers. And this ability, I think, is core and must be core of any legal education concept. You can teach, as my former, our founding dean once mentioned, you can teach the law of banana, which would then allow you to show what the principles of law are. And you can then instill in students the ability to translate, to transfer these skills, that knowledge to other areas. So I think we need to cut down a little bit on what we are trying to teach, and we need to become aware, or we need to remind ourselves that if we are able to create students who are able to apply principles and have actually studied those principles, and that have acquired, students that have acquired core skills, these core skills can, and these general principles can be transferred from one area to another. And I think that also answers the question whether or not we need specializations and how much specialization we need. We can teach, we can allow our students to work towards particular specializations, but at the same time, we must ensure that what they are learning is transferable knowledge between different subjects at local level, and also from the local level to global level, and vice versa.
Great. I have another question from the audience, but I am really tempted to throw in what I believe, in my head at least, is the elephant in the room, and that's, we haven't talked about the government or the state. And there was one thing that Professor Eken had mentioned earlier, which didn't explicitly mention the state, but mentioned in the background the nature of politics that our law schools and legal education currently exist in. She mentioned that there's a skepticism towards law, and I think that's a lot to do with the global climate and the local challenges, socio-political challenges. So what I wanted to ask everybody to reflect a bit about, and that would give the audience a sense of what all of you are thinking globally about these matters, is what do we expect the state and what do we expect the government to do in order to assist in precisely the kind of policies or conversations we are having today on the panel? Does that require a different conceptualization of government support or state's role? Or is it fine for the state to work as it has when it comes to legal education or the law university? So Professor Eken, I wanted you to reflect a bit on that. And say, for example, one of the questions which always bother me is the question of loans and the student indebtedness. Obviously, that has a relationship with what diversity or representation of subjects and possibilities of the legal profession in the future can happen. We can't forget about that. So perhaps reflecting a bit about that, but also more generally about the role of the state in supporting diversity and greater representation in our legal education today.
It's an incredibly important question, and I think in the US we're engaging it more and more as we see the courts fail and our government fail to address significant issues around human rights. Ironically, we're talking about global education, and as I'm developing the curriculum at Wake Forest University, I'm developing a more state and local curriculum, because that is the only place where we see change happening. I think those skill sets that we're developing that challenge, that really rethinks the state in a much more localized community way are transferable internationally. But that is an area where we're really seeing that as the only avenue for teaching our students to make change. That's the first part of what you asked. The second part about financials is that that's something we've all been dealing with for a very long time, the degree to which we only educate elites. And as long as you're only educating elites, you're probably fueling a state that is causing harm, in the US at least, by just populating it with people who've been trained in law who are also elite. I do believe that we have done a better job that has not been known in creating loan forgiveness for people who work in the public interest by giving income-based repayment for loans, federal loans, and that can actually diversify the profession. But we haven't really spent a lot of time educating students about how they can come to law school and not find themselves overwhelmed with debt.
Thank you, Professor Eken. We just have a minute, and I just wanted to give the last few words to each of our speakers. Professor Pokhriyal, just a few sentences on precisely this theme about legal educational reform and curriculum reform. Any last comments you may have? Perhaps even the role of the state?
Yes, I do agree that we need to sensitize. I would like to use the word sensitize the government and the policymakers to increase the diversity in the law schools, because India is again the kind of a diverse country, and we have a diverse legal needs. The legal needs of every strata of the society, the legal needs of the village may be very different than the needs of a person in an urban area. So, how do we cater to this unless and until we empower the community themselves by increasing their access to the legal education? So we need to have some sort of a research, and research should carry out some kind of recommendations for the direction in this regard. And we need to influence the policymakers to come forward with some kind of positive, affirmative policies in this regard.
Thank you, Professor Pokhriyal. I've just realized we are completely out of time, so I'll have to apologize to the panelists for not extending the last comments to everybody. But thank you so much. This was a really wonderful, illuminating conversation. There were so many other questions and so many other thoughts, but hopefully we'll have those offline. So have a wonderful day, night, afternoon, depending on which time zone you are in. And thank you so much for joining. And thank you to all the audience members for logging in. Over to you, Srijit.
Thank you to all the distinguished speakers and also to the moderator. That was a very interesting session. When we conceptualized this section, this particular session, our idea was that we would like to hear the stories of how we reorganized our own disciplines from the fragments due to the fall of the modernity. And you have not only narrated that tale, you have also told about how you have reorganized legal education as we reorganized our own respective disciplines. That was absolutely fascinating. So I request the audience to please stay online. Our next session will commence in 15 minutes, and that's going to be Touching the Constants, Renewalism in Black Letter Law. So please stay tuned, and thank you very much, everyone. Yeah, Vidyut, something happened and he got logged out.
Yes, sir.
Maybe he might have made some wrong clicks. It looks like that. So we'll wait for him to rejoin because he's a moderator. There's no other way we could have started. We are online.
We are live, sir. Okay, thank you. Welcome, everyone. My name is Oishik Sharkar. I teach at the Jindal Global Law School. And welcome to the third day of the Global Law School Summit. This is a particularly exciting session titled Touching the Constants, Renewalism in Black Letter Law. I will introduce our very distinguished panel of speakers in a few seconds. But before that, I want to give you a very quick introduction to the theme of the panel. As we know, and as the discussions in the summit has borne out quite compellingly, that legal education, irrespective of its jurisdictional location, hasn't been untouched by the tectonic changes that have been brought in by globalization. And it isn't a contemporary phenomena any longer. It has in fact become a historical phenomena of law being responsive to changes that are taking place the world over. And these changes are not only changes concerning the way in which we generally think about globalization in terms of the economic opening up of borders to capital, but also both the celebratory as well as the tragedy-laden movement of peoples and ideas as well. The provocation that this panel places before us is to actually negotiate between holding a place that remains committed to a historical moment while at the same time remaining future-facing. We would sometimes tend to think about black letter law as the foundational element that enables us to build an idea of law, legal theory, or jurisprudence, while at the same time, we do have legal scholars who would think about black letter law or holding on to black letter law as a particularly conservative way of thinking about law or legal theory. Now, what does one do at a time where change is the constant, where we are constantly trying to re-energize law to respond to global shifts, be they cultural, economic, or political? Is there some worth in holding on to the historical significance of black letter law? Is it merely a conservative move to look backwards? Or is there something to be gained from a commitment to a historical vision in law that takes the black letter law seriously? And we're not necessarily proposing that it's an either or approach that can help us when we think about black letter law from our place, wherever that might be, given that our speakers are quite variedly situated in different parts of the world. So that's broadly the provocation offered by the theme. And to respond to this provocation, we have three distinguished speakers. I'm told that our fourth speaker, Mr. Nitin Rai, is unfortunately not able to join us. So let me introduce the other three speakers on this panel. We have Professor Oyodele Atsenua, who is the Deputy Vice Chancellor at the Faculty of Law, University of Lagos in Nigeria. Welcome, Professor Atsenua. We have Professor Martin Hogg, who's the Dean at the NUI Galway School of Law at the University of Edinburgh in the UK. Welcome, Professor Hogg. And I have my dear colleague, Professor Saurav Mandal, who is an associate professor at Jindal Global Law School in Sonipat. So let me start off, with the first question, to which I'll request our speakers to respond with, within 3 or 4 minutes, and that's the kind of Q&A back and forth conversation format that we'll follow. We generally think about globalization as a phenomena, particularly the way in which it has affected legal education and legal theory to have broadly kind of divided our idea of law into something that can be referred to as mainstream on the one hand and critical on the other. And in this kind of binary that's been created between the mainstream and the critical, would you think black letter law is what we tend to associate with the idea of the mainstream? We can follow the format of the speakers as I had introduced them. So, Professor Atiniwa, you could start us off.
Okay, thank you very much, Oishik. Yes, what is black letter law? Black letter law, we would usually assume refers to the well-established rules of law, you know, the ones that are not subject to change. And it's law as it's in the text and ingrained, you know, and but to argue that black letter law or to suggest that black letter law is static is something that I have always challenged. I think that law has always been mutating, even when it would lay claims to being constant, but in between. And so, you know, one thing that we're familiar with as scholars of the law is the exceptional principles and the constancy of exceptions to main rules, so that I would say that it is not quite the case that black letter law and critical, you know, legal theory or critical law are poles apart. Law's always been challenged. What we call the dominant principles, the well-established principles, I think the only thing that we know as constant in law is actually that we're forever challenging the principles. And so even though we will say that the principles do exist and that this is black letter law, but we spend all the time telling our students also about all those exceptions, which they always, you know, they always have to adjust to. And in fact, I think I had someone say once that I think it was a dinner joke, and it was like, I'm looking for a lawyer with only one hand, as against, you know, on the one hand and on the other hand. And someone said, can you just give me a lawyer with only one hand? Because I'm a bit tired of this on the one hand and on the other hand thing. So I would say that, yes, globalization is come, and it has come with developments that make us challenge the adequacy of the law that we know. And as we begin to, as law begins to take off the dark, you know, take off the dark band across the eyes and begins to see, which is what, you know, we will say that critical legal theory is all about, and says that, no, you can't pretend that law impacts everybody in the same way. As law begins, as we begin to force that, you know, into the contention, law is responding. And I would say that the reason we've always had specialist areas of law, no matter how peripheral it may seem that they have been, is because we've also recognized that, you know, we need to have those special adaptations to accommodate. And that is, so globalization is forcing us to take on, you know, those new challenges, but I don't think that they might just be asking us to do it more open. It might be that we're being asked to do it more openly, you know, more obviously than law used to accept that it was doing.
Right, right. Thanks a lot. I mean, I think you offered a return provocation to the theme of the panel, which is to not think about the mainstream and the critical as binaries, as a more conservative way of thinking about black letter law would want us to. Let's see where Professor Hawke takes us from there.
Thanks very much. I should just start by saying that I was at the University of Edinburgh. I'm now at the National University of Ireland, Galway. They're actually two different institutions.
Right. So yeah. My mistake. I should have.
That's quite all right. Yeah, moved from Scotland to Ireland, where I am now. I think I would echo the comments of our previous distinguished speaker. I think one of the sort of ruses that critical legal theorists have sort of pulled on us in recent years is to give the impression that they are the only critical ones. Whereas I think, actually, if you look at the history and development of the common law throughout the world, it's always had within it that self-reflective, critical aspect to it, which has enabled the law to be developed within the proper boundaries within which judges can develop the law as opposed to the legislature. So I think the very idea of the common law and the idea of judges gradually reflecting on, reforming and developing the law has inherent in it a degree of criticality and self-reflection, which otherwise would render the common law completely sterile. And I think if I look, for example, at my own field of the law of obligations, and let's go back half a millennium, go back 500 years ago, the law of contract didn't really exist at that time. There was different actions within the law of contracts, the sumsit covenant and so forth. Tort was completely different. The law of unjust enrichment didn't really exist. If there had not been a degree of critical self-reflection on the way in which we should think about the subject of the law of obligations, we would never have got a unified law of obligations as it is today within the fields of contract and tort and restitution, unjust enrichment. There's always been that developmental pool within the law, common law, which has drawn it forward to try and think whether the needs of the people it serves are being met by the law in its current state, or whether it should develop in new directions. Of course, the trick for judges is to make sure that they are trying not to tread on too much on the toes of the legislature, because if they start to do that too much, then they are really taking legislative part themselves. And that's been one of the great debates, hasn't it, in the common law over centuries. What is the proper role of the legislature? What's the proper role of the judiciary? And trying to find that degree of critical self-reflection which is appropriate for the courts in developing the common law has been one of the challenges that society's faced over time. I think looking around the common law world today, there are probably slight differences in the role of the courts in different jurisdictions, but I think all of them would say, if you ask judges from all common law countries, does your role involve a degree of critical self-reflection, leading the law on to develop in ways which reflect modern society? I think they would all say yes to some extent. So I would agree that there really isn't this binary between mainstream and critical. I think the critical has always been part of the mainstream, albeit that if the courts depart too much from interpreting the law as it is, then they run the risk of stepping out beyond the proper bounds of the judicial function.
Right. Thank you, Professor Hogg. And I think you're taking forward Professor Atsenua's argument about trying to kind of, in a certain way, rehabilitate the critical origins of the common law itself, that the critical position didn't necessarily emerge from outside the tradition, but the tradition has enough resources for us to identify criticality within it. And one can actually see that if one sees the degree of discretion that the common law has over time in debatable forms, introduced as far as the authority of judges in the common law tradition is concerned. Two excellent set of comments actually helping us kind of produce a rehabilitative move, as it were, with regard to the black letter law, element in the common law tradition. Let's see what Professor Mondal has to tell us, whether he'll kind of take the rehabilitative move ahead or introduce a counter provocation. Over to you, sir.
Yeah, thank you so much, Oishik. I would call you Oishik, and please call me Saurabh, I think. And thank you so much for having me in this panel. It's really a pleasure to be a part of such a distinguished set of, I think, panelists. I think I would start with Professor Ashwina's. I'm sorry. Yeah, we just had a discussion. Okay. Thank you. So I think I would like to sort of start from there. I think she just started with this remark that what is black letter law? And I think that is very important for us to first of all kind of expound. Although Professor Hogg has already sort of, I guess, given through the example of common law, I guess Professor Hogg has already brought the internal inconsistencies within the common law system and how common law itself has its own corrective abilities, and it has over a period of time through debates, deliberations, and contestations, it has sort of come up with changes. Certainly, that is true. However, having said that, I think what we kind of miss often in our day-to-day, practice of law and legal scholarship in the academia is that the scholarship as well as the classroom discussions, courtroom lawyering, where law is applied, it uses the tools and the assumptions of the black letter law. And I think the problem that the critical scholars have with the black letter law are at a very core level of certain assumptions and the sort of tools that the black letter law often assumes to, on the face. And I think that is where I guess some of the problems come up. However, I think, again, I mean, law has been very corrective in many possible ways, but it's very important to sort of also bring the critical element very consciously in classroom teaching into courtroom lawyering, if possible. For example, the use of ethnographic data to sort of teach constitutional law, for example. I guess that could change the way a student approaches law at the first place. So, for example, when we teach citizenship law, for example, I think it's very important not just to teach them through conventional black letter law methods of teaching, like case law methods, for example, but to also take the discourse out of the classroom and use other legal and other non-legal methods of, I guess, interventions to sort of also introduce these topics of vital concern. So I think in that sense, of course, there is no binary or a sort of a either or kind of scenario, as Oishik has already pointed out at the beginning. I guess we need to sort of look at it how the legal framework as a whole can enrich itself with the presence of, I guess, different other systems of knowledge. And the last thing that I would just end up with by saying that there is no taxonomy of any kind is going to really work of any sort. I think we need to sort of, I guess, work more in tandem with other different knowledge systems. That's very important. And that might come from different other branches of, I think, popular culture, understanding popular culture, or understanding, I guess, just in other possible different ways, how human experiences could contribute the meaning of the law, not necessarily to always look at it from a top to bottom approach, with its very typical assumptions. But I think also to sort of look at law from the subaltern perspective and to sort of kind of look at law with sort of kind of just break the black letter assumptions of law and to look at it from a critical perspective. I guess that is more important. So thank you for now. Yeah, I'll end on that. Yeah.
Thanks, Saurabh. So I think with Saurabh, your comment, we see an interesting a parallel line drawing emerge, unlike the line drawing that Professor Atsenua and Professor Hogg tried to unsettle. The initial line drawing, which was part of the provocation of the panel, was drawing a line between the mainstream and the critical. Their arguments help us see that that isn't necessarily a helpful line to hold on to. You are introducing another kind of element in the discussion, which is to think about unsettling the line that distinguishes the law from what is not law, which is to say things that we generally tend to consider to be even outside the discipline have an important wisdom as far as how legal knowledge is understood. So you refer to other disciplinary perspectives like anthropology, for example. And what you're saying might also be in line with some historical ways of thinking within the common law tradition, not necessarily located in the UK. So if you think about American legal realism, the argument that judges need to look at sociological work or public policy work to help them arrive at better judgment might be somewhat one of the roots of the kind of line drawing you're suggesting. Let me introduce the next question, which I think flows from some of what you were saying at the point on which you ended, Saurabh, which is the question of power. And I think the big grouse really, if we were to think about the relationship between the critical perspective and the so-called mainstream perspective, again, it's poor of me to use those descriptions because I can't think of other labels, but I do think that they are inadequate labels. But the kind of central grouse that exists, if we were to continue to use those labels, is the presence of an analysis of power in the way in which critical scholars would approach their analysis or inquiry about the law, whereas mainstream scholars with a certain kind of commitment to the timelessness of principles or rules would want to make law immune to the workings of power, which primarily would be in the realm of politics. So my question back to the panel is that historically, can we rehabilitate the black letter law tradition by thinking about whether the black letter law tradition in fact has an account of political power, or is its continuance and legacy about keeping political power outside of the way in which rules and principles and commands operate? We could reverse the order of the speakers, but or go back to the same order. Professor Atsniwa, do you want to come back in?
I said it looks like Surab is really keen to say something, and maybe I should let him start. Did I see his hand up?
Sure.
All right. Yeah. No, Professor Ashwina, if you would like to go ahead, that would be perfectly fine. Please.
Okay. Yes, I think I would just. Yes, I would like to have a go at that. I think that speaking from the experience of being a law teacher, a law scholar in a state that was colonized, and the teaching of law has always been interrogating, at least from about the 80s. It has been less settled when initially in the 60s, probably, in fact, I would say that as far back as the 60s, you would find that the areas of law that were most engaged, admittedly, was private law, especially as people started to interrogate, things such as land, the law of property, and, interrogate the family law principles that were like adopted, or imported because of colonialism. I think that tradition of interrogation has consistently remained. Actually, in my curriculum and the way I would teach, there is no principle of law that students are taught without some engagement, without some interrogating. And interrogating in the context of, the North-South debate, particularly because you would find that all too often, you find parallel, you have the people's law, which is the lived reality, the one we see people live by every day. And so we're constantly asking, so why do we have the formal law, but we have a sizable population living out of the formal law? Because the students will always ask you that. For example, that if I'm in human rights law class, the students will say to me, so we have this right, but what is the reality? And so we've always had to interrogate those issues. And maybe that's the backdrop against which I will say that even when we talk about black letter law, it's always the self-reflexiveness possibly has gone a bit further than it might have done in some other jurisdictions that didn't have, or that doesn't have that reality of about half of the population living, under a completely different regime of law that you could say runs parallel with the formal law. And I will say that when it comes to power is always, because of that reality, power has always had to be interrogated. Whose law is this? And why are the people silently, passively resisting the law by not coming under its umbrella and negotiating their lives outside of it? So I would say that, yes, necessarily, we have imported that, although there have been lately greater embracing of, the interdisciplinary approaches, greater embracing of the methods, valuation of the methods of inquiry in other disciplines, and maybe because it's in the field, because I teach human rights law, and I also teach gender and the law, and these are fields that must necessarily interrogate power relations, because these are areas where the law forms and the law system seem to run parallel with what it is you see every day. So I would say that, yes, in our context, speaking from the Nigerian context, the discourse of law, maintaining that tightrope distinction has never been something possible. It wasn't possible because right through colonialism, there was the challenge to everything that was like imported common law. And then through in the post-independence era, it's also been a very dominant approach, and then globalization comes. But what is important is taking us outside. So while these engagements took place very readily in class, in academia, the same didn't always happen in practice. And you will sometimes, we also had the reality where we were told that, oh, that's academic. That has nothing to do with what we're doing here because the rules are set. So it is, what we have tried to do now is, how do we get the transition? How do we get the validation of this and the legitimization, excuse me, please, of those discourses taking place, in legal academia, and getting it to redefine the principles that the courts are. And that's where, we get the challenge. No, the principles of law are well settled. You can't bring all those here. You need to go and get the changes in the law outside of, you need to go back to the legislature before you can have these radical reforms that we're pushing. But we believe that the growth of the law is hinged on how open the law is to these critical interrogations. And we believe that we stultify law if you do not engage within practice. But I think that we're seeing a little bit more openness. Of course, I agree that there are those who think that we're going too far astray and we should bring back law on course.
Right. Thank you. Thank you so much. And thank you for bringing the discussion, back to questions of pedagogy. And, maybe we'll have an occasion in the next round to attend to this, but it might be interesting to think about whether certain areas of legal study or research lend themselves more to a certain kind of critical orientation than others, or is that too a myth? And it is possible to kind of think about more traditional law subjects, unlike gender and law or human rights law, that their beginning point was a certain kind of interrogation of received wisdom. But it's interesting that in our constant attempt at unsettling binaries, we also constantly produce binaries. So, the challenge to the binary between the mainstream and the critical, for example, has also produced the binary of the law in books and the law in action, the realist distinction. And it seems a productive binary in many ways to hold on to, even if the first binary that we wanted to challenge appeared to be not as productive. Over to you, Professor Ho, in response to the question about power.
Oh, I had to unmute myself there. Yes, I think, again, it's a bit of a caricature to say that black letter law, traditional law, is not interested in power. As long as it sees what the law is, it doesn't care who enacted the law or how it got to be in the way it was. I think my biggest piece of evidence in support of the fact that that's a bit of a caricature is, if that were true, the law would never have taken an interest in equity. The whole realm of equitable jurisdiction would simply not have arisen. And of course it did. And it did because very early on, the courts of chancery grew up because the Lord Chancellor and those around him were interested in the way in which legal rights were being abused in a way which had a negative impact on people. So we get this whole jurisdiction of equity, which arises because the law says we have to look beyond what the black letter is. We have to look at the effect it's having. And if people are abusing their position to enforce results which are inequitable, we have to do something about that. And that isn't just a dead jurisdiction, it's still alive today. There are still very lively debates going on in the law about developing new areas of concern for equity, or indeed, to use a kind of modern term, good faith. If you look at the law of contract, my own field, you can see there are very lively debates going on now about good faith and the role that good faith should play in contract law, and the belief that one shouldn't just get to exercise remedies in a way which would be contrary to good faith. Now, of course, there's a big spectrum of views on the role which good faith should have, but I think there's a growing realization in the common law that contract law, if it is to reflect modern mores, has to take account of requirements that someone is acting in bad faith, and that should limit the remedies which they would otherwise be entitled to in black letter law. So I think I would say that there's always been a tradition in the law of looking beyond the black letter and seeing the way in which power can be abused to achieve undesirable outcomes, and that the common law has developed responses to that as required.
Thanks. Thanks again. And interestingly, the point that you make, and possibly in the next round, I'd try and frame a question that attends to this more closely. We do see an emergence of a vocabulary here within the common law tradition that uses other words to talk about power, for example. So clearly the historical insight and its contemporary relevance through the law of equity that you're referring to attends to questions of authority, in a certain sense, and accountability, for instance. Again, both of these words as part of a larger vocabulary that is interested in questions of unequal distribution, concentration of a certain kind of discretionary authority, has also traveled into other areas of law like human rights law. And so, I think your earlier point about kind of putting these impregnable walls isn't in fact helpful, because historically we've seen far more kind of conversation take place across disparate areas of law than we would want to think, especially when we think from a critical point of view, which can be read, if one wants to critique in that sense, as establishing divisions that possibly weren't in fact in place. That's what you'd call, in the way you put it, a caricature of sorts. It's, one could say it's historically been far more contingent rather than how the critics make it out to be. Thank you again. Shaurabh, you want to come in on the power question?
Yeah, I mean, I think I would like to sort of course, appreciate both the trajectories that I think both of our speakers are taking. And I see a bit of, I guess, two different trajectories, in the sense that I think Professor Ashwinia started with a very, her experience of being working in a post-colonial state, and sort of she shared her experience of how law teaching has sort of changed from how it was in the 80s and how now it has been changing. And I think there, I guess we need to sort of start with this very important question, whose law it is. I think that's what Professor said. And I think Professor Hogg's, his description of the equity law as a sort of a kind of a internal method or within the black letter law to sort of check the tyranny of the common law in a way, or the tyranny of rather the more strict implementation, enforcement of the common law principles, and as an alternative, therefore, equity law as a different kind of a sort of a subsystem grew within the larger legal system, which is true. However, I think we also need to appreciate that there are two very different aspects over here. I mean, both the trajectories have a lot of value in it, and I think we need to sort of appreciate that liberal legal frameworks have have essentially frameworks which allow inclusion, and liberal legal frameworks allow principles like rule of law, for example, or a democratic method of lawmaking, for example. But then to what extent is the lawmaking process really democratic? Or to what extent is the knowledge production when it comes to lawmaking, is it democratized? In other words, are we taking, for example, when we are making laws for a certain interest group or certain groups, are we really taking their perspectives really, for example, I think in the case of the UK, I mean, the Gender Recognition Act of 2004 had been facing a lot of trouble, although it was made into a law in 2004 under European courts, I guess, orders. But now UK is changing its gender recognition laws, and very soon probably. But the kind of deliberations that UK has now had, or the British Parliament has now had with respect to changing the Gender Recognition Act, I think it speaks a lot about how pre-legislative processes are really very sound in the case of the in the case of the I guess the lawmaking processes followed in that part of the globe. Whereas when we see the need for changes in the pre-legislative processes in India, I think we have a long way to go. And why I'm bringing pre-legislative processes over here is because the idea is, again, for whom are we making the law, right? Whose law it is after all? Where is the power coming from, right? Or who is holding the power, right? Who is not ready to share that power, right? So I think we need to really look at it from that perspective. If the liberal legal framework allows, I mean, although these assumptions are very problematic, like when we say rule of law, it's a very deeply problematic assumption at the first place. And lawmaking is not objective. It is deeply political in all possible ways. And especially when you allow, I guess, deeply ethno-nationalistic sentiments or kind of muscular majoritarian sentiments to sort of become what the law would then be, I guess then this needs to be challenged. And I think one of the ways or different ways in which it could be done is to have an engaging pre-legislative set of processes, good legislative processes, good legislative discussions, and at the same time, good post-legislative discussions, and to take the courts to use the judicial review methods to sort of question laws, if in case there is a sort of a majoritarian, kind of a sort of what you call a kind of attack on human rights, or sort of the way. So I think in that sense, I guess to close it, I think black letter law it somewhat hides in itself, but not because of the sort of not because of these sort of, I guess, essential principles. The principles by and large could be okay, or they could be used in a much more beneficial manner for a more pluralistic or more broader diverse benefit of the society, for the heterogeneity of the society. But at the same time, it often doesn't happen like that, because black letter law has a possibility to really hide or allow certain categories of or certain sections of the society to sort of retain the power. And I think that is where, I guess, it needs to become more open, and knowledge production has to become more democratized, in other words. Right. I'm not sure how much sense is this making, but yeah, this is what I would like to sort of put it at the moment.
Right, thank you. Thank you, Shor. So I'm going to hold on to just a couple of points from what you said so that we can segue into the next round. So your response to, amongst the other things that you said, one was to try and think about a way, a practical approach to bridging this gap between law in books and law in action, knowing that this transference is not as easy as it generally sounds like. So you're suggesting a particular practice like pre-legislative consultations or post-legislative consultations that bring in the wisdom of the people who live with the law, rather than merely kind of falling back on the wisdom of the experts, as it were. That in itself, in many ways, unsettles the question of where does power lie. That, I think that was one helpful idea from what you said. The other, and that might take us to the next next question. and drawing from what you were saying, is that black letter law principles prima facie might appear good. So the rule of law is a good idea. It's you can't fault it for its promises, but it does hide a certain set of things, and opening up a rule of law to what it hides might actually be able to help us make use of the idea better, rather than to take it as it appears. Now, the question for the speakers, the third question, is with regard to the work that black letter law principles do as they move outside of their jurisdictions of origin. And this takes me back to a point that Professor Atnua had made about the aftermath of colonialism and how post-colonial countries who've inherited the common law tradition have to constantly negotiate between holding on to contradictory pasts. That you don't let go of the common law tradition, but you're also trying to figure out how other diverse plural forms of law coexist with the common law tradition. Now, the question that I wanted to pose to the panelists is, if we were to take, seriously the promise of a certain set of black letter common law principles, like the rule of law, for example, how does one historically account for the, one could say, the violence that's been carried out through the use of a principle like the rule of law in advancing and justifying colonialism, for example, to say, that part of the world does not have the rule of law, so it is our task to actually take the rule of law there. In many ways, one could say that several post-colonial countries have been beneficiaries of that transference, but that transference has also come at the cost of possibly killing off several other diverse or plural, legal traditions that might have existed in that area. The American legal scholar Robert Cover uses a particularly evocative word called jurisprudence in the context of judicial decision-making, that it seems like the travels of the rule of law outside of Europe also performed a certain kind of jurisprudence role in killing off plural legal traditions elsewhere, especially in the context of colonialism. So the question really is, how do we hold on to black letter law principles, knowing well the historical baggage of violence that they currently carry? So it's like the question is about historical negotiation with a certain set of really important black letter law principles. How do we do that both in terms of pedagogy, but also, practically in, the kinds of lives that we live or what we expect from the law today?
Thank you very much, Ashik.
Yeah, please.
Professor Hogg, do you want to go?
Well, I can just give you a very, very, very brief answer to that question. I mean, first of all, I'm not sure I would say that the rule of law was a specifically black letter law principle. I mean, I think the rule of law is more a fundamental ordering constitutional principle of a legal system. It goes simply beyond whether you are engaging in black letter law thinking or engaging in critical legal thinking. It's more of a foundational principle, which I think cuts across different approaches to thinking about the law. But having said that, I'm not sure that I would ever have thought that the principle of the rule of law was a guarantee against oppressive conduct. Because if you go through a process of enacting law and enforcing the law, and you therefore can be said to be respecting the rule of law, that's not a guarantee that the laws that you have implemented are going to be just. You might have very oppressive or tyrannical laws. So I think the rule of law on its own is never enough to guarantee that you don't have an oppressive system which fails to respect minorities, fails to respect diversity. I think you need other substantial constitutional values to do that for you. So First of all, I wouldn't say that the rule of law was specifically a black letter law rule, but additionally, whether or not it is, I don't think it is a guarantee against oppressive colonial practices. I think you need other things in place to prevent that from happening. So that would be my quite brief answer to the question.
Well, I think, thank you. I would say that actually, as I sit here reflecting on the questions, I see how, the very principles, just like Surav has tried to help us understand throughout this conversation, if you take the liberal approach and you assume that because black letter law has within it the elements for some insurrection against it, so for its recreation, you also may miss the opportunity, you may miss out the fact that it's historically it has served, to respond to some power dynamics, and then it shuts the door against some other power dynamics. And the illustration I just wanted to give was, so you have the criminal justice principles, the presumption of innocence, the unreasonable doubt, and the issues of the evidentiary weight that will be accorded to some kind of evidence, and whether the right of the defendant, to confront, the accuser and all of those things. And when you come into it from, gender-based violence, for example, and you then suddenly realize that those rules themselves become, like they shut the door against justice. Because from what we then know, we go back to what we said, learning, looking at the realities from other approaches, and then you realize that, yes, the victim does not want to confront, or the survivor does not want to confront the assailant in open. The victim does not immediately talk about, does not provide all the details because of stigma, shaming, or maybe trauma. And, you find that, so you come up with something 6 months later, and it's like, why didn't you say that when it just happened? And so, yes, I agree. I verily agree that, we need to constantly pressure. So the rules that were designed to protect the accused person, the defendant, against the state, then shuts out the victim, when you get to it, or shuts out, is insensitive. When you consider that crime as it was then understood was what would happen to men, and this is the way men would respond to it, as against, now that we're looking at gender-based violence, is a different type of violence from the other type of violence because of the way women are socialized, whether, or maybe the way they are biologically. Don't let's get into that conversation, but it then tells you how very easily. So yes, I do agree with the question, how do we hold on to the values of those of black letter law, those principles, and at the same time, create the spaces? And I think really that is what gender justice is all about. So it says, yes, we have adversarial, in the adversarial setting, we need proof beyond reasonable doubt. We need that the person who accuses must prove, we need all those things. But the reality also is that it doesn't, the victims, victims of crime are they're not one, and they come from different settings and all of those things. And I think that law is being forced to respond to it now. Law's been forced. Possibly one of the earliest things we have is giving evidence in camera, some of those things that because otherwise, and then but one area that I think we must really look at is, it's like, what kind of evidence, what happens, what are the rules of evidence? Can they accommodate, what we need if we're going to do gender justice? It was easier when you talk about child justice, but I think gender justice is actually forcing. It's forcing those changes. It's making us say, no, these rules will not do justice in this context, because it goes back to what we said about, the power, and shutting the door against because you hold on to. It's slow in coming, but I think the tweaking is already taking place. But what I just want to say is that typically, what we're doing again is using the spaces, which is what I think I started off with, and Professor Hogg did, and just, is using the spaces for insurrection within, the traditions of law to challenge the dominant, to force this. And that is why it may be slow. That is why it seems dissatisfactory. But in terms of practicality, I would say that that really is what is more likely to give us something. It is slow, but I doubt that we can completely dismantle. And in any case, there are enough people who have internalized the modern day inherited laws, the values. I always say, okay, so you talk, I say in my class, so you say this is the custom, but there are a sizable number of people who are no longer living under this custom and they do not want this custom. So you've got to have a legal system that responds to the fact that you can't take us back to that customary place because a sizable number of us are no longer there. And yet there are those who want that. So I think it's evolving. So yes, there is some, and it is when you have those challenges that you get people say, you know what, this is getting too fluid, this is getting too difficult, let's just go back, let's just hold back to the safe quarters, the safe boundaries of what we know as law.
Thanks a lot, and those rich insights, both Professor Hogg and Sinua. Saurabh, did you want to comment?
Yeah, sure. Yeah, thank you so much for, I think, both the very insightful comments, and I think the question could be rephrased, if you like. I think in the sense how Margaret Davis puts in one of her pieces on pluralism, the ethos of pluralism, and she writes that how can we maintain the integrity of law as a system while recognizing the need for it to be more socially responsive, flexible, culturally inclusive, and adapted to other normative systems. I'm not sure if Oshik would agree to this or not, but I think this is the question, I think, perhaps. Now, if that is the case, then I think we need to understand that lawmaking or law per se is not objective. And these ideas, the principles of law at the same time, as taught to us but intergenerationally, are not objective either at the same time. In the sense that if you talk about rule of law, let's say, for example, which we have inherited certainly from, in India at least, from our colonial, knowledge systems. And very clearly the idea, or there could be different debates of how rule of law could be, or has been also there pre-colonially as well. One could always have different types of scholarly engagements on that account. But on a more, clear level, rule of law comes into the Indian legal system from the common law system, right? And if that is the case, then I think the idea of equality before law has its structural limitations in many possible senses. The idea of treating everybody with one objective standard of treatment, taking the society, assuming the society as a homogeneous group of people where one size would fit everybody, has its own problems. And we have seen that across different litigations in colonial and in different post-colonial societies, as well as different first world global north countries as well. I mean, there are clearly limitations of having a very structured notion of rule of law. So I guess obviously we need to sort of understand equality in a more broader framework of substantive equality, and to sort of, I guess, take it beyond a very conventional realm of equality before the law. But having said that, I think Oishik's question is about negotiating with the historical injustices. I guess if we come to that, I would like to take two examples, one from family law and one from criminal laws. What we have inherited from the colonial laws in terms of a family law is a deeply gendered notion of family, is a deeply heteronormative notion of family. And we are really struggling in India and in different other post-colonial societies. And also, I think this is the challenge of many different other societies of the global north as well. I think in many different ways, to sort of negotiate with this very heteronormative set of concepts, that you bring in when you come to describe what is a family, right? How gender roles kind of inform very clearly what is a family. And that is a foundation to our family laws. So how are we negotiating with that? I think that's a big question. I think there are different changes that I think different legal systems have taken quite a few trajectories. For example, France has had a very different trajectory, although it's not a post-colonial society, but I think France has had a very different trajectory of sort of understanding, I think, cohabitation in general, irrespective of whether or not it happens between same-sex or, cross-sex couples. But again, the idea of normativity comes up, like with two people in a relationship. The French law of PACS, which, defines what is unmarried cohabitation, non-marital cohabitation. It simply understands a family as a unit of two people, whether or not they are married, irrespective of that. There are also countries that have taken the marriage route. There are also countries like South Africa, I think, where that is not the case, or it is both ways. But I think it informs a lot of how you are then defining domestic violence, how you are then defining all the other different realms of private and public law remedies. Criminal law, another very important point that we have inherited, historical injustices, the assumptions of, I guess, a lot of binaries that we have inherited from the colonial, framework of laws. Sexual assault, for example, is a deeply gendered, concept for that matter. The male as the aggressor and the female as a victim. And I think we are struggling to change that in India. Although I guess there have been changes with respect to making it more comprehensive, but again, in this very heteronormative frame of male vis-a-vis female, that sort of a framework. I think I'm not sure of what would be the better ways to sort of, I guess, maybe change it. But I think more critical engagement with the law is very important at every stage. I think whether that be just simply the courtroom, whether that simply just be the classroom or beyond the classroom, popular media, I guess, in all possible ways, we need to sort of engage, and sort of then create that vocabulary, which is already there in a way, with the help of critical scholarship, I think. But I mean, I might be wrong. But yeah, these are my submissions for now. Thank you.
All right, thank you, Saurabh. So I think I'll mute my questions because we do have a few questions from the audience. Srijit, will you alert me? We did have an additional five minutes. Okay, great. So we can take about 2 audience questions, I think. And the first question, I think, in many ways speaks to a comment that Professor Hogg had made about, the fact that it's not just the presence of a principle that ensures, that one can stave off injustice, but you need other institutional mechanisms to be in place, other arrangements to be in place, like the Constitution. And this is a question about the Constitution, particularly in the context of judicial activism. I put the question out there, and whoever wants to take it, amongst the panelists. So this comes from Lakshmi Srinivasan, and the question is: can it be said that even in the light of judicial activism, constitutional law believes in grounding itself in black letter law? That the Constitution doesn't escape its commitment to the black letter law. It seems like what Lakshmi's question
I suppose to some extent that's true, because if a constitution, for example, commits itself to equality of treatment, to equality of outcome, and so forth, then it is committing itself to following the laws which one has on paper, either through statute or through the development of case law. So I suppose the regularity of treatment, the regularity of outcome, these are things you'd expect a constitution which was respecting people's rights to commit itself to. So I suppose constitutions will to some extent commit themselves to respect for black letter law. Otherwise, you will have arbitrary results which would undermine fundamental rights, I guess would be my immediate response to that observation from the questioner. Thank you.
I would also want to add that I think it will defeat the whole purpose of law if there isn't, even if it's at the level of like a myth, but at least we need to hide behind that myth that the law is committed to some certainty. Otherwise, it would not be law. There would be no law if there was no commitment to what is said. But within that, the reality we have known of constitutional law also is that that probably is the area of law that has been most responsive to, change in terms of, pushing. And that's why you would, when Professor Hogg spoke, he talked about initially we would just have spoken about equality. But then, the discourse moved to equality of outcomes, equality of opportunities, and that's the responsiveness. But I would say that, and that's what people like Hayden, if there is no assumption of some degree of certainty, which is what some assuredness that this is the law. Although we spend all our life going to challenge that in court, what we do as practitioners is, we just go on and challenge, all of those things and try to suggest that this doesn't quite fit. This is not exactly what the law, what you think the law is saying is not exactly what the law was saying, and you try to do that. That is our life. But at least we've got to hide behind that notion that the law is the law and it is the law and we all know the law. And then we will spend all our lives again trying to establish what the law is. And that's why I started out by saying, you've got that little subtle movement. We think we know the law, but we're constantly challenging the law, and the law is constantly evolving in response. It believes it can afford to do too radically because the upset will be too serious. And so the courts, that is the tension between judicial activism and some stability.
Sure.
I guess I mean, this question has been answered by both the speakers wonderfully, I think, and there is nothing that I think I could add, but I would like to sort of rather bring one more, I think, strand to the question, if I may. I think this is the idea that Robert Cover brings in, jury genesis. And I think that is also very relevant in the sense that it's not just the courts through judicial activism or not just through the statutory lawmaking that we are changing the law, but the law is always constantly undergoing changes in its meaning. It's a process that goes on. And I think the idea is to understand that it goes on irrespective of whether or not the state is doing its role of changing the law, right? I think the law is changing in different other settings, non-legal settings, or at least the meaning of law is changing. Not the black letter law for sure, but certainly we are adding new meanings to the law, and I think that contributes a lot in terms of what then the vocabulary and the language that the lawmakers pick up probably after a few years, after maybe a generation, or probably the courtroom lawyering changes with a lot of, I think, changed meaning and conception. So I think that is it for I think on that account. Yeah, thank you.
Thanks very much. I think we are out of time. So it would be particularly violent on my part to summarize this absolutely, very, very rich set of comments and thoughts in such a short period of time. It's been absolutely fantastic. I'd only possibly end by thanking our three speakers for their wisdom and insight and their time in thinking so thoughtfully through the questions and the provocations of the panel. And maybe the closing thought being that as legal scholars, we always require some ground beneath our feet. How much ever we might want to be critical of black letter law, we do need to stand on something to critique. So on that note, thank you again very much.
Thank you.
Thank you.
Thank you very much to all the distinguished speakers and also to the moderator. That was indeed a conversation between heterodoxy and the black letter law, and a very constructive conversation. And I must say, the question at the end, which came from Lakshmi, that was also absolutely amazing. That brought a beautiful conclusion to this discussion. I love the hope you showed in constitutional law, and which is quite legitimate because constitution many times itself is a fight against many historical injustice. So investing faith in the Constitution, especially the black letteredness of the Constitution, makes a lot of sense in the turbulent times in which we live. So thank you very much to all the distinguished speakers and the moderator. But audience, please stay connected. We are going to start the next session in a couple of minutes, which is going to be on human rights, humanizing rights, postmodernism and human rights law. So please stay connected. Thank you, everyone.
Thank you.
Thank you so much. Thank you.
A very good evening from India to all our panelists and live audience joining us from around the world. My name is Malvika Seth, and it is my pleasure to welcome you all to the final discussion session of the Global Law School Summit on the theme of Present and Future of Global Legal Education. This session is dedicated to the discussion on humanizing rights, postmodernism, and human rights. We have a distinguished panel of 5 speakers who will reflect on this topic and share their perspectives. Please allow me to introduce our August panel. Our first panelist is Professor Dr. Lyra Jakulovic, Dean, Faculty of Law, Mykolas Romeris University, Lithuania. Our second panelist is Professor Dr. Y.S.R. Murthy, Vice Chancellor, RV University, India. Our third panelist is Professor Martin Scheinen, Professor of International Law and Human Rights, Bonnevero Institute of Human Rights, University of Oxford, UK. Our fourth panelist is Professor Mark Tushnet, William Nelson Comwell, Professor of Law, Emeritus, Harvard Law School, USA. And our final panelist is Professor Jill C. Engel, Associate Dean, Academic Affairs, Penn State Law University Park, USA. Thank you so much for joining us today for this discussion. This 60-minute session is divided into a brief introduction of the theme, followed by a moderated discussion with the panelists in a question-answer format, ending with inviting questions from the live audience. In the interest of time, I request the panelists to restrict their responses to 3 to 4 minutes. I will now briefly introduce the theme of the session to lay the foundation for the discussion to follow. The modern-day iteration of human rights, as laid down in the International Bill of Human Rights, is universal in nature. The present era has been described as the age of rights. Human rights are deemed to be inherent and attached to the identity of any and all human beings. The Universal Declaration of Human Rights, or UDHR, signed in 1948, was the fulfillment of the promise of the modern age to humanize society through the rights of individuals. These rights, as posited by the UDHR and put into obligatory language by the 2 international covenants, are heralded as a grand milestone in the evolution of humanity. However, the concept of universal human rights has not come through without significant challenge. The loss of cultural context has been a concern since 1948, when out of a total of 56 participating countries, South Africa, Saudi Arabia, and Soviet Union chose to abstain from signing the UDHR. Postmodernism in human rights, as in other disciplines, is essentially a departure from the grand totalizing meta-narratives of modernity. Any postmodern theorists argue that human rights is in fact devoid of any universality. In postmodernism, the identity of the protector of rights as well as the claimant of rights has undergone a shift. The human rights struggle is no longer only between the citizen and the sovereign state. For example, with the advent of transnational corporations with annual turnovers in excess of national GDPs of many developing countries, the language of human rights is being turned to combat corporate action and not just state action. The deconstruction of national and citizenship-oriented identity allows for self-identification on the lines of ethnicity, religion, gender, sexual orientation, to name a few. These changes, however, may not detract from ideals laid down in the UDHR, as the UDHR obligations are for everyone and not just the state actor. Hence, it may ultimately allow for the language of universality to be employed for demand of cultural and relative rights for micro self-identities. The COVID-19 pandemic united the world in crisis and may have exposed some fault lines in the postmodern understanding of rights. On the one hand, the right to health, access to medicine and vaccines was a universal call, and on the other hand, majority has rejected the right of communities for cultural or religious reasons to stand against vaccine mandates. The pandemic has exposed disparities between different countries and communities, with several transnational corporations doubling their wealth as farmers and laborers went into crushing debt across developing nations. Maybe the new goals for postmodern discourse regarding human rights should be to include social contingencies of micro-identities to help vulnerable groups achieve basic minimum universal standards by combating the specific hurdles created by such social contingencies. Without much ado, I will now address my first question. The concept of human rights has oscillated between two theories of law, natural law and positive law. Essentially, an unsettled debate over the source of human rights, whether they emanate from the inherent dignity of the human person or from the will of the sovereign state. May I request Professor Engel to reflect upon this?
Thank you. Yes, thank you so much. And good evening, good morning, wherever you are, to everyone. It's wonderful to be with all of you. I would like to frame my response to this question in the context of gender-based violence. Here in the US, we have an interesting approach to human rights in that we don't often call them human rights. And the US has been operating under this paradigm since our body of law developed. We have never adopted even the language of human rights very, very widely, if at all. Certainly into our federal laws and statutes, it does not appear. Although there are some states and even towns which are becoming more open to adopting it in that context. And so I thought I would tell you an anecdote to illustrate what I mean by this. In gender-based violence, legal advocacy, we have struggled to name the problem and to understand the best way to provide legal advocacy and to provide positive legal outcomes for families, for women, and also for lawmakers. How do we address such a complicated problem that occurs between two people intimately? One of the ways that colleagues of mine at law schools in the US have advocated is to go to city councils and even some small town councils, like the town at Penn State, here in the US, I'm at Penn State. This is our little mascot. And at Penn State, we're located in a very small town of State College, less than 100,000 residents. And in my legal clinic, about 10 years ago, we joined a movement of law students and law professors across the country who advocated for a city proclamation, a declaration, if you will, of our own, just like the UDHR, that freedom from domestic violence is a fundamental human right. And it passed here in State College thanks to the advocacy of my students, which actually took almost 3 years to bring just that small declaration to fruition. And I add that fact to you for consideration because my students, when they began the project 3 years earlier, they actually went to state legislatures. So our state of Pennsylvania has millions of residents, very big geographic area here in the state of Pennsylvania. And they lobbied some of our state representatives to try and get this passed at the state level. And it was not acceptable. It was not even our local representative who philosophically believes in human rights and wanted to advocate for awareness of domestic violence. He tried and he failed because there was no acceptance of even the language of human rights into a statute among his colleagues. So I'll stop there for now, but I wanted to highlight that as a challenge, but also a path forward for advocacy in the nature of statutes that can reframe the way we think about the fundamental human rights of those who might otherwise be vulnerable to violence.
Thank you, Professor Engel. So from USA, let's move to India. Professor Murthy, May I request for your comment?
Thank you, Professor Malavika, and greetings to fellow panelists and other participants. It's not exactly an oscillation between the idea of natural law and positive law. In fact, the idea of human rights evolved over centuries in response to various historical stimuli like Holocaust and genocide. The idea of natural rights, in fact, evolved over time after extensive critiques and eventually settled in the current notion of human rights. Values associated with natural law are now transformed into positive law. The Universal Declaration of Human Rights and the covenants are clear in grounding human rights in human reason and human dignity. After valiant attempts to find philosophical foundations for the notion of human rights, scholars have veered round to the view whether it is indeed necessary to have a source at all. After all, human rights are moral claims which need to be respected for their own sake. The Constitution and other laws only merely recognize what is otherwise inherent. If correctly interpreted, human rights are one of the best instruments societies has for defending various liberties and for securing economic and social progress. In India, we can clearly see how some recent judicial interpretations in the National Legal Services Authority versus Union of India, otherwise known as Section 377 case, which decriminalized the Indian Penal Code provisions relating to homosexuality between consenting adults, and in another case, India Young Lawyers Association versus State of Kerala, popularly known as Sabarimala case. In both these cases, courts have relied on human dignity to apply a transformative approach in the interpretation of the Constitution and upheld human rights of people. Today, we need not appeal to a higher or a divine law in order to defend our cause. We can appeal to the pertinent provisions under the current national and international framework of rights.
Thank you, Professor Murthy. Surely in India, there has been a drastic shift in terms of how we see human rights and how the courts have come to agree that there is an evolution that is taking place and they are not sort of constant. So the sources may also be changing in that understanding. May I now move to Professor Martin to present to us a perspective from UK on this question.
Thank you, panel chair. Your introduction indicated that there would be an unsettled dilemma, oscillation between the natural school and the positive law school. I don't think so. I think we can say that the matter is settled. And I propose in the following way, that morality is the origin of human rights. It is in the recognition of each and every human person as the subject. That is the essence of human rights, and dignity comes into play, yes. And human rights enter the law as a discourse through the natural law school. But that's not enough. That's the historical background. Then we have the process of positivization. And I would say that the usual three sources of international law apply also in respect of the legal validation of human rights norms as norms of international law. So we have, of course, the treaty-making procedure by states. That's one way of positivization. But we also have judicial recognition of custom and opinion juris as crystallizing norms of customary international law. So there's a more direct link from morality, the background, through judicial action. And similarly, we have the distillation of principles from national legal orders, mainly through comparative constitutional law, as then recognition at the international level as general principles of law. So I see that we need both. We need the natural school to bring human rights into the discourse, and then we need the positive law school to make them valid norms within the framework of law. Thank you very much, Chair.
Thank you so much, Professor Martin. I'll quickly move on to the next question. My next question is, many provisions of the Universal Declaration of Human Rights reflect expressions of rights from earlier Western documents. But even if UDHR has its origins in Western philosophical thought, does this necessarily mean it cannot be considered universal? Or does it leave micro-identities vulnerable to a global homogenizing force? I would request Professor Mark Tushnet to comment on this.
Thanks very much. So I guess my first observation would be that although the sort of drafting origins of the UDHR may well have been mostly Western, although there was some, what we now think of as global South influence on it. I think on reflection, particularly for me at least in connection with the debate about 20 years ago over Asian values as contrasted with Western values in the UDHR, it became clear that in the, call them non-Western tradition, in many non-Western traditions, there were rough equivalents of the concepts embedded in the UDHR, or the Western versions of the concepts embedded in the UDHR. And so, despite the, as I say, drafting origins, I think the notion of, in some sense, the notion of universality and transcultural relevance remains significant. But I want to stress that the postmodernist view does place some pressure on the sense in which these are universal claims, because even within the West, there are various understandings of each of the, or many of the claims. And the point of, one point of modernist discourse is to, postmodernist discourse, is to insist on the, call it for these purposes, local specificity of the instantiation of the rights. So when you combine the fact that there are versions of these ideas available across traditions with the postmodern insistence on local specificity, the document does have some universality, but it's brought to ground in various quite actually distinctive and interestingly distinctive ways in a specific cultural context.
Thank you, Professor Tushnet. And yes, this idea of Asian values that has sort of been troubling, and taking from Professor Martin's comment here, even Asian values to an extent have a morality integrated within it, which talks about individual rights, which we have seen in ancient cultures, even in India. One of the first sort of iteration of right of food. Right to food comes from Ashoka's epithets that he had created long back before all of this discussion of Western and global North and global South. So yes, thank you so much for that. Professor Lyra, may I request for your comment on this?
Good afternoon, dear colleagues, dear participants. It's a pleasure to join you for this important event. As the point about cultural aspects and universality has been already addressed, maybe I will start from a completely different point where we see the national specificities nowadays, which are very dear to particular countries. They are not necessarily related to, let's say, cultural aspects, but other ethnic aspects or national security aspects. And this also sometimes gives the impression that we don't really want universality because we need something very specific for our countries, for our regions. But even in these kind of situations, I think there is nothing to do but just to go with universality, because in particular, when we deal with global crisis, and this is where, let's say, there have been a number of very national and specific approaches to how human rights should be balanced, let's say, with national security issues. Here, we cannot really solve those crises if we just follow the very national approaches. And two crises that we have been in, the COVID crisis, if countries would treat the right to health differently, I understand it's nothing probably or not much to deal with cultural, although there could be some aspects. But if countries do deal with the COVID crisis differently, that of course affects all of us. Now, if we take migration as, you may call it positive, you may call it crisis. I'm coming now from the region where where migrants are being used as weapon in the nowadays political arena by our neighboring country. So here, again, if we would just approach this issue nationally, it would be very, very difficult to address the whole issue of vulnerable populations like migrants. So here there is, of course, very close connection with the declaration, even though I agree with Professor that probably at the time when it was adopted for various reasons, because of Soviet regime, because of colonial regime, there could have been some claims with universality. But I believe that in 1993, with the Vienna Congress, somehow we already put the stamp of universality also on this document. But my point is that without universality, I think nowadays it would be very, very difficult to address those global crises that all of us are facing, even though we would like to have very, very national approaches to that.
Thank you so much, Professor Lyra, for bringing forward different aspects of micro-identities that need to be considered in this conversation. And of course, the whole idea of how COVID may have sort of brought us all together as well as exposed the differences that we are living in makes this conversation extremely pertinent. I would request Professor Murthy to shed some light from the Indian experience, maybe. Professor Murthy? Okay, then maybe we'll move on to the next question. My next question is...
Oh, got it. Sorry. Hello.
Sorry.
Can you hear
Yes.
me? Actually,
Yes,
I was muted by this thing. Okay, I'll see. There is a lot of work being done by scholars from the global south, particularly in Latin America, Africa, and South Asia, who, while criticizing the universalizing language, have put forth regional interpretations of human rights, which bring out rich and diverse ways of looking at human rights by including the vulnerabilities in different cultures and regions and contextualizing these within the human rights discourse. Universalist perspective on human rights can achieve some degree of progress, for instance, in the case of historically vulnerable sections such as the women. However, its utility to understand deeper, localized rights-based issues is limited, as has been shown by global South scholars. In fact, scholars have identified 4